You do all in your tote bags with your stuff. There is a little printout of the agenda. It's a little bit more linear than this, but it'll tell you exactly who's going on when, what time we're having snack. We do have 5 presentations today. We also have a special guest presenter during our lunch, so that's going to be pretty cool. And we'll get to more on that in just a moment. But again, you all have a copy of the agenda in your bag today.
We just want to take a special moment to thank our platinum sponsor, Crown Real Estate Group. Tom, if you want to stand up and wave real quick.
Let's give a quick shout out to Tom. Woohoo!
Thank you, Tom, for dedicating your time and efforts to Manor Law Group and to Elder Boot Camp. Without you, we wouldn't be here today. So we appreciate you.
Yeah, really. Thank you so much, Tom. And he's just a cool dude. I'd also like to give a shout out to our premium sponsors today. Amara. So big shout out for that coffee bar. Like, it's so good. Woo! Yay. And then we also have Lockwood and Wellbridge of Brighton. And again, like Wellbridge and Lockwood, we're so grateful for the support that we get from those organizations year after year. And we're just so happy to have you guys here and your support. So thank you so much to all of our sponsors, but especially Amara, Lockwood, Wellbridge, and of course, Crown. So just a big round of applause for all of our sponsors today. Thank you all so much.
The next thing, most important, in my opinion, because you could win a prize, is our Circle of Care card. So in your bag, inside is the Circle of Care card. We are encouraging you to visit every vendor table, get a little sticker on their spot, and at the end, once you filled up all your Circle of Care with stickers, you submit it to the Manor Law Group table for a chance to win a prize at the end. Without everybody on this card, we couldn't be here today. We all work together. We all make differences in lives. And so we appreciate everybody that's here. So we really encourage you to visit the vendors, get to know them, know about their services that they offer.
And we talk a lot about the Circle of Care throughout the whole event and really throughout the whole year. And it is a circle of care because without one piece of the circle, you don't have a circle anymore. So it's like that old song, "May the circle be unbroken." I won't sing it for you, but so really we're just so happy to have all of you, not just here today, but every day. We couldn't do what we do at Manor Law Group without the support of all of you in the audience today. It's not just our sponsors, it's literally everyone in here today. And we know that we all work together to make this happen for our clients. So it really is a circle of care. And again, you're going to hear that a few times throughout the day today. So now this is an important part of the presentation. This is the part where y'all get your credit. So go ahead and get into your tote bag and you can pull out your evaluation form. If you're at home and you're watching virtually, which we do have like 50 or so people at home or in their office, wherever they're watching, go ahead and pull up that evaluation form. You should have the fillable PDF if you're online. But if you're in the room with us here today, you have a green paper. If you're an attendee, sponsors, you actually have one too. Yours is blue. So you can pull out your evaluation form. And now it is important that you only fill out what we ask you to fill out now, and then we'll go through later today and we'll fill out more of this together. So for now, you're just going to fill out your name. If you are a nursing home administrator, you'll put your license number. You'll enter your employer or your organization. If you're retired, you can just put that too. And you'll put your license type. And then the check-in time, which we have our wonderful timekeeper, Liz. Yay, Liz. Liz, what is the official check-in time for today? 8:10 is the official check-in time. 8:10. And after you have that filled out, you can go ahead and put the evaluation form away. If you're at home, minimize the tab, set it aside, and then we'll come back to this later. All right, so now I'm going to actually invite Bob up on the stage. These are a couple other sheets that are in your tote bag, or if you are from watching at home, these were also sent out in the materials or on the materials page. But Bob, go ahead and tell us about these brainstormer worksheets and the insights and actions worksheet.
Okay, so I blatantly stole these from another organization that I participate in. So many of you know, and if you've been here before, you probably heard me talk about these sheets before. Many of you know that I'm involved in some coaching groups where we kind of coach each other, and mostly lawyers and law firm owners, and so. One of them is called Atticus. Anybody know where the term or the name Atticus comes from? Some of you literary people will know Atticus Finch. Anybody? Oh yeah, it's like To Kill a Mockingbird. Anyway, so the name of the organization is called Atticus. And they came up with this idea, and I thought it was brilliant, that whenever I attend a conference, the speaker or somebody or something will jump into my mind, and then I lose track of what the speaker's saying. And so a lot of times it's because the speaker triggered something to say, oh, that would relate to one of my clients, or that would relate, or I got to remember to follow through on that issue. And so the concept here is to have a place to write that down so that you can come back to it later. And so that way, then you can kind of refocus on the next thing that's happening. I found this to be very effective, so I decided to share it with all of you guys. And so there's two different things here. So there's the brainstormer workshop page, and that's a worksheet. And that's really designed to be like, something pops into my head. I need to get it out of there. I need to get it down somewhere so that I remember to follow through on that thing. It could be, I know we're running out of milk at home, whatever it is, so that I can focus on the next thing. And so that's the idea of the brainstormer worksheet. The insights and action items, that might be where we say, okay, when Kelly talks about substitute decision-making and powers of attorney, you might be like, oh my gosh, my parents don't have these. I better make sure my parents get these. She's going to talk after her presentation. If you haven't heard us talk about this before, you're going to realize those are incredibly important. If you have parents and they don't have them, then this is your homework now. Make sure your parents get these. And obviously we prefer that you work with an attorney, but even if you just get something in place, something's better than nothing. And so that might be one of those insight and action things that we say, okay, I've got to follow through with my parents. I've got to follow through with my husband, my spouse, whatever it is. And so that's something that the idea is, we should go ahead and write that down, and then you can get back to listening to the speaker. Whenever I attend a conference, I usually have both sides of these pages filled out because there's just so many things that come up that kind of spark an idea for me. Okay, so these are the two laminates, or this was one laminate? This is one laminate.
It's front and back.
Okay. So we're going to reference this a little bit throughout. This is the thing that we've been handing out for years, at least 10 years. And it's the thing that most people seem to have real interest in getting updated every year. So we probably print off 1,000 of these and laminate them. And if you need more, so you got other people in your organization that want one, or you lost yours, whatever. So we update it every year. This is what we call our Medicaid and Veterans Benefit Qualification Worksheet. So on the one side is all the numbers for 2025. Very, very important, right? Numbers change. You're going to see there's one number that hadn't changed in 50 years, and it changed in February. So it's a huge deal, and it's a big plus for our seniors and our folks that we're helping. But these are the numbers, and a lot of them change every year. Some of them never change or hadn't changed in 50 years, and now they do. So that's the one page. It has we're going to talk about veterans. We're going to do a deep dive on veterans benefits today. It has the dates of service there that we need to qualify, have the amounts, have the Medicaid numbers, have the waiver and PACE numbers, all of those types of things. And on the other side of the page, I think this is particularly helpful, and I'm hoping that at some point you'll be able to use this. I have a checkbox, and this is where we call it the qualification worksheet, okay? These checkboxes, if you're working with a resident, patient, client, whoever you're working with, and they're looking at the qualifying for Medicaid. So this side of the page is specifically for Medicaid. If we check any of these boxes, they probably should come see us. They should probably come see an elder law attorney. And I do specify elder law attorney because I hear this all the time from financial advisors, bankers, whatever, and they say, oh, you should go see an attorney. The reality is most attorneys are not well versed in Medicaid rules or veterans rules or things like that. It's not likely that you're going to get the same advice from an attorney versus somebody that does Medicaid every day. Okay. The things like real estate. Is there a ladybird deed? You would think, oh, that's a good thing. Anybody that knows about ladybird deeds, you'd say, oh, that's a good thing. I've seen so many ladybird deeds that aren't ladybird deeds or that don't do what the family think they're going to do. So that's something they should probably just get checked. Okay. It takes me, 1 minute to look at it and say, all right, you're good. Ladybird deed is sufficient or it's not. So those types of things. If they're over $9,660 and they're a single person. So any asset over that, life insurance, money in their house, money they gave away, anything over that. If they have real estate and don't have a ladybird deed, probably need to come see a lawyer. If they have a trust and they have a house in a trust, probably need to come see us. And then there's the gifting checklist. A lot of people don't think of gifting. I call it the G word because I tell people don't do it. Don't do gifting. Don't give your money away to your kids, especially if you're thinking about Medicaid. And so I call it the G word because I don't want people to do it. But the thing is, a lot of people don't think of things as gifting. Oh, I just helped my granddaughter with her wedding. I put $10,000 towards her wedding. Or here's a good one. I'm moving in with my daughter. So we sold my house and we took the money from the sale of my house to build an addition to my daughter's house. That's gifting because mom's name's not on daughter's house. So you wouldn't think of those things. So things that normally we wouldn't think of as gifting can still be considered gifting. So be very, very careful on those things. So that's why I have those checkbox, and that's why it's a laminate, so that you can kind of go through that with a client, patient, resident, whatever, if they're looking at Medicaid and whether or not they need to see a lawyer or not. Because a lot of people like, oh, I have no money. All right, well, I've had people tell me they had no money. There was one famous one, and I always remember this. It was one of my mom's friends, and she said, she had said many times to my staff, well, I have no money. I don't even know why I'm doing this. I have no money. She came in, she had $500,000. In her mind, that was she didn't have any money. And I don't know why that was the way she thought. We have another client that has a lot of money and can't get it through his head. Now, we finally got him to spend some of that money and pay for care, which he's needed to do for years. But it took a long time of us working with him to get where he was comfortable that, no, you're going to be fine. You're not going to run out of money. And so sometimes people just have that mentality, or they were just thrifty their whole lives. And so this is the type of thing that we can help folks with. So I think these sheets are very helpful. Is that the last one for me? Okay. Is there another one? Okay. I like this form too. Now, this is a form that I often will go through when I sit down with a client that's interested in long-term care. I like this one because if you look at the first column, it goes through the different types of care, right? We've got home care, we've got independent living, we've got assisted living and memory care, we've got adult foster care, we've got skilled care, we've got hospice, okay? And the reason why this chart exists is we go across and we say, okay, can that work with Blue Cross? Can that work with veterans benefits? Can it work with veterans benefits health services? Can it work with any of the Medicaid programs, Medicaid PACE, Medicaid waiver, and different settings will work with different Medicaid programs. So if we're in independent living, we're not getting traditional Medicaid, but we can absolutely consider PACE or waiver. Okay. And so this is helpful not only for us to kind of keep track of it, but it's very helpful for the clients who think of everything beyond home as a nursing home. They move into independent living, they call it the nursing home. So the idea is that's not how the law treats it. That's not how these government benefits treat it. And so this helps us, not only us keep track of it, but it also helps the families understand the distinction of where they move into and where they get their care is going to make a difference about which government benefits might apply to them. Okay, so I like it. On the back, I think it's like annotated, and it just gives some information about some of the programs there. So
thanks, Bob. So who the heck are we? We're Manor Law Group. We have been in business. Bob's been practicing law for almost 30 years. Yeah, I won't give away the full number, but that's good enough. Long time.
Almost as old as I am.
Yeah. Ooh,
sorry, Bob.
Burn. So we have 3 locations. We have our main office, which is located here in Grand Blanc. We also have another office in Brighton and a third office in the Rochester Hills area. We practice, of course, as you know, elder law. We also do estate planning. We do veterans benefits, long-term care planning, Medicaid. We have guardianships. We help a little bit with that. Discharge planning, all kinds of stuff, estate administration, from life to death. We can help your family or your clients. I didn't introduce myself earlier. I'm Savannah Mexto. I just kind of jumped right into. I'm really excited and on fire for boot camp today. I'm our marketing director, executive director here at Manor Law Group. So I have my hands in a lot of little things. A lot of the communication and stuff will come from me. And then we also have Danielle, which we'll talk about her in a little bit here too. But yeah, so she's going to go ahead and explain to you our attorneys.
Yeah. So we are lucky enough to have 3 attorneys on staff. If you guys would stand up when I say your name. So we've got Kelly King-Penner. Stand up.
Stand up, Kelly.
Look
we can't see you.
We've got
standing.
We've got Bob Manor, who you guys all just met, and our newest attorney, we have Nick Lucic. He just joined our team in February, I believe, December. So he's new to our firm, but just a little bit about Bob and our team of attorneys. So Bob is one of 18 certified elder law attorneys in the state of Michigan. So there's not many here, but he's been doing this for a long time. Kelly's been with our practice for about 8 years now. And she does a lot of stuff behind the scenes, as well as meeting with clients and families and helping them through the process as well. And Nick is still learning. So we're happy to have him on our team, and you may see him around a little bit, just kind of getting to know everybody today. So.
And then something that's unique to our law firm is that we have social workers on staff. Yes, woohoo! And we're really proud of that. We love our social workers. Danielle Schwalabog here is one of our social workers. And then we also have Elise. Is Elise in the room with us?
Is.
Yay, Elise, stand up. Yep, Elise Kruger. And then we also have Nikki. She's not here now. Nikki, she's not a full-time social worker here at Manor Law Group anymore, but she does facilitate a monthly support group for families and caregivers of folks with dementia. So in partnership with the Alzheimer's Association back there. So yes, thank you, Doug. And we're really happy to have her too.
Okay. So today it's going to be a great day. There's probably going to be a lot of questions.
Yes.
We're asking if you have questions, write them down during the presentation so you don't forget them. If at the end of the presentation we have time to answer questions, we will run around with the microphone and get your questions answered. If not, approach a staff member that you see has a Manor Law Group name tag. We will get your questions answered no matter what. Just depends on how long the presentations go today. Mm-hmm. But always write them down so you don't forget them, okay?
Yep. And don't be shy, because I want to get my steps in. I'm wearing my Fitbit. I will come to you. It's like my cheat of the day to get in the steps. So help me help you. Also, if you're watching from home and you have questions, we do have a chat box. You can go ahead and put your questions in the chat. The lovely Olivia is going to be monitoring the chat, and she can relay those questions to us. She's actually texting them to me directly. So if I'm up on stage, I won't see your question. But as soon as I do see it, I'll just pass it along to someone who will know it. You don't necessarily have to wait until the end of the presentation if you're watching from home. We'll try to get the questions answered. Again, if we don't get the question answered, in that time, we will take care of it. We can see the chat and we'll try to get your question answered. So even if you're at home, you're still a part of the event, and we're happy to have you here too. And with that, we are going to bring up our first presenter, Attorney Kelly King-Penner. Welcome to the stage.
All right. I usually tell people loud is not my problem. Can you hear me okay? All right. All right. So everything that we're going to go through as part of this presentation is foundational for everything that we are going to talk about today. So the thing that I really want you to remember is that it's all about choice, and it's about planning for our future. And the future is coming, whether we like it or not, so we might as well plan for it. And the biggest thing that we need to plan for is what we want for ourselves. How we choose to live our lives is one of the most important things that we have, because that's how we choose to do it. I don't live my life according to how someone else wants to live it for me. So substitute decision-making is really foundational in choosing of what is best for you. Substitute decision-making at its core is when you are appointing someone else or someone else is standing in your shoes and making decisions for you. There are a lot of different types of substitute decision-making arrangements, and we're going to go through a lot of them today. Each one is unique. It has its own process for how they are created, the rules that they have to operate, the hats that the agents wear. All of these have different arrangements for it. And we tend to think about substitute decision-making in these three areas in terms of financial, health and medical, personal care. But it really can be much more far-reaching than just those three areas. Truly, substitute decision-making is spanning a lifetime of choices. I think a lot of times people tend to focus on when we get sick. But really, you've encountered substitute decision-making your whole life. When you were younger, your parents made decisions for you. You couldn't decide what medical care you received or didn't receive. You couldn't be in control of your own financial assets. Someone else made those decisions for you. And if any of you are parents, you're doing that for your children now. For individuals that are disabled and need that extra help into adulthood, we have substitute decision-making through guardianships or extra supportive care. Then there's a scenario I think a lot of us think of when we think of someone standing in our shoes is when we are physically unable to communicate. We have a medical event or a tragic incident that causes someone to have to step in and make those decisions for us because we are physically unable to communicate. Or what I'm sure many of us see is as we get older and maybe we're facing a diagnosis of Alzheimer's and dementia, where we are here and present but can't communicate our needs. Someone needs to be able to make those decisions for us and advocate on what we would want for ourselves. So truly, this is something that you're going to encounter your entire life. It's a cycle that's going to continue as we age. We're helping our children, we're helping ourselves, we're helping our parents, we're helping our loved ones. The goal of substitute decision-making, as I've mentioned, is to protect our patients' residents' autonomy and self-determination. It is not how we would choose to live our lives for them. It's how they would choose to live their lives for themselves. Navigating these complex legal and ethical issues is a part of that. And that's what we are all here to do, is to help families and their loved ones navigate this process. And it's not always an easy path forward. Making decisions for other people based on what is best for them and what they would want is not always a clear, smooth road. We want to advocate for our residents' best interest, and those best interests sometimes don't always align with what other people would choose for them. And that is complex for families to navigate. But also, at the bare core of this, we're here to help support people through this process. That's what substitute decision-making is to help support people. Before we get into too much of the substitute decision-makings, though, I really want to go through this idea of capacity versus competency. Any of you that have attended boot camp before has heard us talk about this. And this is truly vital to understanding how we move forward with this idea. So let's start with competency. Competency is a legal determination. This is often made by a court that has determined formally that a person is unable to make decisions for themselves. That's where a judge has evaluated all of the information and has said this person can't participate in their own decisions. They don't understand things that are going on. That is a formal determination. When we're focusing on substitute decision-making, though, instead of focusing on competency, which is actually the minority of issues that we encounter, we need to focus instead on capacity. And capacity, unlike being a competency with a formal determination, is the ability to understand the cause and effect of your decisions. As long as you can understand the impact of a decision that you are making and knowing that it comes with pros or cons or risk or benefits, that's what capacity is to be evaluated on. So you might choose to do something that someone else wouldn't do. That doesn't mean that you're making a decision lacking capacity. It just means you're doing something different than other people would do. As long as you understand the consequences of that, that's what we need to focus on. And too often I feel like people focus on competency instead of evaluating the capacity. So what you need to know about capacity is that it's not an on-off switch. It's not something that we wake up one day and determine that that person no longer has capacity. It's also area specific. So you can have capacity in one area and be lacking it in another. All of these things need to be evaluated on that level. And it really isn't an all or nothing approach that continues all the time. If you have a determination of lacking capacity, it doesn't mean that that's a continuing determination. We have to evaluate it. Any of you that are working with individuals with Alzheimer's or dementia know that they have good days, bad days. Certain days, yeah, they know everything. They could tell you the street that they grew up on, their first grade teacher's name, and their first pet. And then the next day, they may not be able to identify their children. We have to evaluate this on a continuing basis. Also, I feel like temporary confusion sometimes is used as a basis for this continuing finding of incapacity. People can have circumstances where they're not able to make decisions in that moment, but that doesn't mean that that continues. We all know of those pseudo-dementias or those temporary circumstances. Delirium after surgery, urinary tract infection that's causing some confusion. You took too much of your blood pressure pill and now you're acting a little funny. All of these things need to be evaluated before we just assume that someone's not able to make decisions for themselves because they're getting older. So instead of asking, is there capacity? Ask yourself, capacity for what? What is the problem that we are trying to solve? What is the area in which this person might need some extra support? And what are the tools that are most appropriate to solve that problem? Capacity assessments are not an easy thing to go through. Most professionals working with individuals with some form of diminished capacity receive no formal training on this. In law school, I think we spend approximately half a day, maybe, talking about this idea of testamentary capacity. As a professional, though, in the field working with people, rarely do we receive any training on what this actually means. We focus a lot on competency, those formal court orders that says this person can't make decision anymore, but we don't focus enough on capacity. The sad fact of it is, as well, is that people don't often consider the long-term consequences of alleging that somebody lacks capacity. Think about it. It would be like somebody coming in and saying that you're not in control of any decision-making ability your entire life. You want to wear that sweater today? Too bad. We really need to be cautious before we allege that people are unable to make decisions for themselves. Because if you put yourself in that shoe, you wouldn't want that for yourself. So capacity, as I've mentioned, is area specific. Here's a host of areas that it could be. We have to evaluate this. Someone could very clearly be able to decide on their vices in life, right? So if they want to have a glass of wine at dinner or an extra piece of chocolate cake, if they can understand the consequences of that, that's something that they might have capacity in that area. At the same time, they may not have capacity to make financial decisions because maybe they just don't understand the nature of them taking a particular course. So we have to look at the problem that we're trying to solve, and then from there, fill in what supports are the most appropriate. Here's the other part. Capacity is presumed. We don't go into a scenario thinking that somebody is unable to make decisions for themselves. We have to say this person is in charge unless there's evidence to the contrary. So we have to look at what circumstances are coming up. If we don't have a judicial determination or a triggering effect in documents, so we're going to get into what a triggering event is in documents when we talk about powers of attorney. But absent these circumstances that are cutting off someone's ability to make decisions for themselves, we need to presume that they are able to make decisions for themselves. Merely appointing somebody or having a power of attorney does not mean that you lack capacity. Simply planning for your future and making sure that you have people that are in your circle to help take care of you is not evidence of lacking in capacity. It is making sure that you're planning the way you want to lead your future. So, bad decisions are not presumed incapacity. We all make bad decisions every single day. I could go into a list of dietary problems that I have every single day making bad decisions. That doesn't mean that I need somebody to come in and say, okay, well, you're not allowed to have that cupcake. I would say, fight me for it. The key to evaluating capacity is, do they understand the consequences of that action? If I eat that cupcake, I know I'm going to have a sugar crash later. I might get a little extra hangry, might pack on a little extra weight. I understand the consequences of that. So I'm allowed to make that bad decision. We all make bad decisions every single day. And you know what? That's our choice. We are allowed to continue to have that bad decision making as long as we understand the consequences. So let's get into the different types of substitute decision-making arrangements. And we're going to start kind of with an overview. Typically, we tend to focus on what is the most restrictive and what is the most flexible. And all of these tools serve a purpose. So there isn't necessarily good or bad. There's proper tool for the job. And when we talk about most restrictive, we're typically looking at court-appointed processes, right? So this is where we get our guardianships of incapacitated individuals or conservators of protected individuals, as the law refers to them as. With guardianships too, I'm sure some of you are also familiar with this idea of guardianships, or not this idea, this process for guardianships of developmentally disabled individuals. When I'm talking about guardianships today, I'm going to focus mostly on incapacitated adults. Those of you that have had experience with developmentally disabled guardians know that the processes mimic each other a fair amount. They actually operate under two different laws. But most of what I'm going to be talking about today is pertaining to incapacitated individuals. If you have questions about developmentally disabled guardianship scenarios, feel free to send those into the chat, reach out to me afterwards. I'm happy to go over that. But today we're focusing mostly on incapacitated adults. We're also going to talk about the most flexible types of arrangements. These tend to be more private arrangements. So this is when you're doing some pre-planning, powers of attorney like Bob mentioned earlier today. Durable power of attorney for financial decisions. Patient advocate designation for medical, or sometimes referred to as a healthcare power of attorney. Any of you that have ever dealt with residents or patients receiving Social Security benefits know that Social Security doesn't typically recognize financial power of attorney. So the substitute decision-making in those areas are typically representative payee. So all of these are different types of substitute decision-making arrangements. We're going to start with the conservatorship. Conservatorship is a legal process through the probate court. So there is a whole process on how we file for conservatorship. Guardianship is often pursued around the same time. They're usually done hand in hand, not always, but it's oftentimes you'll see both of them. The processes mimic each other quite a bit, so I will be repeating myself. in terms of how we go through that. But a conservatorship is where a court appoints a person or an entity. Sometimes it can be a company, other things in terms of that, to make financial decisions on behalf of another whom the court has determined is unable to make decisions for themselves. And this is often referred to as the protected individual. So again, this is a court determination of lacking competency. Some actions under a conservatorship are restricted. So some of them are restricted by statute. Other ones are restricted by kind of local custom. It's important to know what authority a conservator has kind of on their own or when they need special permission. All probate courts require approval to sell a protected individual's home. So this is statutory. So whenever we're looking at selling somebody's home in the state of Michigan, if they're subject to a conservatorship, we have to go to court and get permission for that. Other times that local custom is going to dictate how the conservator has to act. And that often involves specifically where the court feels like the protected individual has a lot of liquid funds or easily accessible cash or assets that can be turned into cash. Oftentimes what you'll see is kind of one of two. Some circumstances, the court will actually issue something called a restricted account, which means you can't spend more than a certain amount of money without going to court and saying, is this okay? Can I do this? Alternatively, some courts are issuing what's called a bond, which is like an insurance policy saying that the conservator is not going to do bad things. Bonds can sometimes be challenging for conservators to obtain. Sometimes they can be really expensive. More often, I'm seeing courts do more restrictive accounts, but it depends on local custom and knowing your probate court judge and how they're going to approach that. The important thing to understand about conservatorship, though, is it really limits the individual's ability to act for themselves when it comes to financial decision making. This is much more broad than who's going to pay your consumer's bill. This is really cutting off your ability to act independently. You no longer can contract for yourself. Your conservator is doing all of that for you. The conservator has to respond to how the court acts. So you're talking levels of approval that have to happen before someone can make a decision for you. And they're supposed to look towards your best interest and involve you in that conversation as best as possible. But we know with the court system, there's a high volume of cases. With conservators, especially professional conservators, these are sometimes hard individuals to find. So we know with professional ones, they're sometimes hard to find. So that person often may have a large caseload as well. They may not be able to dedicate the individual attention to each protected individual. And that doesn't necessarily mean that conservatorships are bad. It just means it's a more restricted tool that should really only be used when that is the most appropriate tool, when lesser tools are not going to fix the solution that we're looking at. Now with guardianship, also a legal process in the probate court. This is where the court is appointing a person or an entity to make personal, sometimes property, I'll get into that in a minute, decisions on behalf of another who the court has determined is unable to make decisions for themselves. In this circumstance, people subject to a guardianship are often referred to as a ward. This is an old, archaic term. Often has some bad connotation with it in terms of you're a ward of someone else, you're not your own person. With the property allocation portion of it, guardians can sometimes manage a ward's property. There are certain circumstances in which maybe the individual doesn't have a whole lot besides their monthly income. They need to have somebody manage that. But the cost of going to court and getting both a conservatorship and a guardianship might be out of their means. So the court might say the most appropriate tool in this case to help this person is to allow their guardian to manage their monthly income. For determining that, we always have to look at what the court ordered. So we have to look at the court order of guardianship and the letters of guardianship to see what authority that they have. But you will encounter this, so it's important to keep in mind. It doesn't mean that guardians don't manage anything financially. The biggest thing with guardianship, kind of like what I said with conservatorship, is that it cuts off the person's ability to make decisions for themselves. And this is much more far-reaching than simply who makes decisions on your medical care. This is deciding who you see for your medical care, where you live, who you interact with, who you play bingo with, who you get to be in a relationship with. All of this stuff is limited under a guardianship. You can't marry, you can't divorce, you can't decide that, no, you don't want to live there, you want to live here, and you want to interact with these other people. Oftentimes, guardianship is referred to as creating legal ghost. You're here, but you're really not. Someone else is controlling every aspect of your life. And again, sometimes this is required, but it shouldn't be our first step in the process. This is a great tool when it's necessary. As we've known in the state of Michigan, and I'm sure you guys have heard this too from a celebrity standpoint, and we'll get into that a little bit more. State of Michigan has had some really horrific cases of abuse, neglect, or exploitation of our elder population. There have been some cases in the recent years of these individuals being exploited by their court-appointed guardian. And in some circumstances, that's a person who held themselves out to be a professional. So when the tool is used inappropriately and is not supervised appropriately, that tool becomes a weapon. And we really just need to be cautious before we allege that somebody needs these processes, because these are extreme processes. This doesn't mean we should start here because mom forgot to pay her cable bill 5 days late. The overview of the process, aside from it being very restrictive, is very complicated. It's a court process just like anything else, and it's not a one-time heavy court process. It is a continuous court process. And once we get into that process, they're not easy to back out of. So if we determine that tool is a little too heavy, we want to do something different, it can be very challenging to back out of that process. And you've seen this with celebrities. Some have fought for years trying to get out of these arrangements, and they have a lot of money and a lot of publicity and a lot of lawyers, and it's still difficult for them to get out of it. Overview of the process, though, starts just like anything with court. There's legal paperwork that has to be filed, typically in the form of a petition. If we're seeking both a conservatorship and a guardianship, these are 2 court petitions. One is for the conservatorship, one is for the guardianship. A lot of times the courts will hear them at the same time to conserve resources, but there's still 2 separate petitions that we have to file under 2 separate sets of laws. As I've mentioned before, we have to have evidentiary support. We can't just allege somebody is incapacitated and they need this extreme measure without providing support of why it is necessary. And the courts, in my opinion, this is one area that they're actually getting better at. We're going to go through a host of cases and hot topics this afternoon that's really going to highlight some of the guardianship reform, which I think is good sign of times to come, hopefully. But really, we have to provide that evidentiary support to say that this is the most appropriate tool in our toolbox to solve this problem. There's also a priority of appointment. So there are rules stating who has higher claim to be somebody's guardian or conservator. They are different, surprisingly. The court, however, has final discretion. So even if an individual has priority, the court might determine that they are not fit for that role. And this isn't to say that this is a blanket kind of removal for it, but any of you that have had experience in the conservatorship or guardianship realm, specifically in the last 5 to 10 years, have noticed probably more courts doing criminal background checks. Some courts require it just for everything. There's nothing statutory at this point that requires a criminal background check for individuals seeking to be a guardian or conservator. That might change at some point, but most probate courts now are going to conduct a criminal background check on the people, wanting to be this. And it doesn't necessarily mean that if there's something in someone's criminal record, that it's an automatic disqualifier. But courts are rightfully looking at people who should not be trusted with money, should not be trusted with an individual that maybe can't fully take care of themselves and is dependent on someone else. All of these things should be examined a little bit more for potential abuse. So the court's doing an appropriate thing in investigating these people. Just like any other court thing, there is a hearing involved with it. If everything is as it should be and all of our evidentiary support is in and everybody's getting along, families all holding hands where they're supposed to, court's all satisfied with everything, your hearing is probably your one and done. If people are fighting, there could be multiple hearings. There could be a drawn out process for this. In some circumstances, there might actually even be a trial. It's a court process, just like anything else, and it is not quick, like anybody's experience with the court. If the court determines that this person does, in fact, need more support, what they'll typically do is they'll enter their findings on the record and they'll put that into their order. That's when we will see an order of conservatorship or an order of guardianship or both. The court is supposed to put all of its findings on the record as to why the person needs this extra support and what authority the advocate, the guardian or the conservator, will undertake for them. From there, the court also issues something called letters of authority. I'm sure most of you have heard this idea of letters of authority. I've had somebody recently ask, like, I just need you to write a letter. It's not what letters of authority is. If it was, it would make my life significantly easier. But it's a court order. It's a form from the probate court that's going to specify who is the appointed agent, what time frame they have been appointed for, and in some circumstances, it may have the restrictions that they're allowed to do. Maybe it's a guardian that can only make decisions on medical but can't decide who the person talks to. Those do happen from time to time. So that's just getting it up and running. From there, though, there's annual reporting requirements, and they do differ a little bit depending on the role that the agent is wearing. So with a conservatorship, you're typically looking at least an annual reporting requirement, and that is going through to say, here's the money we started with, this came in, this went out, everything is where it should be. And the court will typically review those on at least like an every 2-year basis. But the annual reports are required on a yearly basis, but the court might require an extra hearing. With guardianship, you have to file a report of the guardian every year, which is dictating what's going on with the individual, what kind of medical treatment they've received, where they're currently residing, how they're doing. And that report has to be filed every year. In addition, there might be special permissions that you have to go in front of court. So if your letters are restricted at all, you might have to go to court to get permission to do a specific activity. As I mentioned with conservatorship, you might have to go to the court and say, hey, the individual is now living in a facility. We feel that it is in the best interest to sell the home. We have found a buyer for the home. We feel it is a good price. Do you give us your blessing? All of that has to be undertaken before the person is able to sell the home on behalf of the other person. And it is all to make sure that the protected individual is being taken care of. But these special permissions are adding time, expense, stress. I'm sure everybody is really happy to be in court, right? Oftentimes you would rather be anywhere else, maybe not the Secretary of State. All right, so as I've mentioned in terms of this, guardianship and conservatorship are great tools. But like any tool in our system, and especially in our legal system, it's not perfect. Celebrities have brought a lot of focus on to this idea of guardianship and conservatorship and being unable to make your own decisions. But we know that for every celebrity case, there's hundreds or thousands of individuals. This is your neighbor, your friend from church, your family members that are going through this process, sometimes unnecessarily. And we are so happy to have the Michigan Elder Justice Initiative here as well. They are currently doing a program on guardianship diversion to determine whether or not that tool is being used appropriately? Is there a lesser tool that we can use in this circumstance to make sure that the individual is supported and protected, but maintaining some self-determination and not at the mercy of someone else and the court making their decisions? So really, we need to focus on that. And in Michigan particularly, I'm sure you guys have heard us talk about this for, God, I don't know how many years now at this point. But in Michigan, guardianship reform has become a particular interest. Now, part of that has come out of these horrific cases that we've seen in the state of Michigan. The other part of it is just the call for reform. Too often, these restrictive arrangements were just rubber stamped, and they weren't looked at appropriately. Well, now we're starting to do that. So in Michigan, they're fighting this on a couple of different fronts. MEGI is definitely one of them. Other parts of this is the Michigan Attorney General's office has made elder abuse and guardianship reform one of their platform topics. That has come from cases in the courts, additionally with proposed legislation for guardianship reform. Now we know that legislation is not something that comes quick, nor is it easy. It's really easy to propose a solution to the law without necessarily thinking of how all the pieces come together. And Michigan's currently in the throes of figuring all of that out. On top of that, we got to get through the legislative process, which is always a fun process to go through. Any of you that have ever watched Schoolhouse Rock know that little Bill, sometimes he doesn't make it. And that's currently where we're at right now. A lot of reform, but we're still fighting. So guardianship is not a standard point in the process. That is the other thing that we need to understand. At no point in our lives do we just hit that point where we need a guardian or we need a conservator. You don't automatically need a guardian because you turned 90. It's not like, well, Ethel, you blew out your birthday cake. It's time to go to court and get your guardian. We don't do that. Same thing if you need help. We all need a little extra help sometimes. The fact that we're asking for it doesn't mean that we're incapable of making decisions for ourselves. We just need some extra help. If you have a diagnosis of Alzheimer's or dementia, it might highlight the ability to plan a little bit more. Let's say, let's get this in order. Let's create some urgency here. But it doesn't necessarily mean we've got a diagnosis, we have to go get a guardian. The same with it's for your own good. How you choose to live your life is an individual choice. And as long as you appreciate the consequences of the choices that you make, that doesn't mean someone needs to step in and make decisions for you. People are different. Families are different. In my own family, there are family members where we just choose to do things differently. It doesn't make me right, them wrong. It just makes us different. Or you're making a bad decision. Again, you want to eat McDonald's 3 times a day? Great. As long as you understand sodium's probably not great, carbs probably aren't great, not sure that it's actual meat. Sure. As long as you understand that, you're making those decisions. It should be the last resort. It is a tool, just like anything else. But we need to really evaluate whether or not the tool is being appropriately used. You don't bring in a wrecking ball when you need to use a hammer. And truly, I love this quote by U.S. Representative Claude Pepper because it really highlights the severity of jumping the gun on this. The typical ward has fewer rights than the typical convicted felon. They no longer receive money or pay their bills. They cannot marry or divorce. It is, in one short sentence, the most punitive civil penalty that can be levied against an American citizen, with the exception of the death penalty. And that might seem extreme. But again, remember, this is losing your ability to make choices for yourself. And it really should be undertaken with that level of severity. We shouldn't just assume that someone can't make decisions because they need a little extra help. All right, so what should you do? We should always start by identifying the problem that we're trying to solve. Remember, the wrecking ball and the hammer. We want to use the tool when it's appropriate. So maybe we've got a flow of information or communication issue. Maybe it's a money management issue, healthcare, living arrangements, safety. We should always start with looking at the least restrictive option first. What can we do first that's not going to cause a tidal wave, but solve the problem? And when that least restrictive measure doesn't work, let's look at the next thing. And we work our way up to most restrictive. We don't start there. Most importantly, we want to work with knowledgeable professionals. You're going to hear us a lot today talking about this idea of the circle of care. We're one part of the circle of care. You are another part of the circle of care. Our vendors are another part of the circle of care. All of us need to work together, be rowing in the same direction, be on the same page when it comes to this. Because truly what we're looking out for is the individuals in the community that we serve, and making sure that they're receiving the same level of treatment that we would want for ourselves. So what should you do when you're working with a guardian or conservator? Don't assume that the person has authority. I'm sure you all have dealt with family members that come in, march in, I'm the guardian, I'm the conservator. Ask for their letters. Ask for the order. You might be surprised, they don't have it. They're just making assumptions. If they won't provide it to you, you can always get it from the probate court. All of this stuff is public record. So you can go to the probate court where they reside, request the information on it. Probate court might say, we don't have a file. That tells you something. You also want to review these documents annually. Courts sometimes update this. The letters of authority, specifically, sometimes those get updated on a regular basis, sometimes they don't. But it's something we want to look at annually. So moving on from most restrictive to less restrictive. Powers of attorney. This is a great tool for you to plan for what you want. We've covered basically two areas. We have the financial with the durable power of attorney. And extraordinary power is what we'll talk about. We'll also talk about the law change that happened last year. And then we've got medical healthcare. So patient advocate designation, living will, healthcare power of attorney, they're all kind of mashed together for the same thing. Or HIPAA. I'm sure all of you have experienced HIPAA, whether personally or in your daily lives, what you can share. Financial power of attorney requirements. Who can create a power of attorney? Anybody 18 years and older. So any of you with college grads or people going out to college in the next couple of months, consider this for your kids. Because once they turn 18, you don't get to manage their stuff anymore. The DVOA must be in writing, so it can't be an oral assignment. I can't say, hey, Liz, you're going to handle my banking, right? It has to be in writing. It also has to be executed appropriately. So in Michigan, this can be done a couple different ways, and there's a lot of confusion amongst the powers that we're going to talk about in terms of their requirements. It's always a problem because they're different. So in Michigan, the power of attorney can be notarized or it can be witnessed. Best practice is to do both. In case one's an issue, you have the other one as a backup. The attorney, in fact, the person who's acting for another person, has to sign an acceptance. This is statutory. There are some standard things that you can just sign and accept to. Any ones that have older powers of attorney pre-October 2012, this was not required. Best practice is still to have them sign an acceptance. That way they're agreeing to do all the things. Have a clear and complete copy of the power of attorney. How many of you have encountered this where somebody comes in with the power of attorney and you have pages 1, 5, and 8 on a regular basis, right? Have a complete copy of the power of attorney. Look at it, review it. What does it say? Does this person actually have authority or are they third on the list? Are they able to make decisions in this area? Maybe they're not able to manage banking. They were only given permission to sell the house for one day for a closing event. We have to look at these in particular. Is the power of attorney springing? What do I mean by that? I don't mean that it's jumping. I mean, when is it going into effect? When is that triggering effect coming into play? Powers of attorney vary in this area. They can be effective immediately, which means upon signing, if I say, I want to have Liz be my power of attorney, that means day one, Liz can make decisions for me. Some powers of attorney have triggering events, meaning Liz only gets to make decisions for me once doctors have determined I'm not able to make decisions for myself. So we have to look and see when it's triggered. Best practice is to have 2 doctors' statements sign off on that for those triggering events. Law change in Michigan. So last July, this went into effect. Michigan passed a uniform durable power of attorney law. What does that mean? It means Michigan was having some problems with powers of attorney not being consistent. So what did they try and do? They tried to provide some consistency. So now we have a statutory form. Any of you that have heard me speak before know that I really take issue with forms being widely available. And it's not because I don't want legal access to things. It's because this is the most important document that you have in your toolbox when it comes to planning for your future. Us as elder law attorneys, this is the very first document that we ask about whenever we meet with individuals. If they don't have one, it's the very first document that we're getting. And it really drives our ability to protect what someone has, what you have worked your entire life for. Because unfortunately, how our world works is money gives you options. And we want to make sure that our clients, our people in our community have those options. So the statutory form is out there. You can, of course, download it. But make sure you're understanding the consequences of what authority you are authorizing, or more importantly, not authorizing. Because if we have a power of attorney that comes in and doesn't do what we need it to do, we might be looking at a longer term battle, which is going to add time, money, and stress to your family. We want to make sure that we're evaluating that. This did not invalidate any previous powers of attorney. Oftentimes I'm recommending an update for it at this point because it'll make your agent's life easier. The financial institutions that we are working with are looking for this consistency now in Michigan. So that's what we're hoping to bring. Patient advocate designations, healthcare powers of attorney. So this is where you are appointing someone else to make medical decisions for yourself. Only medical. Patient advocate doesn't have the authority to decide all the other stuff. It's just medical decision making. By the very nature of this law, it's springing. You can't have an effective, immediately healthcare power of attorney or patient advocate designation. It is only in effect once 2 doctors determine that you cannot make decisions for yourself, and that is by state statute. The patient advocate designation will also provide guidance to the agent about what the patient wants or doesn't want, how they might have to go about making decisions. All of that's going to be contained within the patient advocate itself. A patient advocate can be signed by anybody 18 years or older. So this is another thing for those of you with kids that are leaving the nest soon. That ability to make decisions for your kids ends when they turn 18. We want to make sure we've got some planning in place. Patient must be of sound mind at the time that they are executing this document. What that essentially means is that they understand the nature of what they're doing. That they understand that they can appoint someone else to make decisions for them if they can't make it for themselves. And that you can identify some basic things surrounding that. So you can identify who your family are, kind of what you own, that kind of idea of sound mind. Doesn't mean that you have to be as sharp as you once were. You just need to understand the nature of the arrangement. Other things with healthcare powers of attorney or patient advocate designations is understanding kind of where they come in all of this. And that just like any legal tool, there's pros, there's cons. They have some significant limitations in the ability to make decisions in all areas. Like I said, these are limited. So they're a little bit more limited in terms of what they can talk about. So whenever we've got patient advocate challenges, we always want to look at revocation or removal. So this is one fun area. And even if a person has been determined to be incapacitated under the law, they can still fire their patient advocate. So these documents can be revoked even if 2 doctors have said they can't make decisions for themselves. So that can be a problem, especially in the area that we deal with, which oftentimes has individuals with some level of diminished capacity. And that capacity whole being a fluid thing, you wake up one day, you don't necessarily recognize who your family is. You're like, I don't know who these people are, but they're telling me I gotta take my blood pressure pills, and I don't like that. So we always have the risk of revocation with it. Specifically, whenever we've got the risk of revocation in the terms of diminished capacity, specifically when we're talking about the mind's ability to understand and process information, that's where we want to have this 30-day provision for mental health treatment. Mental health treatment needs to be authorized in the patient advocate designation itself. Mental health treatment is often kind of narrowed by a lot of people, but it needs to be broader. So whenever we're talking mental health treatment, we're typically talking about the mind's ability to understand and process information. Yes, that can be in the form of psychiatric disorders. It can also be Alzheimer's, dementia, medication issues, infections. All of those can often present as a mental health crisis rather than an underlying issue. So that's why it's important for the healthcare power of attorney to have this mental health provision in there. And what that's essentially doing is it says, all right, if I'm having a mental health issue or it's presenting as a mental health issue and I don't recognize who my people are and I fire them, the mental health treatment provision allows that agent to continue to get that person help for a period of up to 30 days. 30 days is time for us to investigate, problem solve. In those worst case scenarios, it's giving us time to go into court, but it's allowing us to provide some stability to the situation. So it's important that our healthcare powers of attorney address that. We also risk with removal with our challenges. So a patient advocate can be removed by the probate court for a variety of reasons. Maybe they're doing a bad job. They're not doing what they're supposed to. Maybe they're doing nothing. They're just non-communicative. In those circumstances, a patient advocate can be removed and replaced with a guardian. So we have those challenges with patient advocates. So what happens when we don't have any of these and there's an emergency? Because we know that not everybody wants to talk about death and incapacity. Sometimes people just ignore it. Cross that bridge when we get to it. So if that happens, there's no patient advocate, no time for a guardian, what do? In Michigan, there's 2 laws that are really going to come into place currently. This might change in the future, but currently there's 2 laws. One is going to be the more relevant one to you guys. This is the Social Welfare Act. So this one applies to nursing home residents and others enrolled in Medicaid. And what this is basically doing is saying that if we don't have a patient advocate and we don't have a guardian and somebody needs to give consent for treatment, they get to stand kind of like in loco parentis, which is like more of a parental role, to be able to consent to that. But this is a very limited portion, right? Nursing homes on Medicaid. Other problems that we have with this is it doesn't define who the nearest relative is. Statute says the nearest relative can make decisions. Is that nearest in proximity? Is that nearest in relationship? What if there's multiple ones? What if it's the kids? You have 15 kids. How many do you got to track down? So there's no guidance on that. There's also no guidance as to when a patient is not of sound mind. Best practice, use those capacity things that I talked about. They understand who their family is. Can they identify some basic things? Having an attending physician and a second physician review it, probably going to be your best course of action. And remember, this is inappropriate to use unless and until that determination is made. The people should always be looking at the patient or the resident first. We presume that they are having capacity. We don't presume that they're not. All right. Dignified Death Act. So Dignified Death Act is much more of an informed consent law. It's not really a surrogate decision-making law, and it's very narrowly kind of applied. This gives physicians certain responsibilities who diagnose an individual as terminally ill to go over certain things. They're supposed to go over that with the patient, but if the patient's not able to have that conversation, they can go over it with a surrogate. So that's a member of the immediate family, next of kin, legal guardian. Same problems, doesn't define the nearest person of priority. And there's no guidance as to someone being of sound mind. So what is your best practice? If the family is all there and everyone's holding hands, singing Kumbaya, and everything's great, low risk. anybody's fighting, higher possibility of an issue. So it's always best to proceed cautiously, loop in your facility's legal department, maybe even kick it to the court. Again, nothing in this law expressly allows a family member to make decisions. It is an implicit. It's just saying, yeah, you can give this person informed consent to substitute for the other. But it doesn't necessarily mean that person gets to make decisions. The law only provides the implication if the person is terminally ill. If they can't have that conversation and there's no guardian or patient advocate, then do you look towards other people? So what happens if you're not on Medicaid or if you're not in a nursing home? Bad news. There is no statutory authority that you guys can rely on. And I know that's frustrating. I went to law to learn the rules. I went to law school because I like rules. Then I got to law school and they're like, everything is shades of gray. Like, cool. So that's what you guys are in the trenches dealing with, is shades of gray. We do the best that we can. We have as much information as possible, the people in our toolbox to help us, but it's shades of gray. Status quo is generally going to be preserve life to the greatest extent possible. Certain customs can dictate other things. But what do you guys risk? Because that's what we're here to look at. We want to make sure you guys are protected. So that's making sure that you understand we could be facing lawsuits, citations from LARA or other regulatory agencies, family issues. Like, really, you want to be able to judge that, and that's where your individual facility's legal department is really going to be helpful. So I mentioned that right now that's the case. In 2024, Michigan House Bill 5833 proposed a legal framework for surrogate healthcare decision-making, where a patient is incapacitated and lacks a designated advocate or guardian. Key provisions here: fix some of the issues, or propose to fix some of the issues. Defined a surrogate, gave a priority of who gets to stand in that role. It also allowed an adult or an emancipated minor to designate that person. So you could kind of proactively designate that if you didn't have the formal documents ahead of time. When you're in the hospital, you could say, this is the person I want. It also specified, and this is important, that the surrogate's authority is suspended when the patient regains decision-making capacity. So if they're able to do it, they run the show. Everybody else is back on the bench. Unfortunately, though, this bill did not pass in 2024. Going back to our Schoolhouse Rock, I'm just a bill. Legislation takes time. And unfortunately, this one died in lame duck. It has not yet been reintroduced in the Michigan legislature. I know that there are those in the community that find this to be incredibly important. This is a backup. Let's not wait for a clear backup to come into play, though. Let's proactively plan. Let's look at those powers of attorney and what we can do. All right. Everyone's favorite topic: do not resuscitate orders. So what is a do not resuscitate order? A document that directs that in the event of a medical emergency outside of a hospital, that no heroic measures, CPR, be undertaken. The legal authority is found in the Michigan Do Not Resuscitate Procedure Act, and it does set some clear procedures that we're supposed to do whenever we're talking about DNRs. One of the biggest things that I often clarify in our office is that this isn't a form that a lawyer prepares for you. This is a physician order. This is something that should be discussed with your doctor. So who can sign one? If the person, him or herself, is able, they can do it. They can talk to their doctor about all of the things that might necessitate the underlying reason why they want a DNR. If they can't do it for themselves, the patient advocate can do it if the document allows. That's why we have to read the documents to see what's determined. Best practice is to have a clear copy and review it each year. Having a DNR on file one time does not necessarily mean that somebody can't change their mind. This is something that should be reviewed with them on a regular basis. I'm sure all of you have had experience doing this, discussing this with your residents or your patients. If the patient advocate is the one signing on behalf of them, you got to look at the patient advocate designation. Determine if they're able to make that decision. Does that person want this? Those are things that are often contained within the patient advocate designation to see what they want with regard to life-sustaining measures, but you have to look at it. So guardians of legally incapacitated individuals, this is going to sound really technical, bear with me, appointed after February 4th, 2014, can execute a DNR on behalf of their wards if the ward can't act on their own. So if they have a guardian, the ward has to rely on the guardian. It has some requirements with it though. So prior to signing the DNR, the guardian must visit with the patient not more than 14 days prior to signing the DNR. To the extent possible, they have to talk to the patient about the circumstances, about, okay, here's the cause, here's the effect, here's what would happen. And making sure that if meaningful conversation is possible, that we're having that meaningful conversation with that person. Just because they need extra help doesn't mean that what they want for themselves isn't important. They also are then supposed to consult with the patient's physician and talk about the circumstances justifying the DNR. So the underlying conditions and why this might be an appropriate thing. After signing the DNR, the guardians must each year do the same thing over again. Consult with the person if meaningful conversation is possible, and consult with the physician to make sure that this is still appropriate. This is still something that they want. For guardians that were appointed pre-February 4th, 2014, if your letters of authority haven't been updated, you haven't gone to court to specifically deal with this issue, those guardians might want to consider going to court and just saying, is this okay? Sometimes this is referred to as like a petition for instruction or a court approval issue. It's basically just having the court rubber stamp it to say that this is okay. In circumstances where that's happening, likely they're still going to do the same steps that we just went over. So they have to talk to the person, they have to talk to the physician, they have to do that every single year.
Hey, Kelly.
Yeah.
So we were told by some of our social workers that in Macomb County, the judges are often specifically putting a restriction saying that the guardians cannot sign a DNR.
Yep.
So you have to go back to the judge. And I think that's consistent among all the judges in Macomb County.
Yeah, so that's one of those things, again, that I highlight when it comes to the guardian's letters of authority. And this is why we have to look at it. Not all guardianships are the same. You have to look at the order or the letters of authority. And if your letters of authority say that they can't sign a DNR without court permission, then our best bet is to not sign a DNR without court permission. This is not a scenario where you want to be explaining to the court of like, I saw that instruction, but I ignored it. That won't go over well. For DNR validity, a patient must be 18 years or older. The patient must be of sound mind. There's a theme here with sound mind. Or if it's being signed by an agent, that it's a validly appointed agent or patient advocate. So guardian or patient advocate acting pursuant to those documents. It also must be signed by the patient's physician unless the physician is refusing to do so out of religious purposes. And then finally, it's got to be signed by 2 witnesses. So the patient advocate is a little different from this, and this is where it causes a lot of confusion. The patient advocate has to be signed by 2 witnesses. So where you're appointing someone else to make medical decisions for yourself, has to be signed by 2 independent witnesses. Now, independent, what does that mean? Nobody related to the person. And if that person is also in a facility, nobody that works at the facility. So I'm sure many of you have been asked by family members, hey, can you witness this? If what you're signing is a patient advocate, you have to politely yet firmly decline. When in doubt, blame me. I'm happy to take that on and say, I saw this lawyer talk and she told me not to do it. Opposite with the DNR. So the DNR, you still need witnesses, but one of them can be related to the person. So you've got all these documents with different execution requirements and trying to navigate this field. And that's why it's really important to understand the different hats that people have. All right. Doc Brown said it best. Your future is whatever you make it. So make it a good one. The whole point of substitute decision-making is allowing you to choose what is the best path forward for yourself. And if that choice is deciding who you want in your toolbox to make decisions for you, that is one of the most important choices that you guys can make. So it's really important that not only for your patients and your residents, but yourselves, every single person in this room, I'm assuming is 18 years and older. I haven't scanned the crowd. You don't look a day over 21, none of you. But this is important not only for those that you serve, it's important for yourselves as well. All of us can't stop time. None of us have a time machine yet. And if you do, please let me know. I have some important dates I need to check on. But the future is coming, whether we like it or not. We might as well plan for it. And making sure that our needs and what we want for ourselves is the path that we're going down. All right. I finished a minute early. New record.
Yes, thank you, Kelly. So we do have a couple minutes for questions. Does anyone have a question for Kelly? Oh, we have one.
Awesome.
So on the guardianship, so you got guardianship and you're out of the country.
So is the guardian out of the country?
Yes.
Okay.
Yes.
All right.
And, or they could just be out of the state, just
Yes.
kind of unreachable, or they're far away.
Yeah.
And there is something happens
Yep.
to the ward. I'll just use that word.
Yeah. Somebody needs to make a decision. Yep.
Is that something a guardian should make sure if they're going to be out of the country, they should have some kind of, is
Yeah.
there a secondary, what happens in a case like that?
The possibility exists that there's actually a court case with that exact.
Yeah.
fact
It's, I think, did we leak the PowerPoints? So there is a court case that actually happened with that exact circumstance. What's going to happen is in the event that somebody is non-communicative, if the guardian just leaves and is like, I'm going to live my best Parisian life, I'm not going to deal with this anymore. Court can remove that person. We can go to court and say, hey, court, can you do something about this? And the facility can petition for these instructions to say, hey, this is what's going on. We need someone to make a determination. If there's other family members or individuals involved, they can also insert themselves with it. But when there is that court-appointed agent and nobody is responding, your best bet is to go back to that court and say, hey, this is what's going on. These are the circumstances that are happening. We need direction. But yes, it does happen.
We're going to talk about this a little bit later, but the court case was the court tried to do a temporary removal of the person without a full hearing. And the Court of Appeals says you can't do that.
Court made some mistakes in that circumstance, which is.
Well, let's assume this guardian is a responsible one.
They're just not communicating?
No, they're just out of the country.
So, I mean.
And, okay, they would communicate from wherever they are to the situation.
So communication is one thing, timely communication would be another. So if you're communicating, you can have guardians be out of state as long as they're appropriately responding to the underlying events, right? If they're not appropriately responding, you might want to consider those extra steps, but you can be in other places. Some courts I know are particular about somebody being in state. They might not appoint one. They might have had a circumstance where somebody got burned. But physical presence isn't necessarily required. Now, as a guardian, they are required to physically meet with the ward at least once a year, if not more as a best practice. But, you know, timely communication would be one thing. So yeah, they respond to our messages 3 days later, but then there may not be serving that role appropriately. But physical location in the state of Michigan is not necessarily required all the time.
But I'm not sure that that is the answer. I mean, I'm not sure that answered my question. So I have in mind a friend who's taking a trip to Greece for 2 weeks.
Okay. She wants to have a temporary person in place.
Well, that's my question. If
she can do that.
That's what can the guardian do?
She can go to court.
It's a responsible person.
Yeah. So what she would end up having to do in this circumstance, especially if it's an extended vacation, she'd have to go to court to say, hey, this is the circumstance that's going on. Can we appoint somebody as a temporary in that circumstance? But they can't just delegate their authority to someone blatantly in all circumstances.
Okay. And then on the DNR, doesn't it have to specify? I always thought that the DNR is if there's no hope for or no good reason to think this person's going to come out of that situation.
So
doesn't it have
DNR's
to
a little,
specify in a DNR that the chances for survival or whatever are slim.
So DNR does require counseling with a physician to talk about the circumstances underlying what might justify the DNR. It doesn't necessarily mean that that person has to be in a life-threatening circumstance at that point. There are individuals that are okay health-wise, but as we get older, our bones become much more brittle. The idea of doing heroic measures can sometimes be more damaging on the body than what it would serve a purpose for. So those would be one of those underlying conditions that the physician would counsel on. But it doesn't necessarily mean that there has to be an emergency at that point.
Thank you.
So I just specify on that. That's kind of the difference between a DNR and a patient advocate
Exactly.
or a healthcare power of attorney. Healthcare power of attorney is going to have that language in there that says, if there's no meaningful chance of recovery. DNR is don't resuscitate.
DNR is
don't give me CPR.
Yeah, don't do chest compressions, all of that. That's specifically what DNR is referencing. All right.
All
With
right.
that.
Oh.
Oh.
We can take one more quick question. I told you to give me some steps. So
You
here
got
we go.
I believe in you, Savannah.
Thank you so much for your presentation.
Oh, thank you.
It was great. I am currently working with a woman who she came up to me and she said, well, what happens when my husband passes? He is my durable power of attorney.
He's her agent. Okay.
Right, for medical and for financial, but she said, say he dies before me or I die before him. We have no children.
Okay.
No friends that she would feel are going to outlive her.
Yeah.
And she says, what do I do?
What options do I have?
Yeah,
And
what
those are
my
hard.
options?
Yeah. So the question being is, if we have somebody who is our agent, we love and trust that person, but if something happened to that person, we don't really have anybody else. What are our options? There are options out there. They're not as multiple as they should be. So there are some circumstances where you can find a professional to serve in that role. Those are harder and harder roles to fill. Part of that is from the guardianship reform and some of the things that we're seeing from trying to catch bad seeds. Whenever you try and catch bad seeds, you often make it harder for good seeds to grow. So that's one of the circumstances. There's not nearly enough out there. But that's where having those community resources are really, really important. So if we can find a professional, I know in our office, we have a couple that we refer to on a professional basis that for this exact circumstance, saying, this is who it is, this is who I trust. But that's one of the things that we commonly counsel on and do our best to link that person with community resources or professionals in the community. But it can be challenging. All right. Thank you all. If you guys
Thank
have
you,
questions
Kelly.
you weren't comfortable asking, I'll be around.
Thank you, Kelly.
So let's go ahead and give it up for Bob and Amy.
All right. I'll use the clicker here. So, if you've been to boot camp before, you know that on some years we try to make sure we go back to the basics, right? We cover what I would call Elder Law 101. In fact, that's what I think we called it last year, was Elder Law 101. And then some years we take you to school. This is one of those years. So we're calling this the master class because we're going to do a deep dive on Medicare and Medicaid. And later on, we're going to do a deep dive on veterans benefits. This has been something that the attendees at boot camp have been requesting for a few years, saying, we'd really like a real deep dive, more information about veterans benefits, about Medicare and Medicaid. Now, here's my promise to you. My promise to you is that I will make this relevant to you, especially the Medicare. Everybody's probably needs to know about Medicaid, and that'll be the second part of this presentation right now. The Medicare stuff, okay, it gets a little weighty. It can be a little bit complicated. I promise you there's a payoff at the end. I have to get through some of the stuff about, and we're going to focus mostly on Medicare. We're going to focus on how many days of rehab do you get, okay? Anybody been around long enough, like Amy and I, where we remember people getting 100 days of rehab? A few of you, or if not 100 days, 60 or 70, days. Now, sometimes 7 days, maybe 20 days, maybe 2 weeks. And there's some reasons why. I know a lot of us like to blame the insurance companies, and that's definitely part of it, but there's more to it than that. And so I promise to make this relevant, even if you're not, don't work in skilled care, even if you're not, it's something that if you work with seniors, this is going to be relevant for you to help your seniors, okay? And so I promise, I know that Medicare can be a really weighty issue, and I'm taking you to a graduate level class today, okay? But understand, I promise to make it relevant. So if some of the stuff you really like, okay, RACs and RUGs and all these other things, understand. We got to go through it, but then I'm going to say, okay, this is what this really means for you and the people you serve. All right. So that's my promise to you. So we're going to really focus and just do a deep dive on those two issues. Medicare as it relates to the Medicare days in skilled care, so your rehab days, and then Medicaid, an overview of all of Medicaid. Okay, so let's get started. Before we do this, I think it's important to talk about the context of this. So I'm going to refer to Amy and ask Amy, why is Medicare and Medicaid so important? I know a lot of us are worried that there's going to be cuts, right? This is something that we should be worried about, but why do we need to be advocates of these programs? Okay, and so I'm going to ask Amy to kind of wax poetic about how important this is and the importance of it in the lives of the folks that we serve.
Medicare and Medicaid aren't just government programs. They are lifelines for a lot of us. For millions of older adults, these aren't abstract policies. They can be the difference between getting care and going without, between aging with dignity or facing impossible choices. Medicare ensures that our seniors aren't denied the health care they've earned simply because they turned 65. It covers hospital stays, doctors, and therapists that help people recover and stay independent. But Medicare isn't free, and it doesn't cover everything. That's where Medicaid becomes crucial. Because when a loved one needs 24-hour care after a stroke or help at home with Alzheimer's, Medicaid is often the only safety net strong enough to catch them. It's not just for the poor, it's for the middle-class families who've worked their whole lives and suddenly find themselves with a $11,000 or more skilled nursing bill. Yet every year, these programs are misunderstood, under threat, or burdened with red tape. That's why we must raise our voices. We must protect and strengthen Medicare and Medicaid, not just for today's seniors, but for every generation that follows. Aging is inevitable. Going bankrupt to get care shouldn't be. This isn't a political issue. It's a human one.
Okay, so I know we have a lot of people watching online today, and so it's first of all, I'd encourage you to try to get here next year. It's much more fun. When you guys agree, it's more fun. You hear all the
get to win prizes.
There's an energy in the room that I've always liked about boot camp, and that's one of the reasons why we have the vendors in the room with us, is because it really provides a nice energy for today. But I will say that this can be it's easy to get distracted when you're online. And so again, as we go through kind of a weightier issue here with the first part of this presentation on Medicare, I encourage you to know there is a payoff at the end of something that you're going to find fascinating and frustrating and hopefully be a little bit angry about. It leads up to that. So just know that this is going to be relevant to anybody that works with seniors. So we're going to start off, like I said, with the Medicare benefit and kind of diving on specifically the days that we get after we leave the hospital, right?
Bob, what are the rights to appeal Medicare discharge from a skilled nursing facility?
So this is probably where you have some context that you may have at least heard of this, and so this might be your context of it. That some of you might not know that you can also appeal a discharge from the hospital. It's actually a very similar process of appealing a discharge from a hospital, which I'll spend a second on that in a minute. But appealing discharge from rehab for physical therapy, all of that, that's something that many of you have heard about, and we're going to talk about that process. So I decided to start with that concept of appealing that discharge. It's not scary, and it's best if you can make sure the clients and the families understand it's not scary. It's a phone call. Okay, so we're going to dive into this process. But if you've been told, or if any of the folks that you help have been told that Medicare will stop covering care at the skilled nursing facility, and you have a right to a fast appeal. That's one of the few Medicare and insurance appeals, Blue Cross and insurance appeals, that actually is effective because it's fast. Years ago, I tried to appeal I had a client who had spent 10 days in the hospital under observation. Now, if you understand the concept of going to the hospital and you're there for observation versus being admitted to the hospital, that's not supposed to happen, okay? You're not supposed to be on observation for 10 days because a whole lot of Medicare rights kick in as soon as you get admitted, okay? You have a lot more that the hospital is obligated to you as soon as you get admitted versus observation. And so no one should be on observation for 10 days. And so I was like, this needs to be appealed. We need to address this. And I looked into it, and the appeal was probably going to take 6 months, possibly a year. What good is that? No one's going to remember the whole concept of it. So this is not that. When we're appealing a discharge either from the hospital or from skilled nursing, it is a fast appeal. So step one, we're just going to go through the steps real quick. They were teasing me because I tend to be a bit overambitious about how much information we can cover. So I got 60 slides, so I can't spend more than 60 seconds on any slide. We're not going to get through all the slides, guys. We're going to end up having to skip some of the slides, especially at the end. But the bottom line is I'm going to go through this part pretty quickly. A lot of you have at least had someone that you know be discharged from either the hospital or discharged from the skilled care. Let me talk about the discharge from the hospital really quick. We use that strategically frequently. So if the hospital is saying, get out, and I don't mean to be mean about this, but sometimes it feels like the hospital is saying, get out, and so we can appeal that discharge, and we do two things. We ask for a formal discharge meeting and express our concerns, and then we can do an appeal I probably shouldn't, this is the part I shouldn't say out loud, especially since we're on recording, but if you appeal it on a Friday afternoon, it won't be heard until Monday morning. And now we got through the weekend.
We've never done that.
Yeah. Now we got through the weekend, and now they can call our office and we can help them with that process. Because anybody ever notice it seems like there's a whole lot of hospital discharges on Friday afternoons? I know if you work in skilled care, you're like busy on Friday afternoons because that's when they want to get everybody out of the hospital. And that's not ideal, especially if you're supposed to be getting some rehab, because they're probably not going to get physical therapy, occupational therapy on the weekend, really. So now we just burned 2 days out of our benefit. But okay, I told you I was going to move fast. Step one, you get the notice of non-coverage. That's going to be the facility distributes this notice of non-coverage. Back in the day, when we would do these appeals, so the appeal organization is called the Quality Improvement Organization, currently Levanta. I'm sure many of you are familiar with. Levanta, back in the day when it was MPRO, anybody remember MPRO? So we could win an appeal and get an extension on technicalities. So if it wasn't delivered properly, if it wasn't communicated properly, we almost always would get an extension just on some kind of technicality. They don't, Levanta does not care about technicalities. I've never won a Levanta appeal on technicalities. They only look at, my opinion, I'm not sure this is true, but my opinion is they're only looking at the case file, not really looking at anything I say or what the family says. Okay. So we get the notice of non-coverage. Act fast. Okay. So we have the Levanta is part of the quality improvement organizations. It should be listed on the notice, and there's a phone number to call. Act fast, meaning they have to call by noon of the day before services end. When does services end? If they say you're discharged on Thursday, when did services end? Wednesday, meaning we have to call on Tuesday before noon. That gets confusing for a lot of the families because they say, oh, you have to call by noon of the, when services end. Well, they're thinking Thursday, so they're calling by Wednesday at noon. And also, you can't call too early because it might not be in the system yet. So if they're just kind of talking about discharge but haven't actually formally submitted the discharge paperwork to the QIO, then you can't do that. So it's kind of a small window, but it's very important. There's, of course, the review by the QIO. They have to make a decision within 72 hours. It's usually much faster than that. Levanta, okay, sorry, that's you.
What does Levanta consider when making a decision about continued coverage in a skilled nursing facility?
So I'm going to tell you what officially they're supposed to consider, and then I'll tell you what I think they would consider. So they're supposed to consider, of course, what happened there? Medical necessity, which is required daily skilled services. Are they reasonable and necessary for that diagnosis? Documentation from the facility, including progress notes, physician orders, a therapy evaluation, discharge summaries. Now, again, I told you I was going to make this relevant to everybody. Why do we care about this? We care about this because if we can get our, if you're working in a home care agency and you've got somebody that's ends up going into skilled care, and we can get them continuing skilled care, more skilled care. Let's say there was a stroke. Boy, and I would think if you have a massive stroke, you'd get your whole 100 days. I've seen people kicked out after 2 weeks after they had a massive stroke. But how do you get that? It's this documentation, okay? And we're going to talk about specifically the documentation. So what if you don't work in long-term care? Not long-term care. What if you don't work in a skilled nursing facility? You might be a home care place. You might be assisted living, but people are still looking for you for advice. They're certainly looking for us for advice. And if we can help them request better documentation of this, which I'm going to show you in a minute specifically what the forms are, which are the most important ones, then more likely that we're going to get longer coverage. Therapy evaluation and logs, discharge summaries, and planned discharge orders. So this is where there's a sort of a conflict between number 3 and number 4. Number 3 says, has the patient's condition plateaued? We all hear that, right? Plateau. If it's plateaued, we're probably going to lose coverage. Yet number 4 says, oh, but if it's plateaued, that's not enough to end coverage because of this JIMO settlement from, 2013. You guys?
Yes.
2013. So it's been around for a bit, right? We have this JIMO settlement that says you shouldn't be denying coverage simply because of a plateau. That Medicare coverage does not require the patient to improve, only that the skilled care is needed to maintain or slow the decline of the condition. But number 3 just said, what is the patient's condition plateau? That's almost the exact opposite. And people get discharged when they plateau. That's what's actually, regardless of what JIMO says, that's been my experience. Okay, so beneficiary area and specific considerations and time coverage. Obviously, if we've gone through the whole 100 days, on those rare occasions where we do get our whole 100 days, then coverage would typically end. There's, of course, some exceptions to that rule, too.
What is the process of appeal of the discharge?
Okay, so discharge appeals, again, this is kind of a repeat, but the question here, we kind of phrased this question wrong because what I just went through was the traditional Medicare appeal, right? And so I had a question when I was preparing this presentation, and I kind of knew the answer just by, what actually happens, but I wanted to confirm that this was the law. how many people now, instead of having traditional Medicare, they got the Medicare Advantage plans, right? It's very popular. We're going to show you the statistic in a second here. So, and again, this is relevant. If you work with seniors, this is relevant because the conversation about, traditional Medicare versus Medicare Advantage, and the good news is on this from a discharge, it's pretty much the same process. You still get to call Levanta.
Levant. Yes.
Okay, thank you. You still get to call Levanta. So you look for the notice of non-coverage. You have to call by noon of the day before coverage ends. Medicare continues to pay during the review and if the appeal is timely, and the QIO or Levanta reviews the medical records. If the appeal is denied, they can ask for an additional appeal by the independent review entity. They're supposed to apply the GMO standard. We all know about that, but the difference is the Medicare Advantage plans are actively involved in that review process, which obviously wouldn't occur if it was traditional Medicare. Okay, so we're going to dive a little bit deeper in that Medicare versus Medicare Advantage in just a second here. But the good news is they have this legal right. So I was concerned after the trend was everybody moving to the Medicare Advantage programs. I was concerned that the insurance companies were going to take over the discharge process. Really, the first level of appeal is the same. Beyond that, then the insurance company might have a different appeal process beyond the first level of appeal. What is our experience? So I told you back when we had MPRO as the quality improvement organization, we almost always got extension. We'd file appeals on almost every case. We'd almost always get extensions. Levanta, the one before it, I can't remember the name of the one before Levanta. It was the one out of Ohio. Anyway, they had like a 98% denial rate for appeals. They just rubber stamped denials for everything. Now, Levanta's not that way. Levanta actually, we get a lot of extensions through Levanta. I cannot ever predict if we're going to get an extension or not. I think the answer is it's based almost entirely on the facility's notes. Okay, they don't care what I say. They don't care what the family says. They don't care. They don't look at any outside input. It's based on the documentation in the facility. And I think it's solely based on, that's why I can't predict it, because I don't always get to see all the documentation from the facility. All right.
What is the difference between traditional Medicare and Medicare Advantage?
Okay, so we've been skirting around this issue, right? I've been talking about this for the last few minutes here about Medicare versus Medicare Advantage. So Medicare Advantage is actually, so you know about Medicare Part A and Part B, right? So Part A is going to be the skilled care nursing home. Part B is going to be the outpatient, right? So if we need continuing rehab, that's going to be under Part B. If we're going to be inpatient in a rehab facility, that's going to be under Part A. And so often, once you've exhausted your Part A, you can go to Part B and get some outpatient. Sometimes, when we have cooperative facilities, which we generally have all of the cooperative facilities, pretty much everybody that we work with, I think, tries to cooperate with this. We can get Part B outpatient while we're still inpatient. Meaning, let's say the Part A runs out, we can't get any more Part A, but we're staying at the facility, whichever one it is. Often we can work with the skilled care place to say, okay, can we now get outpatient even though we're still living at Wellbridge or Regency or Oaks or wherever it is, okay? And the answer is often we can, okay? Now, you got to kind of thread that needle. It's not always the easiest administrative process, but that's what we do. That's what we advocate for. So traditional Medicare typically covers about 80% of the cost, okay? Medicare Advantage is where it incorporates the Medicare benefit through the insurance company. So the insurance company kind of runs everything under Medicare Advantage. And this is set up through Medicare Part C, okay? What's the difference? Well, Medicare, if we have traditional Medicare, so when my parents were looking into this, I recommended that they do traditional Medicare and then get a Medicare supplement. Why? because it has deeper coverage. Okay, more deeper coverage, less copays, more coverage. Medicare Advantage has wider coverage. You might get prescriptions and dental and free health visits and gym membership. I don't know. They have all kinds of crazy stuff that they put as part of Medicare Advantage these days. And so it has more stuff, but less deep, meaning you can have copays and less coverage potentially. And so I think as we get older, probably my advice for most people is we want deeper coverage. Now, if you're 65 and running marathons, I can see why there's an advantage, that Medicare Advantage might be real attractive to you because maybe it covers vision and dental, maybe it covers other stuff. Definitely probably covers prescriptions rather than having to have a separate coverage for each of those things. So my main thought is if you're healthy, Medicare Advantage is okay. If you're less healthy or getting to the 80s and 90s and beyond, maybe traditional. Now, switching back and forth isn't always that easy. Okay, that's where you have to be careful about that because you can't just switch on a dime.
How many seniors choose traditional Medicare versus Medicare Advantage?
So this is really interesting. Nationally, 54% have the Medicare Advantage. Okay, that's up from 19% in 2007. So we went from 19% in 2007 up to 54% nationally. Michigan's even more. So Michigan, 62% of Michigan seniors have the Medicare Advantage. I think there's one primary reason why. Anybody remember the, what was it called? Legacy, the Medigap Legacy plan through Blue Cross? I try not to be too critical of insurance companies, but insurance companies in Michigan have a whole lot of political power. And so they used to be required to offer this legacy plan, which was a low cost, great coverage, Medigap policy. So it wasn't an Advantage. It was a traditional Medicare. And then you have the Medigap policy, and it costs $100 and some bucks, $102 or something like that. And anybody could get it because it was guaranteed. It was mandated as part of the no fault or not no fault, but with the requirements of, because Blue Cross was sort of the default insurance company in Michigan. They lobbied, and it was about the same time that they changed the insurance law, Medicare law changed quite a bit in Michigan at the same time, but they got rid of that requirement. Here's the problem with it. Now they can raise the price. Fewer and fewer people are going to do it because the price is raised. Less people doing it mean the price goes up even more. The whole point of insurance is you got to have a whole bunch of people participate so you can keep the prices down. If there's less people in that legacy plan, so there's probably no one starting the legacy plan now. It still exists for people that were already on it, but the price has gone way up and people are moving off of it because there's fewer and fewer people participating in that plan, and it's no longer mandated by the state. So as soon as that went away, it was a very attractive option to move over to this Medicare Advantage option. Those are things that are relevant to anybody that works with seniors, okay?
What are recovery audit contractors in Michigan, and how are they related to skilled nursing facility Medicare coverage?
I promised you a payoff, right? This is the payoff. I would suspect many don't know about recovery audit contractors. Some of you probably do, but what is a recovery audit contractor, and particularly how do they get paid? So we're going to get there, but this is really important because what happens with recovery audit contractors is they're a third-party entity. So I'm going to give you, I'll kind of go through the specifics there, but here's kind of how it works. If you go in for in-house, inpatient, and you are staying at a skilled care facility for rehab for physical therapy, and you're there for 20 days or 30 days or 100 days, then the RAC, the recovery audit contractor, will, they can come in like 6 weeks later after you left. And then they look at the facility's records. And they then say whether or not they think that you should have gotten that many days, that you should have gotten that coverage. Okay. And so it's after the fact. Now here's one of the problems. The patient, and you'd think this is a good thing, but we'll see. The patient can't get billed. So if recovery audit contractor comes in and says you shouldn't have gotten 30 days, you should have only gotten 10 days. The facility can't charge the patient for that extra 20 days. Okay, that's the water's under the bridge. They can't go back and charge you for it. So the facility eats that cost. So they authorized 30 days. They thought that they had documented properly to authorize 30 days. Somebody else comes in, this third party comes in 6 weeks later and says, no, you should have only authorized 10 days. And the facility eats that cost of the extra 20 days. Do you see how that might make them a little gun shy? A little less likely to give 100 days? Okay, it gets worse. So overpayments, of course, that they have to pay back. And so in Michigan, it's under Region 4, it's currently assigned to this company called Performant Recovery, Inc. And they can review both Part A, hospital and skilled nursing, and Part B claims.
What does recovery audit contractors consider in determining coverage?
So they're supposed to consider medical necessity. They're supposed to consider whether it's reasonable and necessary. They're supposed to consider the GMO compliance issue. And they're the key, the last one's important, coding and documentation. So we're gonna, in a second, I'm gonna dive deep into that coding and documentation, because that's the key. If you wanna make sure your employer gets paid, we gotta make sure it's coded properly. They can deny just because we coded it wrong. You know, everything else, it's clearly the person was entitled to the benefits, but if it's not coded right, then we could end up having the recovery audit contracted. Why am I so adamant about this? It goes to the next question. Actually, no, one more question first.
What happens if a skilled nursing facility is audited?
So they can either repay it, they can accept the findings and repay it, they can appeal it. They don't have to repay it until all the appeals are done. The tips for ensuring that they're less likely to get an audit or the audit will be successful, or, result in a repayment, is ensure comprehensive documentation of all skilled services, verify the coverage and criteria for each claim, maintain policies associated with GMO compliance. That's where it says that you shouldn't lose coverage just because you plateaued, and track your additional documentation requests and meet deadlines. But this is the key.
How does the RAC get paid?
This is it. Remember, anybody old enough to remember, I was not old enough, but I've seen this movie a bunch of times, Watergate, and the movie with Robert Redford and all that. And the big thing in the movie was follow the money. I think that's really good advice. If you ever want to figure out anything, follow the money. And so how does the recovery audit contractors get paid? They only get paid if they deny coverage. They literally only get paid if they get denied coverage. They get a commission for denying coverage. Anywhere from 9% to 12.5% of the denied benefit. And that's the only way that RAC, so RAC is that, I named the company that does it for Michigan. They don't get paid as a company unless they deny coverage. Seems like not the best system in the world if we want people to get the rehab that they need, for a massive stroke or something like that.
How is the patient evaluated for continued rehab?
Okay, so I'm going to spend just a couple minutes on this. I know this is kind of gets into some in-depth stuff, but the idea is if we're going to have, we know now what the incentives are and following the money and the recovery audit contractors. How do we avoid that? How do we get more days? How do we make sure our employers get paid? And the answer is one of the big answers is these three forms. The resident assessment instrument. This is a standardized clinical assessment tool. Captures health status, ADLs, therapy. It's used to justify the skilled care extension when services are still needed. Very, very important document. So if, this is something that, we all have forms. You don't know how many forms we have in our office. My team sometimes gets really frustrated by the level of process that we've created to make sure that we have consistency of service. And so I understand people hate filling out the forms, but this is such an important form that we do it thoroughly. Same thing with the minimum data set. A minimum data set includes the care area assessments, utilization guides, guides to planning and medical necessity documentation, and it supports extended coverage. And then we used to have, I mentioned this RUGs earlier. It's no longer RUGs. We got rid of RUGs. That was the resource utilization group. It's now patient-driven payment model, and it is payment based on clinical needs. This is where the coding is critical, okay? So we have to make sure the coding is critical under the patient-driven payment model. So those are some of the key documents to make it more likely that we're not going to get audited or lose an audit, and that we potentially can get more days and extensions for the folks in rehab. Coverage depends on medical necessity. We talked about that. Key takeaways, and then we're going to move on to Medicare. So I'm doing pretty good on time. We're not doing bad. Okay. Key takeaways, the MDS and the RAI, that's what those forms we just went over, are what is used to justify extended stay care. The PDPM guide is a guide to payment and non-coverage, and accurate documentation is essential to get that Medicare coverage.
Under traditional Medicare, what is the coinsurance responsibility during Medicare coverage?
We'll see. I think there might be, oh no, we fixed it. So there's a typo if you're looking at the online version of this, that I had a lower number.
204.
Yeah, so the real number is, so this is traditional, and we'll talk about what if you've got Advantage, but traditional, first 20 days are covered on 100% by Medicare, days 21 through 100, it's a 209.50. That number is wrong on the online version of this, and then after 100 days, for the generally, it's private pay. What about if you have Medicare Advantage? Who knows? It could be that you start paying a copay or coinsurance from day one. It really depends on the coverage you have through, whatever your insurance company is. All right, now we switch to Medicare.
My turn.
Right. Okay, this is cool. Amy, tell us about the new numbers.
So for the first time in 50 years, we got an increase in the individual resource allowance. We get to keep $9,660 versus $2,000. And that changed in February. There was rumor about it for a while, and now we've got it. So that's awesome.
This
we
is
are
going to help a
super
lot of
excited.
Yeah.
I can't tell you how many times in the past I had clients with a $2,500 life insurance policy. And now we can keep that $2,500 policy, not worry about getting it cashed in before we can apply for Medicaid. It's phenomenal. But this does not apply to SSI.
So when it comes to Medicaid in particular, this is really important because often so many people would have these little miscellaneous things, or they had a second car, but the second car is worth, $600 or whatever. Or we're going to use that $600 as part of the 2,000. This, I know it doesn't seem like that big of a difference between 2009. It makes a huge difference for so many people so that they don't have to. And part of it is, when can you file for Medicaid? One of the things is sometimes it's really important that we try to get the Medicaid application filed quickly, right? Well, do we have to sell a car first? Do we have to, how do we get rid of a life insurance? Well, the life insurance return our phone call, And so now just having that little more buffer, I think that's going to make a huge difference for a lot of people.
It truly does. Medicaid planning can be done for My Choice Waiver and PACE.
This is something that I think you probably all know this, that you can work with us to protect assets and qualify for My Choice Waiver and PACE. A lot of lawyers, so I do, you probably know, I do a lot of teaching, Kelly does teaching too, of other lawyers through the Institute for Continuing Legal Education or through the State Bar Association. And this is a question I get from other lawyers all the time. Can you do asset protection? Can you protect assets and help people qualify if it's not traditional nursing home Medicaid? but they want to stay in their home or they want PACE or waiver? And the answer is absolutely yes, but it is slightly more complicated. And so a lot of lawyers ask that question. And if you ever had that question, the answer is yes, we can still help people qualify and get them eligible.
So for my choice waiver, it can help pay for care in the home, in an independent living, and some assisted livings. So some assisted livings are contracted with waiver. There are more coming. I see more every day. They can transition from waiver into a long-term care facility, Medicaid in a skilled nursing facility. They can also transition from a skilled nursing facility back home. So if they're in a rehab situation, but they're well enough that they can go home, but they still need a little bit of extra help. So they need that extra care. They qualify for those services and their income qualifies. We'll talk about that in a minute, but they can go back home and we can get them qualified while they're still in the facility. And it eliminates a wait list if there is one.
Well, it does. Eliminate might be strong.
Sure.
It makes it less likely there's going to be a wait list, or if there is, it'll be shorter. And Amy, it was just a misspoke. Amy knows that better than I do. So the key on this that I like to talk about, this is one of the main strategies that we use actually. So we're not just dealing with the legal financial, right? We're dealing with emotions. We're dealing with families. We're dealing with families that maybe just hit this health crisis and haven't wrapped their head around what's going on yet and are in a little bit of denial saying, oh, mom's coming home no matter what. Great. Because if I tell somebody, I don't really see mom coming home, even if I can see the writing on the wall, some families aren't ready for that. The mom might not be ready for that, to hear that. Great. So let's start off with the idea that we can come home and be on one of these PACE or waiver programs, but it's going to be a lot easier to get into that program and not have a waiting list and get Medicaid approved faster if we get Medicaid approved while you stay at the skilled care for a month or two, and then we transition you home. Now that, of course, is the goal. Great, if that's the truth. But sometimes it's a part of it is the family has to get their head wrapped around this whole concept. And this, this all started 2 weeks ago. This all started a month ago, and they haven't got their head wrapped around, okay, life is changing now, and it probably will never go back to the way it was before. And so sometimes this is a really good way for families to, if we just say, I don't really see you coming home, family's not going to hear that. And so sometimes we have to work with them to say, okay, absolutely, we're going to work to get home. And we definitely want mom to work hard on that. So that's an incentive to talk to mom to say, keep up with the therapy, keep up with your exercise. We got to get you stronger. And so it's good all the way around.
My choice waiver eligibility. So they must meet the Michigan Medicaid level of care determination, same as a skilled nursing facility. So those doors. The financial eligibility is the same as a long-term care nursing facility, and they have an income limit. So it's $2,901 for 2025, and that number does change every year. Waitlist priority categories. So these are the categories that the waitlist gives a priority to. But the one that we want to focus on, or that we mostly focus on really, is the imminent risk assessment. So, or is that individual in risk of having to go to a skilled nursing facility if they don't get any care in the home, any additional services?
So this is, you call up for waiver and they say, hey, there's a wait list. I think in 1B, age-wise. Lately they usually say a year waiting list, whether it's going to be a whole year or not. But okay, well, how do we deal with that? This is from home. We're not in the rehab right now. We're already home and we want to get on waiver. Well, we can try to move up that list by making an argument that they have imminent risk of going to the nursing home if we don't move up that list. So that's an option that we do.
So then obviously we talked about PACE. So Program of All-Inclusive Care for the Elderly. PACE is well known and trusted model of long-term care nationwide. It started over 50 years ago, and there's over 270 PACE sites. So in 30 states. So it's growing, it's getting bigger. And I just recently found out that our Ascension PACE facility was actually moving to a larger facility.
I have it's a bittersweet thought that there our pace in 104 Genesis is moving, because I really like the place that they're at. It was right next to the Flint Farmers Market. It's a beautiful building. I like everything about it, and I get it. They want to expand and offer the services to more people. So awesome! I'm glad that they're doing that, but I just really like the building that they're in. So yeah.
So the model of care, personalized wraparound care. So PACE offers basically everything under one roof. So you get transportation to the facility or transportation back home. They have doctors. So that's one of the downfalls that people find. You have to use the PACE doctors. You can't use your own doctors and use PACE. So that is a downfall that people find, that because they like their doctors. But a lot of times we find patients that are okay with it. So that is one of the things. But they have physical therapy. They have recreation therapy, dietitians. Every person that you might need to have help you is in there to be able to give you a personalized plan of care. So nursing home, skilled nursing facility, traditional Medicaid.
So why do we make this distinction between what I I call it traditional Medicaid. It could be considered MA Medicaid, whatever. But the bottom line is that it is different in planning for when we're doing a nursing home type Medicaid versus PACE or waiver. First of all, with PACE or waiver, there's two agencies, right? There's the Department of Health and Human Services and then the PACE agency. There's the Department of Health and Human Services and then the waiver agency. With the nursing home, we don't really have to, we just have to deal with the Department of Health and Human Services. The nursing home is going to obviously be cooperative, but it's not like a separate agency that we have to sort of coordinate everything with. So frankly, it's a little bit easier to get Medicaid in a traditional, in what I would call traditional or nursing home. We do all of the above, and we do whatever is appropriate for our client. But that's why we make the distinction, is because the planning or the eligibility is different depending on which program we're using.
So Medicaid asset rules. There are default rules. So quickly, you can have a house up to $730,000 value for 2025. But the state can take it after that person passes away. One car, one prepaid funeral, a life insurance policy with a value of $1,500 or less, household goods, $2 a day, $60 a month. That's it. That hasn't changed. And half of the assets for a married couple up to $157,920. So default, those are default. With proper legal help for a single person, we can save the default plus approximately half of the assets. Well, for a married couple, we can save the default with one spouse in the facility, not both. We can save the default and all of their assets. We can protect everything.
So let's talk a little bit about that. First of all, I just want to repeat it, because that sounds, for those that aren't familiar with this, that might sound a bit shocking, because you've been told you got to spend down all your assets before you can get Medicaid. All right. So let me give you a quick example. Everybody in my office is so tired of this story because I've told it so many times, but I think it's really poignant and important to understand. And so I use my own parents as the example. So my dad had open heart surgery. Okay. He was almost 90 when he had it. He was a very strong man. Most people, they wouldn't even do open heart surgery at his age, but he was just very strong and healthy. And so they did open heart surgery. There was about a year leading up to it, the surgery, the rehab, and then about a year afterwards. I kept track of the bills. My dad retired from GM, so he had Blue Cross and Medicare, right? Traditional Medicare. And how much do you think that cost as far as got paid out on Dad's behalf? It was over $500,000 over that 2-year period of time. How much did Dad pay out of pocket? Almost nothing. Okay. And I joke, and it's a half joke, half true. Dad got lucky enough to have heart disease because it was one of the things covered by Blue Cross and Medicare. And so he was not expected to become impoverished as a result of needing a valve replacement. Okay. And so my mom at the very same time had Alzheimer's disease. Okay. Her care needs, she still had care needs, right? Especially since Dad was going through this heart issue. And so same 2-year period, her needs were about a third of the cost of what it cost to do, the heart stuff. And so how much did Blue Cross pay towards that? Zero. How much Medicare pay towards that? Zero. Now, fortunately, there is other programs. You're going to hear about veterans benefits in a few minutes from our esteemed Liz is going to be our resident guru on veterans benefits. And so, and Medicaid. And so many people think about Medicaid and they're like, oh, I say Medicaid and they're like, oh, that's for poor people. And then I say, what about Medicare? Oh, that's for everybody. I paid for that. You also paid for Medicaid. Every check that you ever got, they took money out for both. And they give us, obviously we have to pay a premium every month, but they give for Part B, they give us Medicare when we turn 65 or under other circumstances. Medicaid is also an insurance program. And it's an insurance program that's more than just for folks that are indigent, okay? In fact, since 2000, whatever it was, when the Affordable Care Act got passed, it's for anybody under 65 who doesn't have sufficient income. They could have $1 million in the bank and still qualify for Medicaid because they don't have sufficient income if they're under age 65. That goes away when you turn 65. They figure people under age, I don't know if they did this on purpose, but probably they figured people under 65 aren't going to spend that much time in the hospital. People over 65 might. And so whole different rules for when you turn over 65. But the idea is Medicaid is an insurance program, and they have programs for people that can't afford medical care. They have programs for people that have certain disabilities. They have programs for pregnant women. They have programs for people over age 65 that need continuing long-term care. It's just they make us jump through more hoops to qualify for those. And that's what we do, is we help people jump through those hoops without having to become impoverished. So when Amy says for a single person, we can protect typically at least 50% of their assets plus their house, often it's more than that. There's many cases where we might be able to protect more than 50%. For a married couple, we can often protect everything in favor of the healthy, or what they call the community spouse. Now, I'm going to put a caveat on that. Somebody comes in and they have $3 million. Am I going to qualify them for Medicaid? No, I'm probably not. Mostly because they can afford, the fancy assisted living that costs $10,000 or $12,000 a month. Why wouldn't, if they can afford it, why not spend the money, And so, but we have lots of folks that have $300,000 or $400,000, and I don't want to impoverish the wife because the husband has Alzheimer's. I don't want her to end up in a situation where she doesn't have resources when she needs it because we spend everything on the husband. And then a lot of the folks that we help don't have very much money at all. They have under $100,000. They have $60,000. A good percentage of the people we help have very little. And that's even more important to preserve the little that they have. Okay. So we are able to preserve assets and qualify for people for any of these 3 Medicaid programs we just talked about.
So realistically, many families fail to plan ahead. We can still help. Even if it's last minute, mom's in the facility, dad's in the facility, whatever's going on, we can still help, even at the last minute.
And so that's really important that, people do think you have to do it 5 years in advance. That's great. I love it when people plan ahead. There's just not enough people that plan ahead. And so a lot of what we can do is what we call crisis planning, meaning that we really can't even do the plan until we know we're ready to file for veterans benefits or Medicaid.
So with Medicaid, there is a gifting penalty. I'm sure everyone in the room has heard of a gifting penalty. If you gift in the last 5 years, you've given away anything, a car, given your daughter money to pay for her wedding, any of that will cause a penalty. So for every $11,842, and that's 2025 number, you're penalized 1 month in the facility. So that's a lot. That's a lot. 1 month in the facility. The 1 month in the facility could cost $15,000. And you're being penalized for giving away $11,842.
So let's talk about this for just a second, this gifting penalty. So a lot of people, when they hear gifting penalty, they think it's a dollar penalty. It's a time penalty is what it is. And so I don't know if you have any hockey fans, but it kind of, somebody beats somebody up in hockey, they go into the penalty box for 2 minutes or whatever. So it's a time penalty like that. I used to use this with my kids when they were littler, where they'd have to sit in timeout. And we had this clock, and it would tick away. The red would disappear when they know that they could be done with their timeout. They broke the clock pretty quickly after we bought the clock. But anyway, the idea here is that it's when does the clock start? That's where the difficulty comes in, because the clock can't start for that penalty until the person's in the nursing home, has $2,000 left to their name, not 2,000.
9660.
9660 left to their name, and is otherwise eligible for Medicaid. So we can't start the clock if they're at home and not on waiver or PACE. So if it's a waiver, PACE, or nursing home, we can start the clock, and we're private paying for that period of time. But if they're not getting any of those services, the clock doesn't start. All right, and they look back 5 years to see if there's any of these gifts. And so the clock doesn't start until you're down to less than $10,000. And how do you pay a $15,000, fee every month, or $14,000 fee every month, whatever it happens to be, if you only have $9,000 to your name? So here's the answer to that question. Never get to that position. So we're often told, oh, you'll get Medicaid as soon as you spend down all your assets. I don't know how many times families came in and said, we'll just get Medicaid once we lost all our assets. That's the worst scenario. You don't want to be in that situation where you've spent down all your assets. Let's make sure we get Medicaid set up before you spent down all your assets, for a bunch of reasons. But the other thing is they assume that every place takes Medicaid. So they're in the nice assisted living that it doesn't take any form of Medicaid. And they're like, well, it doesn't matter when we run out of money, they'll just have to take Medicaid. No, they don't. That's not the way it works, right? And so this is very important, this gifting penalty. So I call it the G word. We never encourage people to give money away in advance. Amy and I will help them do it strategically if it's appropriate when the time comes in a crisis setting, but never in advance, because there's no way to calculate the appropriate amount and be strategic about it. People say, oh, I'm just going to give each of my kids $20,000. Bad idea. Don't do it. If you need Medicaid, if you need nursing home in the next 5 years after that, we got a big problem.
Yeah, definitely. So the Community Spouse Resource Allowance. So we have an IAA date, Initial Asset Assessment Date. That is the day that the patient needing Medicaid this is for a married couple also. Yeah. So goes into a hospital or skilled nursing facility for a continuous period of 30 days or more. So it can be hospital for 10 days and then to the facility for 20, and then maybe they go home on the 31st day. That first day of their hospital stay triggers this IAA date. And that's where we take the accountable resources into account and what we get to keep for a married couple. So Medicaid must. They have to meet the level of care determination to qualify. asset and income requirements and be otherwise eligible. So if not receiving Medicaid type of services, so they haven't applied, but they cannot be in the home. They can't go back home on the 31st day and then apply for Medicaid to get into a skilled nursing facility. You cannot be at home unless you're on waiver or pay services, right? To get skilled nursing facility Medicaid. It doesn't work. They have to be in a facility.
So sometimes we're told, oh, well, we'll be happy to take this patient as long as they're already approved for Medicaid. And the answer is, unless they're in the hospital, which you can apply for Medicaid while you're in the hospital, or they can get waiver or PACE. You can switch from waiver and PACE to traditional Medicaid. That's fine. But some people can't get waiver or PACE because there's that income limit that we keep talking about. Okay. And so sometimes it's literally impossible for us to get Medicaid approved before we move into the facility.
So income requirements for a skilled nursing facility, income must be less than the cost of the nursing home. I mean, for most of us, that's probably pretty easy, right? The patient pay amount is income minus $60, that $2 a day we talked about. So they get that personal needs allowance, $60 a day. And they can keep their private health insurance. So especially for anyone that has vision problems, any of those types of things, like you want that additional insurance to be able to cover, Medicaid covers the cheapest things that are probably going to fall apart tomorrow. But your extra insurance might cover more. So we want you to keep that.
Glasses,
no designer glasses.
Okay.
No. Go to the other side of the wall where there's, nothing you want. So it's just nice to have that additional insurance, and they subtract it from your patient pay amount.
So it's particularly for single people because it's basically, if you don't keep your insurance, then if you're unskilled, your patient pay will go up. So you might as well keep your insurance, and because you can, and it doesn't cost you anything.
Yep,
out of pocket.
absolutely. So for my choice waiver and PACE, the 2025, that's a typo. Monthly income must be $2,901 or less. So skilled nursing does not have an income limit other than less than the cost of the nursing facility.
So families get confused about this all the time. I have families come in all the time saying, I did my research on Google and I know that mom can't get Medicaid because her income is $2,901.37. And that's unfortunately true if you wanted a waiver or PACE. It doesn't mean you can't get nursing home Medicaid. We're going to talk about this later in Hot Topics about our continuing efforts to try to get that changed, because it really is unfair to have this income limit. But
yeah, very much so. And there's no patient pay amount for PACE or waiver unless they're in a facility like an assisted living, so room and board for PACE. So their assets must be below $9,660 in total assets. So there's a list of some of the things that we see for the included assets. One thing I wanted to point out is life insurance policies. A lot of clients come in and say, well, I have a life insurance policy, but it's for my funeral. It doesn't count. It does count. And especially if there's a cash value on it. And most of the time, there is a cash value of it. And that cash value is a countable asset. So we need to make sure that we are looking out for those things. That's one of the biggest things that I find that people discount and think that doesn't apply to them. Jointly owned assets, that's another problem that we come into. Just yesterday, we had a client's son say, oh, by the way, mom's on my account and my brother's account. I said, get him off. Get her off right now. So there are complications to that. I know you put mom on there to help you out. You're single, you need someone to help you in case you need it, but yeah. And then exempt assets, we talked about life insurance, one vehicle, prepaid funeral and burial, and a house.
The key on this is that all these numbers that we've been going through, that's on that laminate that you have. And if you need more laminates for other people in your organization or others, feel free, and we will be happy to get those to you.
So after someone dies that is receiving Medicaid, their family gets an estate recovery letter from the state of Michigan.
Everybody, regardless. So if you had $0 when you went in, you're still going to get what I call the hate mail from the state. And it does start off with, we're sorry for your loss, but we're going to come after you hard. And it doesn't really say that, but it really kind of implies that. And none of that's true. If you've ever been subject to a debt collection letter by a debt collection company, it has the feel and vibe of a debt collection letter. And none of it's true. They're not going to come after you. They're probably not going to open up a probate. And the answer is, for most of our clients at least, ignore the letter. We used to respond to them, and then they just send us more letters like debt collectors do. So the answer is ignore the letter. But everybody's going to get it. And so now some people might be subject to a state recovery, but if you didn't have any assets that were subject to a state recovery, the answer is ignore the letter.
Right. They're hoping there's a house. They're hoping there's an unprotected house and they can recoup some of their money.
But if you're our client, we're never going to leave the house unprotected.
No. Consult with an experienced elder law attorney. And, Bob talked about that earlier. An elder law attorney. Make sure we're working with a family right now that used an attorney that said they would help them do all these things to get Medicaid, and months later, they're still waiting and nothing's been done. So you've got to make sure that it's an experienced elder law attorney.
I don't know if you mentioned this about the state recovery only applies to probate assets.
Yes, right. Yes.
Okay.
Only probate assets.
Yeah.
So again, they're hoping you have a house that's unprotected. So if you have to open a probate, those assets could be or will be subject to a state recovery. So if you have a bank account that doesn't have a beneficiary, or a home that's not protected, or extra homes that are not protected, that's what they're looking for. And they will open a probate on your behalf.
So I had this fun Taylor Swift and Travis Kelce example, but if you want to look through it later, it's kind of fun. And I go through some examples of what we would do in that situation if one of them needed care. So you can read that on your own. We've been saying this over and over again. This is, we always say you're always part of our circle of care. This is something that if you have something come up, now we can't offer this to the general public, right? We can't offer access to us to everybody without paying us. Otherwise, we wouldn't be able to stay in business. But if you're another professional in the long-term care field, you work in long-term care, and something comes up on one of these things. Now, sometimes if it's a specific thing, we might have to refer you back to your corporate counsel. Okay, if you say, hey, we've got this person and they're not paying our bill. Okay, that's a corporate counsel thing, whatever. But if you have a question and you just have to say, I'm not sure how this works with regard to the Medicare benefit, is there something they can do with regard to the Medicaid benefit, any of the things that we talk about, and you just have a quick question, you can reach out to us and we'll do our best to get you an answer. We're going to give you some advice about the easiest way to reach out to us at the end of the day. We call it our easy button for if you have questions, if you have referrals for us, easy way to kind of cut through our intake process and just get right to the source, or right to the right people. So we offer that to all of you as part of our circle of care. You need some clarification on something, we're happy to do that. And so you can reach out by email or phone or whatever, but we're going to talk a little bit about that later. So thank you. I think we're getting ready for the next presentation, right?
So we are going to go ahead and welcome to the stage our timekeeper, Liz Hiltz. Liz, yes, clap it up for Liz. She deserves a hand clap. She's one of the hardest girls here at boot camp every year. But we're going to go ahead and have Liz come to the stage. Liz is a certified elder care coordinator, certified dementia planner, and she works a lot with our clients who are getting veterans benefits. So she is like living this every day. And she's really a great knowledgeable person on the topic. And then we also have a special guest. You won't find him on the official agenda, but we do have attorney Nick who's going to come to the stage with Liz. And let's go ahead and just welcome them now and get right into it. Come on up, Nick and Liz.
Thank you.
You're welcome. Yes.
Shall we test? Hello, can you hear me? Am I being too loud? Quiet? Perfect. Okay, cool. Well, thank you all for being here today with us. We have our master expert in VA here to educate us all a little bit about past promises and present solutions. So Liz, let's talk about the importance of veteran benefits for a moment.
Here's where I'm going to get excited, because really this is something I really am passionate about. So if I get excited, just bear with me, okay? Get excited with me. Okay, it's not too long. Okay, so every veterans benefit that we're going to discuss today is more than a line in a regulation or a checkbox on a form. It's a promise, right? It's a promise that we made to our veterans when they put their lives on hold, when they put their families through sacrifice, so that we could live with freedom and peace and security. Long-term care benefits, kind of like Amy said, long-term care benefits aren't just handouts, they're earned. There's a chair there. It's about dignity and aging and support and vulnerability, ensuring that no veteran's going to face their final years alone or without care. So when we talk about aid and attendance benefits and housebound allowances, or state veterans homes, we're not just talking about policy. We're talking about helping a father who served in Korea stay in the house that he built for his family. We're talking about supporting a widow who was with her husband during deployments and diagnosis. We're talking about honoring their sacrifice with our support. As we go forward today, I invite you to keep one thing in mind. We're not just navigating benefits. We're carrying that torch of gratitude back to the past, grounded in the present, and lighting the way for the future.
Whew, what a statement.
Whew.
Unreal. Well, thank you for that introduction. Liz, which veteran benefits will we be talking about today?
Yes, so there are a ton of veteran benefits. Bob won't let me stay up here for 3 hours and go over all of them with you. So we're not going to talk about like burial benefits, GI benefits, vocational rehab, none of those things, but those are great benefits that do exist. What we're going to talk about is your service-connected benefits. This is your disability compensation, is sometimes what that's referred to. Healthcare services, and your aid and attendance and homebound benefits.
Can you tell us about what some of the myths about long-term care veterans benefits are?
Yeah, so no two veterans have the same situation, right? So this is why sometimes a veteran will say, oh, I don't qualify for this, I can't qualify for that, because their buddy didn't qualify for that, right? So some of those myths there, with Biff's guide to VA benefits, right? We don't want to fall for that one. So the VA will pay for all nursing homes. That's false. Not all veterans will qualify for nursing home care through the VA. They can't go to just any nursing home. So that's false. That you can't have too many assets. Some VA programs don't have an asset limit at all. Sort of like there's a bunch of Medicaid programs. They all have different qualifications. VA is the same way. All those programs have different qualifications. And that you have to be injured in service. Again, there are so many veterans programs that there are benefits for people who were not injured in service as well.
What do we need to know about VA service-connected disability?
So like I said, that's not always called service-connected disability. Disability compensation is how a lot of people will refer to it, or a veteran will probably say, I'm getting my disability from VA. So we're going to talk about who qualifies for those benefits, what long-term care services are available for them with those benefits, and why they matter more than ever today.
How are service-connected disability benefits determined?
So they're determined from an injury or an illness that happened or was aggravated, was made worse during the veteran's service. So the VA will do, and we'll get into this more in a minute, is they'll rate it from 0 to 100%. And the higher rating is going to be the more care, but it's also going to be the more cash in the veteran's pocket. So for our seniors, that can make a huge difference. A 10% rating is about $126 a month the veteran will receive, whereas 100% is going to be closer to $4,000. So that makes a big difference for people every month to get that extra income.
Okay, let's shift gears a little bit. What long-term care benefits are available for service-connected disabilities?
Yep, so there is some VA nursing home care that can be available. There are 3 state veterans homes in Michigan right now, Grand Rapids, Chesterfield, and Marquette. So it's a little bit spaced out, but still some great homes. VA contracted private nursing homes, and then those home-based and community services that can be available too.
Great. And who qualifies for VA long-term care?
So a veteran who has a disability rating or a service-connected rating over 70%, 70% or higher, is going to qualify for long-term care through the VA. Or if the veteran is considered catastrophically disabled, they can qualify that way as well.
Okay. What are the home and community-based services that are available?
So they could potentially get a homemaker or a home health aide. It's probably the better way to say that. Some respite care, adult day health care, and even some skilled home care can be available as well.
How do we apply for these service-connected disability benefits?
Okay, so there's a form. You get the veteran to fill out the form, fill it out for them. You can apply online, by mail, or in person. I would probably only apply in person. My husband and I we're not seniors. I like to think we're technology savvy. Apparently we're not. We just to get logged into the VA website took us 3 days just to get logged in. They use this, I'm not going to get on the whole soapbox. You have to take a virtual selfie of the veteran. So imagine doing that with a senior, and they have to move their head the right way. It's a whole thing. 3 days. So I would do it in person. And the way you're going to want to do that is working with a veteran service officer, a VSO, or with an accredited VA attorney.
All right. What about the VA disability rating? What is it?
So the VA will take each of the veterans' injuries and illnesses and give them each a rating of 10%, 20%, 10, 10, 10, whichever they do, based on how severe the VA feels that injury or that illness is.
All right. And how do the service-connected benefits help seniors?
So 2 ways. So the financial compensation is really huge. Like I said, if you're a veteran who's just getting Social Security, and now you're getting an additional $4,000 a month from the VA, that's huge. But it also helps unlock other benefits within the VA. It can unlock the VA health system for them. It can help them qualify for long-term care and rehab. So it's the first step into getting some of those other benefits to be available to them.
And what is VA math?
Okay, so the VA doesn't really understand math, I think. They do their own math. So we all feel like Doc Brown here. You think of this. So my husband gave me permission to share this with you all. He has 8 service-connected disabilities or injuries, illness, whichever you want to call them. He's rated at 10% for each of them. So 8 times 10, 80% disabled, right? No, 50% disabled. So I don't know. I thought I was good at math. I'm better than the VA. So
VA math, not mathing.
the math is not mathing.
Math's not mathing.
The math ain't mathing. Okay. So Agent Orange is if you're meeting with a veteran, you're speaking with a veteran, they mentioned they were in Vietnam or they had some kind of Agent Orange exposure, that's like all the red flags, right? The VA, and we'll get into this more in a minute, there has so many presumptive illnesses related to Agent Orange. They're probably are going to get some kind of disability compensation if they were exposed to Agent Orange.
What is a presumptive service connection?
Okay, so a presumptive service connection, when a veteran goes in and meets with the VA, they have to be evaluated to prove that that injury or the illness happened during their time of service. For a presumptive illness, all they have to do is prove that they were serving during that time. They don't have to prove that it was, the VA just assumes that your injury is because of your time in service, your illness is because of your time in service. So for a lot of the people we're seeing now, especially your Agent Orange guys, your Vietnam guys, if they were in Vietnam, Laos, or Cambodia, or if they were in the DMZ, which I learned this week is the demilitarized zone. So now you all have a little extra military lingo knowledge. If they were in those areas, then they're presumed to have been exposed to Agent Orange. This is also kind of interesting, the brown water Navy. So if they were in Vietnam, they're in the lakes and the rivers and the water in the country, actually in Vietnam, they are presumed to have been exposed. But also if they're blue water Navy, so if they were in the ocean, maybe they never actually stepped foot onto land, within 12.8 nautical miles, that's a real thing, it's 13 regular miles, in case you were wondering, they also have that presumptive eligibility.
And are there presumptive conditions from Agent Orange that we should highlight?
There are tons. So if your veteran that you're speaking with has any of these, you need to get them with the VA right away. Type 2 diabetes, ischemic heart disease, Parkinson's disease, this whole list of cancers, blood, prostate, lung, larynx, trachea, this goes on and on.
Well, we have a second there. I wanted to mention that my father-in-law got benefits through this, and it wasn't one of the cancers that's listed there. Mm-hmm. And so he got denied, but we set him up with an attorney that appeals those types of denials, and he got approved. And it wasn't one of the listed cancers, but so even if there's a cancer and it's not on that list, I'd still apply.
Absolutely. Yep. And this list, the font is very small, but this is still just a list of even more conditions that are presumptive. And it goes on and on.
Liz, is there any recent legislation to share with us about service-connected benefits to make us a little bit more aware of stuff out there?
Yeah, so the PACT Act was signed in August of 2022. PACT Act is actually kind of really cool for veterans. It expands your healthcare benefits for your toxic exposed veterans. So this is not just your Vietnam guys. Any of your post 9/11, veterans who are exposed to those burn pits. I don't know if you hear about that sometimes. This opens up VA healthcare to the burn pit veterans and the Agent Orange Vietnam guys. They just automatically get access to VA healthcare, which is huge. We'll talk about that in a minute. And it also put on like 20 more presumptive illnesses, and they keep building onto that list too. So there are more and more presumptive illnesses being added because of PACT Act.
Who is impacted by the PACT Act?
So like I just said a second ago, your post 9/11 veterans, your Vietnam era guys, and your Gulf War guys, certain survivors and dependents, what they did, so this, I'm gonna get a little excited again, with the burn pit stuff. So Agent Orange, we're seeing a lot of that now as those Vietnam veterans are aging. But a lot of our post 9/11 veterans are still younger. They've not aged yet. So what they've done for those guys is they've made these burn pit registries as a part of PACT Act. So as they start to get ill and older, they're tracking those illnesses so that they can better add presumptive injuries and illnesses as those guys age. So it is helpful. It's sad we didn't have that for, when Agent Orange was first happening, but we're making improvements, so that's good.
What are some of the new key conditions now covered because of the PACT Act?
So all your respiratory cancers, brain cancer, throat, neck, it's like any cancer from the collarbone up is covered on the PACT Act now. A lot of sort of respiratory illnesses, you made me think of that. Yeah, thank you. Your chronic bronchitis, your COPD, emphysema, those are all presumptive now.
Any benefits beyond just compensation under the PACT Act?
Yep. So the big one we're going to talk about in just a minute is it unlocks that VA healthcare enrollment. That's a huge one. It can unlock some long-term care benefits, certain spousal and survivor benefits, and then also some home and community-based services as well.
Liz, do you got any tips to give to families and veterans?
I do. So reassess, have those veterans and those families just reassess those service records since they have added more locations. Reapply if you were previously denied, kind of like Bob said with his father-in-law. We had a neighbor, my husband and I, nicest guy, was kind of turned off by the VA when he first left the service. He went in, they denied all of his illnesses. He was talking to my husband one day. We convinced him to go back to the VA several years later. He ended up getting enough money to pay off his mortgage as a senior person, as a senior citizen. So that was really, really cool for them. And then he was able to continue to get that benefit monthly after that. So reapply, even if you've been denied. And then you want to coordinate that with your Medicaid planning too, kind of weigh your options, what's going to be the better benefit for you. And then keep watching for new presumptive conditions because they are adding those all the time.
And do you have any final thoughts on the PACT Act to share with us?
I do. So I'm going to say it again. Reapply for the PACT Act. Now that the PACT Act is here, we just want to help those veterans get one, that compensation every month, and two, unlock those benefits, that healthcare benefit especially. And like it says here, we want to really honor that full cost of service. These veterans were injured and hurt serving our country, and if we can get them on these benefits that are designed to help them, then they should be able to get on these benefits.
Okay, let's move forward to VA healthcare services. Can you explain to us a little bit what are VA healthcare services?
Yeah, so VA healthcare services, like I said, is probably the most overlooked benefit that veterans have. It can provide some low cost or even no cost hospitalizations, prescriptions, long-term care, all their primary care can all be covered by the VA.
And who qualifies for healthcare services?
So there are several ways to qualify. Like we said, with PACT Act, anybody who served Vietnam post 9/11, they're all going to qualify automatically for VA healthcare, which is really cool. Otherwise, they have to have served on active duty. They have to have a discharge that's other than dishonorable. So a general discharge or a medical discharge or obviously an honorable discharge would qualify. A veteran with a service-connected disability is going to qualify. If they don't qualify one of those ways, there are some income and financial status ways that they can qualify. If they have a lower income, things like that. Or veterans with specific needs. So your prisoners of war, your Medal of Honor recipients, things like that, they're going to qualify for veterans health care. And even if they served active duty or in the reserves, there are still ways that they could qualify for that veterans health care benefit.
Just because you're eligible for VA healthcare services, does that mean that all are eligible to get services for free?
It does not. So lots of veterans are going to be able to qualify for no copay. Like I said, if they have that service-connected disability rating of 50% or higher, they're going to be in that highest priority group. The VA will assign you to one of 8 priority groups, and that determines your how much you're going to pay, if you're going to pay anything, things like that. So 50% or higher, they're not paying anything. They're in that top group. Veterans with special statuses, like I said, Medal of Honor recipients, people who have military sexual trauma, they're qualified under that group. Some veterans will have a copay if they're in one of those lower 8 priority groups. And that's just kind of based on their disability rating, their income, and some other factors.
And What about VA long-term care services?
Yeah, so VA doctors can do a cool thing that most doctors can't do, where they can actually write a prescription for some some in-home skilled care. So I think I'm trying to say. Some in-home care. So if the veteran has a disability rating of 70% or higher, they're going to get free nursing home care. They can get that at a VA-run facility or a VA contracted facility. But that nursing home care, that long-term skilled care, is free for them forever. So that's a really huge benefit.
All right. How do you enroll in VA healthcare, in the VA healthcare system?
There's only one way to enroll in. No, there's not. There's several ways. There's only one way that I want you to enroll in anything. It's going to be in person. They're going to have their proof of service. They have to meet that eligibility. You have to be able to prove that they meet that eligibility requirement. But the best way to do that is going to be in person. You can't do it online, but don't.
That's fair.
All right, Nick, I'm going to switch it up on you and ask you to talk briefly about aid and attendance, homebound benefits for us.
This is my moment.
It's your moment to shine, Nick.
If I may.
Yes, please.
Take the podium for my 15 minutes of fame. All right. Well, y'all, what is often referred to as aid and attendance benefit through the VA is a VA enhanced pension benefit. It's available through the Department of Veteran Affairs for wartime veterans and their surviving spouses who demonstrate both financial and medical necessity for assistance with activities of daily living. Unlike service-connected compensation, this benefit is part of the non-service-connected pension framework and requires the applicant to meet certain asset and clinical thresholds. In the 1990s, it was enhanced to help veterans where long-term care costs exceeded their income by subtracting medical and long-term care expenses from the income to determine income for VA purposes.
All right. Thanks, Nick. All right.
Thank you very much for the opportunity, Liz.
Yay, Nick.
Appreciate it.
All right. It's my turn again.
Yes.
Yeah.
Do you need to have fought in the war to qualify for aid and attendance?
No. So you have to have served one day during a wartime period.
And what are the wartime periods?
Okay. So the government has come out and said that these are the periods of wartime that count when you're looking for veterans benefits. World War I, probably not going to see any World War I veterans coming to you, but April 6th of 1917 to November 11th of 1918. What we're not seeing a whole ton of World War II veterans needing services anymore, maybe some of their spouses, surviving spouses. So that wartime period is December 7th of 1941 to December 31st of 1946. Where we're starting to see some more veterans and still some spouses is the Korean conflict. So June 27th of 1950 to January 31st of 1955. Your Vietnam era, this is where we're really starting to see a lot of folks, is your August 5th of 1964 to May 7th of 1975. With the caveat of veterans who were in country, so actually physically in Vietnam, from November 1st of 1955 to August 4th of 1964. I almost said 84, and that would have been crazy. Gulf War, August 2nd of 1990 to a time that has still not been established as the end date for that conflict.
Is there a length of service to qualify?
Yes, so you have to have served 90 days of active duty, with one of those days being in one of those wartime periods we just talked about.
And what about the reserve or National Guard duty? Does that count?
It can count. So it would only count for those days that the the reserve unit or the National Guard unit was activated by the federal government. So when they actually had to go and do the things, right? Not if they're home serving here, which is still important. Those days unfortunately do not count.
And what if you were dishonorably discharged?
No, you have to have a discharge other than dishonorable. So an honorable discharge, general discharge, maybe they were even medically discharged. There is a way that they can appeal to have their discharge changed if they do have a dishonorable discharge.
What can aid in attendance help pay for?
So aid in attendance helps. It can help you pay for that independent living costs, your assisted living, your nursing home, and even your in-home care. The aid in attendance can help with all of those things.
What are the eligibility requirements for it?
Yep. So like we talked about a couple of times, the 90 days of active duty with 1 day being during the wartime period. If they receive that discharge other than dishonorable, they have to be over the age of 65. There has to be a medical need, excuse me. So some doctor's orders saying that they do need that care. And then the income and medical expenses. So your long-term care, your medical expenses must be close to or exceed your income. So they have to be paying for some care. And then there are some asset requirements as well.
Well, thank you for the lead in. What
You're welcome.
are
You're
the
welcome.
assets? What assets can you keep and still qualify?
Yep. So they can have a house with up to 2 acres, $159,240 in assets for 2025. So kind of like Medicaid, that does change year to year. Their household assets, including their family cars, multiple, plural cars. Oh, did I push the button? There is a penalty for gifting or transfers within the last 3 years and within 3 years of applying. And there can't be any income annuities after October 18th of 2018. So Nick, are there any legal planning opportunities to protect your assets and qualify for aid and attendance?
I'm glad you asked, Liz. Protect assets 3 years in advance with an asset protection trust. Or without 3 years notice, we can still protect the proceeds from the sale of the house with proper legal planning. So basically, create an asset protection trust. And within 3 years, we can apply for aid and attendance benefit.
So we're gonna do a little quick case study here on this. We have the time. So we have Dave and Betty. Dave served in Vietnam. He was honorably discharged. We're going to pretend that doesn't say that he has Parkinson's. That would have been a really great, it's typo. It would have been really good to talk about in our service-connected disability section. But so Dave, he has some medical issues. We'll leave it at that. And Betty has some memory issues. They want to move into an assisted living, but they don't know what to do with their home other than to sell it. So they're going to sell their home. They have about $100,000 in assets between all of their bank accounts and all their other accounts, and their home is valued around $300,000. Right, and so okay, wait. So before Dave and Betty sell their house, they're going to come in and meet with an elder law attorney, probably from Manor Law Group, right? Thanks, Dave and Betty. And we're going to help them get their house into an asset protection trust. So before they sell the home, we're going to put it into the trust. That way, when they do sell the home and they, hopefully they get their full value because the market is wild, we're going to be able to protect those assets for them. And they can still go on and get their aid and attendance benefit.
I'm just going to comment briefly on that. Just that, this is just one of those things when the VA came up with these asset rules, let's just say they weren't as thorough as Medicaid tends to be. Medicaid tends to constantly be tweaking their rules, and they put a lot of time in it. VA, when they first proposed the asset rules, it was completely different. They got, I don't know, 900, was it 900 or 9,000 comments? Yeah, and which made it clear that their initial attempt at putting the asset rules in there were kind of absurd. And then they waited about 3 years and they instituted a final rule without an opportunity for comment. And the final rule was actually a little bit more thorough and had some continuity to it, but they certainly missed some things. And frankly, and I think this is probably a loophole. I don't like to talk about Medicaid loopholes because they're not loopholes. They were intentional. They write them that way, and we're following their rules, and we get to protect assets. I think with the VA, this was probably a mistake when they tried to write the federal regulation, but it's it's not easy for the VA to change its rules. It happens once every couple generations or so, and so we have this nice little loophole where we're able to protect the proceeds from the sale of the house as long as we do it before the house sells.
Thanks, Bob.
Thank you, Bob. How much per month can aid and attendance pay for?
So these numbers are on your laminate that's in your bag. So you do have these too. This just kind of shows how much it can range. So it depends, right, on the situation. If it's just a veteran, just a single veteran, a veteran with his spouse or her spouse, a surviving spouse of a veteran, that all makes a difference in how much the VA can pay. So like I said, that's in your handouts too. You guys do have that on your laminate.
Liz, any final thoughts on aid and attendance, maybe our role in the timeline?
Yeah, absolutely.
As a
So, we don't want to don't wait until you're stuck in 1985. What? It's Back to the Future, Danielle. Get excited. Educate your clients now. If you're meeting with people, like I said, if you're meeting with a veteran and they said, I think I have some Agent Orange exposure, all the red flags, right? We're thinking about that now. And team up with your elder law professionals, so we can protect the dignity and independence for these veterans. Like I said, they served our country and they have these injuries, and we can help them get benefits that they earned. So then just some practice tips for success. Work with acclaimed would be great too. An accredited claims agent, your Manor Law Group, your VA accredited attorneys, your veteran service officers are a really great resource too. Like I said, there's a lot of benefits that we didn't even discuss today that those veteran service officers are going to be able to tell you if your veteran qualifies for most of the time as well. So they can help you apply for other benefits too. You're going to want to request that certified DD-214, that discharge paperwork, as far in advance as you can. Sometimes that could take a long time to get. I know there was a National Archives fire in 1973. So a lot of veterans lost their records were lost, even though we can still get those though. It just takes a little bit longer. So always request that early on. You're going to want to always submit a fully developed claim. So that means, the 3 or 4 forms you have to fill out and all the evidence. You're going to want to have that all submitted at once. What you don't want to do is submit part of it and have the VA ask you 6 times for more documentation. It's just going to make it go slower. So the more you can submit right in the beginning is the best. Always, I never mail anything to the VA without getting a tracking number. Because I don't want the VA to do is say, oh, we never got that. And you have to start all over and it's been 6 months already. So always maintain your copies, a proof that they received your fax, a tracking number, something so that you can say, no, boo-boo, you got my stuff. That's exactly what you say to them, Kelly. Yeah. There's a doctor statement that has to be filled out for, the service connected stuff, the aid and attendance. If you're having a doctor fill that out, just make sure you discuss that with the doctor ahead of time so that they know what you want the form to say. They know that they're filling it out properly. You can't leave a box empty or a space empty on those VA forms. So they have to know to fill everything out. If you're working with a veteran service officer or a VA accredited attorney, and you get mail from the VA, always get it to that agent that's helping you as soon as possible and let them be the one to respond to the VA. And then lastly, just never, if you can help it, don't file an appeal just because you got denied. If you can request a higher level of review or you can submit a supplemental claim, doing an actual appeal is going to add 6 months? I'm guessing. I might be being dramatic, but it's going to add a lot of time to how long it already takes to get approved. And it already can take so long to get the VA to approve your documents.
One of the things that we often do at that level, if we're not satisfied with the response from the VA, is we'll get the U.S. senators from Michigan involved.
Yeah,
They
absolutely.
both have people in their office that are, designated as their sort of VA, what's that? Liaison. Thank you. That's the word I was looking for. And we find that very helpful. So the folks at the VA don't typically respond all that quickly to an inquiry from a lawyer, but they tend to respond pretty quickly from an inquiry from a U.S. senator.
Yeah. And the folks that work at the senator's office, in my experience, have always been really responsive too. So that is a very good resource, Bob. Thank you.
Lovely tips. Liz, do you have any resources and contacts you can share?
Yeah. So in the DeLorean's glove box, does the DeLorean have a glove box? Probably. The va.gov benefits page, I know I said don't submit things online. It's a pain in the butt to get into that website. There's a ton of great information on that website. It's not super gray. It's very black and white on the website. You're making a face. The actual information is pretty clear on that website. They hide the gray stuff, Bob. That's why the website's fine. If you're fortunate enough to have a veteran that already has a login and is able to get logged in, you can track your status of your claim online, which is cool, but it's very hard to actually get to that point. The Michigan Veterans Affairs Agency, they're really good at responding to. They're really good at getting that discharge paperwork for you. So they're a great resource. Your VA accredited attorneys like Bob and Kelly here in our office. And then your local veterans resource officers. Those guys are a really good resource as well. And then all of you. So, we all come into this line of work from different angles, but no matter our role, we share one common mission, and that is to help older adults and their families navigate aging with dignity and a peace of mind. So that mission is too big for any of us, even Bob and even Nick to manage alone. So that's why our circle of care matters so much. When we work together and when the home care company can talk to the physician and the assisted living facility can talk to the elder law attorney, when medical professionals and the legal advocates can work together, we can get best results for our patients and our residents and our clients. But our seniors aren't just patients and residents and clients. They're whole people with complex needs. So when they deserve the circle of care that we have here together, that, professionals that listen to each other and work together, the circle of care, it's not just a concept, it's a commitment to partnership, to communication, and most of all, to do better together than any of us can do alone. Thank you for listening to Nick and I. We'll give
Thank you all for your patience and time and attention.
All right. Thank you so much, Nick and Liz. We do have time for questions. So, all right, there we go. She was ready to go, locked and loaded. All right.
Where can we find a list of the local veterans agents? Like, is there something via your county, or how do you find them?
Yep. So there's always going to be a county resource officer.
VA.gov will list everybody.
Yep. They have a search
va.gov.
bar.
If you didn't hear Bob, va.gov lists everyone. Yep. Good question. Oh, yes.
I saw in your laminate that assisted living is sometimes covered for spouses of veterans. Can you talk about when that would apply?
Yep. So if it's a surviving spouse, right, they could be covered. Or if the spouse needs care and the veteran is healthy, the VA actually is paying for the ill spouse, not for the veteran.
So if you didn't hear the question, what if the veteran has passed and the spouse is surviving?
So there are survivor benefits that aid and attendants can pay for that spouse too.
Good question. So that question was, is there a marriage time frame?
Yeah, so I don't know so much if there's a time. Okay.
1 year. So if you're listening at home and you didn't hear Bob, 1 year they have to be married before the veteran passes away. Who else has a question? Yeah. Oh, yeah, please.
Does the veteran, did they already need to be open to the services for the spouse to get the benefit?
When the veteran's living, the benefit always runs to the veteran. If the veteran's deceased, then it can go to the surviving spouse. So if the veteran's living, the dollars goes into the account of the veteran, whether it's the spouse that needs the care or the veteran that needs the care. But if the veteran's deceased, then it's a spousal benefit, and that goes to the surviving spouse.
Yeah, that's a great question. Can the spouse put in a claim if they never claimed benefits, the veteran?
Yeah, with aid and attendants. Yep, they absolutely can.
Yeah, aid and attendance is pretty cool. Oh, we got it. Oh, okay, we have some more too.
So my question is kind of specific.
Okay.
You have a person, and they say that they had, their spouse passed away because they had issue, and they can get benefits because I guess, like you said, for the spouse, but the person is having issues with capacity or whatnot. Would it be a good idea for the child or whatnot if the next person to try to apply for that benefit because they wouldn't be able to receive it? Does that make sense?
I think that makes sense. So the surviving spouse, correct? Is that what you're asking about? Is the surviving spouse
Right.
maybe doesn't have capacity to receive the benefit? They can still receive the benefits. So, if somebody else fills out the paperwork for them, the child. I don't know if I understood your question.
Okay, I think I understand now. So they would just maybe get some paperwork or something saying that they would be in charge of the funds because they wouldn't be able to handle the funds.
Yeah.
Okay.
So you can do with Social Security, you can do a rep payee. You can do that with VA as well. The VA fiduciary. Thank you, Kelly.
All right, we have
you.
a question here.
If a veteran is getting 100% or is 100% disabled and is getting compensated at 100%, does the aid and attendance go on top of that, or would they take away that 100% disabled compensation?
Yes. No, I was looking at you.
I'm coming.
So the answer is that you're not going to get separate aid and attendance. You're not going to get, it's not going to be a separate application for aid and attendance. You already get more from the compensation than you get from aid and attendance. However, my understanding is through the compensation program, you might get more dollars if you actually meet the standards of aid and attendance. If you meet that medical standard, that might add to the number of dollars that you get. So it's not really a separate application. It's just that you might be able to get more dollars if you qualify.
All right, and I think we had a question back here. Okay. I'm gonna shimmy.
Clarify, is a couple questions ago. When we talk about the remaining spouse qualifying for aid and attendance for assisted living, it's not going to cover the full cost of the
Correct.
assisted living. It's just going to be $1,515 towards the cost.
Correct.
Yeah, I didn't want people to be
Right, yeah.
misled by that. So.
Thank you.
Thank you.
Do we have any other questions? Oh, yes, we do.
I'm running. I need some.
I know it's like they're racing. You guys
So
keep
if
raising
you're
hands
100
on opposites.
If you're 100% disabled, you don't qualify for aid and attendance then?
Yeah, so if you didn't hear Kelly, what Kelly said was you're not going to get the benefit in addition to that 100% compensation. Right, you could get more money, so.
All right. Do we have any other questions? Oh, we do. Oh, we have two more.
So would that aid and attendance benefit end if the level of care, they needed to go into a nursing home and they needed to apply for Medicaid?
No.
Can you get both benefits?
So you can, but what happens if you get all your Medicaid approved and then the VA reduces your benefit to $90. So you're still getting some VA benefits, but it's significantly less. But you're getting Medicaid, so balance it back out.
I recently had a patient who was getting 100% VA disability, and I asked the same thing: could they get the aid and attendance pension too? So the answer was no. But what I was told is they can get the Agent Orange benefit in addition to the 100% VA disability. Does that sound right? They had them apply for that too to try to get an increase in.
Yeah.
That goes back to the VA math question. If you're if you're already 100%, can you get more than 100%? And probably,
I was going to say, because sometimes they do change your ratings where they determined at one thing, like we've had experiences where people have unservice connected disabilities. So if they're just adding the Agent Orange on top of it, it's kind of like putting extra butter on your pancake. Just making sure it's covered.
I like that. Extra butter on your pancake. I know. It's almost lunchtime. We're hungry, Bob.
Are there attorneys that will advise and consult with clients who are not accredited VA attorneys?
You don't want them to.
Well, I know you wouldn't want them to. I mean,
They probably do. There's probably some that do.
What the VA says is that you're supposed to be accredited if you are giving advice about veterans benefits.
And the VA is who's accrediting you.
Yeah, and for attorneys, it's not difficult.
So there is a search for accredited agents, and you can look up attorney claims or attorney agents and whether or not they're accredited through the VA.
So we have a lot of attorneys. So we do a lot within the Bar Association, especially the Elder Law Bar Association. And so a lot of attorneys in Michigan have chosen not to continue their accreditation. And so we'll get calls from folks that say, hey, we were working with Raymond Harris, or we were working with somebody else, and they said they weren't accredited, so I have to call you now. It's like, okay, that's fine. So a lot of times there's elder law attorneys that just chose not to continue their accreditation, but then what they're supposed to do is just to defer to another attorney that is accredited.
That's a great question. Do we have any more questions? Oh.
I have a friend that says he doesn't qualify. He was in Vietnam, and he says he doesn't qualify because his discharge, it wasn't dishonorable, but his group of people followed what his leader told them to do and wasn't right. And they got in trouble, and I don't know what the discharge was, but he says he doesn't qualify for the benefits.
So like I said, there is a way to appeal your dishonorable discharge. I don't know all the specifics of that. I'm not going to pretend that I do, but there is a way to do it. Otherwise, it would depend. As long as it's not dishonorable, if it's just a general discharge, he might still be okay and probably should reapply.
Let me just say this, that a lot of veterans sort of make an assumption or they called the 800 number, or they typed a veteran service officer, someone discouraged. I had a case, oh boy, I hate this case. The daughter, spina bifida is something that is Agent Orange related, I think, but it's for the children of the veteran. And so they went to apply, and the VA, they probably went to like a VA hospital. They went to apply back in the 80s or something. And told, no, that has nothing to do with it. That's your child, has nothing to do with it. Well, later they found out, no, it absolutely has nothing to do with it. It's probably directly related. But because there was no record of him ever applying, because he was told not to, When he goes back now, he'll only get benefits starting now, as opposed to getting benefits, probably hundreds of thousands of dollars since the 1980s that he's entitled to if they would have just let him apply. So sometimes with veterans, it's like, okay, you got to apply anyway, even if you're told not to.
All right. Do we have any other questions? Yes, we do.
Just one, in related to that case, would the child be eligible for benefits?
Again, same thing. If the veteran's alive, I think the benefit always runs to the veteran. But if the veteran had died, then I think the child would be entitled to the benefits.
All right. Any other questions? This was a good topic. All right. Well, I think it's safe to say thank you to Nick and to Liz. All right, folks, we're going to go ahead and invite our lunch speaker up on stage. We have Tom Farrell here. He's also our platinum sponsor from Crown Real Estate. And I would love for Tom to are you going to stay down here? Or are you going to come up here? We're the same height now. But let's go ahead and just give a polite round of applause for Tom.
Thank you, dear.
Before Tom gets started, I always like to give a shout out to Tom. He's probably the primary realtor we use at our office because he's so accommodating and so helpful. And, if we need something involving real estate, Tom's our first call. So I always just like to make sure that everybody else knows that that's the kind of confidence that we have in him. So.
Thank you very much. A lot of people ask, why real estate here at this place? And it's for a very good reason. And thank you, Bob, and your team for putting on this kind of event for everyone. I wanted just to say a quick thing because I went through something that I didn't think I would have to go through. I've come to these for several years. I try to get the information, listen to it. My mother was a GM employee. I thought, just like everybody, her insurance is great. Everything is wonderful. She started having what I guess they would call dementia. And I thought everything was just on autopilot. I just had to show up, threaten somebody if they don't take care of mom just so good, which I didn't do. But I was so wrong. And as I went to other places, my mom went to we're a local hospital and went through different experiences there. I didn't know what to do. And I consider myself a pretty smart person. I come here, I listen to Bob, I listen to the stories, and I think, I got this. I think I can do this. If not, I'll just bulldoze my way through. And I went to a couple local facilities with my mother, different various how I felt about them, some good, some bad. They tell you you're approved for something, and then come to find out you're not. And at my weakest moment, which I don't like to admit because I always pretend to be the tough guy, I called Bob and his team, and I said, I don't know what to do. They tell me my mom doesn't qualify for this. She makes too much. I don't know what too much means. She's not getting healthy fast enough. And I don't know what to do. So I got a hold of Bob's team, which they're like, duh, why didn't you come sooner? We could have made this a whole lot easier. But, I'm the tough guy. I'm going to bulldoze this through. And once they got involved, my life changed. So what I wanted to do is first, thank you all for coming here. You taking an interest, we have to do Con Ed in my industry. Taking an interest in your industry so that you can help people like me who don't know what to ask when it comes to help, getting help and where do we go? Having a resource like Bob and his team, and there's other attorneys out there too, but Bob is, to me, number one. And that's why I do this. I do anytime he says, Tom, I'd like to have you sponsor. He don't have to ask. I'm in. It's not, I would do this whether we had a relationship with business or not, because he took care of me and my family. And I'm going to tell you, you guys, we get, at least in real estate, we get in our bubbles. You know, I've done real estate for 25 years, so there ain't too much I haven't ran across. And I look great for 25. And I did go through the foreclosure and short sale days. I was one of the bigger agents. And the people that you talk to, they may look at you with those eyes and shake their head yes. We have no clue. We have no direction. You probably all have talked to somebody with some level of frustration of what people are interacting with. They've been told one thing and it's not true. I told Bob, my mom, she doesn't qualify for this. Within about an hour, I got a call back. Yeah, she does. They lied to you. We got you covered. And then they moved my mom to a place that gave my mom A1 care. So a couple of things for me is, one, Bob's team is great. And you're lucky to have a resource like this. I wish I had this resource in my industry. We wouldn't be as bad as we are at times. Two, they care. And it's easy to throw around. It's easy to say, oh yeah, I care. It's a financial care. It's not. They get personal. They know the names. They don't forget. There's a smile on their face that makes you feel like you're part of something. And I do. That's why I do this. And lastly, as you're going through this class, and sometimes, and I'm guilty, I slept in class a lot. I was not the greatest student. And my wife said no jokes, so I'm trying to keep clear of jokes. She's the smart one. Just understand that we don't know. And you guys coming here and taking advantage of this thing to talk to us, to teach us, means the world. I wish I got lucky before I met Bob. I had some senior people that I dealt with my family, because I belong to an older family. I'm blown away every time I come here and he educates me on something. Blown away. I know for you it's every day. I'm sure if you came to my world, you would be blown away with some of the things that we do and don't do. But that's all I wanted to say today. I want to let Bob know I'm ready for next year's sponsorship. I'll come in. Next time it's going to be a war with all the other vendors. I will have some really cool swag. You can guarantee it. You guys are going down. Thank you very much.
I'd like to go ahead and bring Attorney Bob Manner, and he's going to introduce our keynote speaker today, which I know Bob's really excited about, but I'm super excited too.
So, some of you noticed over the years, a lot of you have been here more than once to boot camp. And so some of you have noticed over the years that we're not exactly typical lawyers. Our law firm, and I'm not exactly a typical lawyer. And there's a lot of influences that come from that. But one of them is probably the main one is going to be Julianne Steinbacher. And so it's not the way you think it would be, though. Because when I first saw, I'd never heard of Julie until about, I think it was, let me see on my notes here, 2008, I believe. I went to this conference, so I had an associate attorney back then, and he had convinced me to start doing Medicaid and elder law, and we started doing some veterans benefits. And then he had heard about this conference in Kansas City at the airport. Not as much fun as you might think it would be. We never left the airport. And Julie was one of the speakers there. And so I'd never heard of her before. And I was at the point in my career where, it had gotten kind of frustrating. And I'll tell you this, when I went to law school, I expected that we were going to be able to help people, that was, that we were actually making a difference. And when I started out, some of you may know, I started out actually doing courtroom work, litigation, and I found that frustrating. I didn't feel like I was really making a difference. It really felt more like a cog in the system, that I was just another cog in the system. And then even when we switched to estate planning and elder law and veterans benefits and all that, it was very much just about the, what you expect it to be. Okay, it's dollars, it's documents, it's how do we get benefits, how do we fill out these forms. And so then at this conference, Julie was one of the primary speakers. I'd never heard any lawyer speak like this before or describe her job the way that she had described her job. Because typically when you get into this, it's just like, okay, well, who do you want as your executor? Who do you want? You need veterans benefits. Okay, here's what you need to get the veterans benefit. Julie didn't approach her meetings with clients that way. Julie was asking them about their life and what they were going through. She was asking about what prescriptions that, if somebody had dementia, she was asking about what prescriptions they were taking. She was asking about how this had impacted the family and how it impacted the spouse. I'd never heard a lawyer talk like that before. And really that's what we're trying to do, right? Is have a real impact. It's not, of course, dollars matter. Of course, documents matter. But the way that she approached it, and then she went on and she'll probably tell you a little bit about her background. I don't know if it's all in there or not, but she went on and said, well, she had worked in a nursing home before she went to law school. She has a degree in some format in gerontology or some kind of gerontology. And I was like, okay, yeah, I finally found that's the kind of lawyer I want to be. But I also thought there's no way I could be that. I had just started doing Medicaid and elder law. I was like, okay, yeah, Julie can do that because, she's Julie. She worked in a nursing home. She has this experience. She understands these things. And I was just starting to get, hold of understand the law, let alone trying to get into people's, family situation, really help solve problems as opposed to just solve dollars. And I'm, any of you that approach, we talk one-on-one, if I might look like I'm really friendly up on stage, I'm actually pretty shy. And so I didn't talk to Julie for another 15 years. But by the time I talked to her again, we were doing the stuff that she was doing. We were asking those questions. So she was always kind of like that North Star was like, okay, that's the kind of lawyer I want to be. I didn't think I could do it back in 2008. But I saw that it was something that could be done, that you could really try to impact lives and not just how much money is in your bank account. And I was, it's kind of funny that I didn't then say, hey, Julie, you're the exact type of lawyer I want to be. Can I find out more about your practice or whatever? I was just kind of too shy to do that. So then come about, and I had gone to a couple other events. It's not like I had never not interacted with Julie over that time period. So it was from 2008 up until about 2020. But it was, again, just sort of an audience member in one of her amazing presentations. And then in 2020, Amy and Kelly came back from an event, and they're like, okay, because many of you know, we had a social worker on staff. We were doing, this form of care navigation, and then we kind of stopped doing it. And I didn't have a social worker on staff. And so Amy and Kelly came back and they're like, we've got to do that again. This is really important. This is what we need to be doing. We need to hire a social worker. And we found this other, Julie. I was like, I know who Julie is. Don't tell me who Julie is. I know who Julie is. And so we started interacting with Julie a little bit more online because it was COVID, right? 2020. And she was doing this event. And I said, okay, we can go to the event. I think we took 4 people or whatever. We can go to the event, but I'm not hiring a social worker. Came back, we hired 2. And so now on the other side of the story, Julie's actually been a tremendous mentor to me for the last 5 years. I've got to know her family and her husband and her kids. We even she puts together some trips sometimes, and so my wife and I and Julie and her husband and a number of other attorneys toured Ireland and London, and we've done some good things. And one of her daughters is one of our main advisors in our office for on accounting and making sure our payroll and all that is done well. So we've become very close. We're actually leaving next week, and I'm going to talk a little bit about this in Hot Topics, but to go to Amsterdam, because with Julie and a number of other contingents of lawyers, because there's this place called the Dementia Village. Anybody hear of this in Amsterdam? Mm-hmm. So we're going to get to visit the Dementia Village and observe, and I'm really excited about it. And so Julie and Julie's daughter actually helped organize this trip. So I'm very excited about that. But that's who Julie is. She's also, I was told I can't say bad words, but it's hard to describe Julie without saying that she's a badass. She's just, she's one of the most down-to-earth people I've ever met. For somebody as successful as she's been, and she's incredibly successful, she's just so down-to-earth. And I've met and interacted with a lot of very successful people. Never been anybody who's so approachable and down to earth as Julie is. And so she's a great source of information. I'm really excited to hear her presentation. But I did feel like that it was worth kind of sharing with you that if you either like the fact that we're not like other attorneys or you dislike it, you can blame Julie, because she was, so anyway, so we're going to go ahead and bring up Julie. She does run a large law firm in Pennsylvania. Do you have how many offices now? 7 offices?
7 offices, yeah.
7 offices in Pennsylvania. She runs a coaching group. So the coaching group that I had gone to in Kansas City, she actually took over that coaching group, and it's a great group to be a part of. And is one thing I wanted to point out and thank her for. She was invited to speak today at a national conference for the National Academy of Elder Law Attorneys. It's a much more prestigious speaking event than our little boot camp. And she had already committed to speak here. And so even though they asked her to speak at a much more prestigious event, she chose to come and talk to you guys over going to this national conference. And she's spoken at all these different conferences. She's really highly respected, but really appreciate her commitment. And I think you guys are going to love her. So come on up, Julie.
Thank you.
I'm not okay, but it's all gonna be all right. It's not okay, but we're all gonna be all right. Gonna be all right. Gonna be all right.
So how many of you have ever felt like you're just not okay? Well, we all have, right? Yeah, my mom passed away in December, and I listen to that song all the time. I'll be in my Jeep and I'll just be belting out the tunes. And it's just like, I'm not okay. So I get to do is spend the next hour with you and really kind of talk about both the changing landscape of elder law in this country and what we are going to have to do to confront that. And then also talk about what is it that you can do really for yourself. And if I meet my goal of what I wanted to do today, you'll leave here with at least one idea that you can do to help you. Because if you're not okay, the people you serve are not okay. And I look around this room and I see people who I bet you usually don't put themselves first. Usually you think, oh, it'll be okay. I'll just do it. I just have to do it, right? And so we really want to think about that. As Bob said, I am a practicing attorney. I basically spend my days helping people answer 3 questions. The first question is, what happens if you die? Who gets your stuff? How do I get your couch, your Hummels, your investments, your house, to whoever you want in the simplest, most cost-efficient manner possible? And as Bob indicated, that's really not all that fun of a question, but we help people do that. The second question is, what happens if you don't die? What happens if you get sick? What do we need to do today to make sure that you get good care? Having good decision makers, having a power of attorney. Who is it in your family that you want me to talk to? Who's your voice? How do we make sure that we appeal that discharge from the hospital and we don't have a situation where it's Friday afternoon and you walk in and they're like, yeah, your mom's going to a nursing home today. Here's a list, right? That happened to me. My mom passed away of restrictive lung disease. It's a horrible disease. I visited my mom every day in the hospital, even though it was an hour away from me. And they never talked about her discharge. Until one Friday, I walked in and the social worker gave me a thing and said, your mom's being discharged today. Here is a list of places she can go. And I looked at them and said, my mom is not going to any of those places. Because what I know is that if somebody is discharged to a nursing home, they have a 25% chance of ever getting discharged. Now, there's some nursing homes that beat that average, and there's some that don't. What I know is that my mom lived in a personal care home, and what she really needed to do was go to a short-term rehab. And so I said, my mom will be going to Encompass Rehab in Pleasant Gap. Do you want to call them or shall I? Right? So what happens if you get sick? How do we make sure you get good care? And the third question is, what happens if you don't just get sick, but you get dementia? How do we protect you? That journey is so hard in this country. That's why attorneys like Bob and I are going over to the dementia village because, listen, there's got to be a better way to do this, right? And if there is a better way to do it and people get it, I believe the people in this room are going to be the people that make it happen. It's not going to happen in Washington. It's not going to happen with big industry. It's going to happen because we created a circle of care and communicated with each other, and we helped families one by one. It's really, really important. So that's what I spend my days doing. I do have a law firm in North Central Pennsylvania. So we span from, am I allowed to say Penn State College here? I mean, I know I'm like in Michigan country, but Altoona State College, Williamsport, Wilkes-Barre. So if you look at the state of Pennsylvania and you take out Philadelphia and Pittsburgh, I probably have an office there, but we don't go into the cities. So I was born and raised on a farm in North Central Pennsylvania, married my high school sweetheart, came home, had some kids, and put roots there. And I'm very glad that I did that. I'm also a serial entrepreneur, as Bob indicated. I have a coaching group where I coach attorneys across the nation about having the lives and practices that they desire. I also own a personal care home. That was fun during COVID. I cut people's hair, I made meals, I did all kinds of things during COVID. And so really excited. And so what I'm going to talk to you about today is really pulling from all of those things that I do to kind of talk to you about what do we see going on in this country and where do we need to go. I also just want to announce, I have to announce, my daughter and I, Courtney, just launched a podcast called Hey Woman. And that podcast is really a tribute to my mom. We called her Woman. We'd walk into her apartment, we'd be like, hey, woman, how are you? She loved that, especially when my son would say, hey, woman, to her. But it's really about real conversations on caregiving, legacy, and love, and what we're talking about today. Just acknowledging that this is hard is really, really important for us. So why am I so passionate about this? Like, why did I choose to come here? Because I, like you, I'm so much more than my job. I'm a mom to 3 kids. They're my 3 kids. That's an old picture, but I love it. So the middle kid is my youngest, the boy. He played on a football team in high school, but he just graduated from college last weekend. I know I'm getting to be an old lady, for God's sakes, right? I'm also a wife, an aunt, a daughter, a caregiver myself. I cared for my stepdad who had congestive heart failure for years. Used to put my 3 kids in a car on a Friday night and drive to Maine from Pennsylvania, clean my mom's house, do anything I could to help her, and then the following Sunday night, put my kids back in a car and drive back. Did that for years. And so for each of you, I want you to think about, when I talk about not just your jobs, but who are you as a person? And so much of what we do that's so wrong, and every one of us does it. We give the best of who we are at work, and we leave the rest for people at home. We don't mean to do it. I certainly have done it. We have to stop doing that. And sometimes it's about making tough decisions at work, and we'll talk about that. So basically, it's like okay that you're not okay. None of us are. But your clients, and this slide should be changed because it should say your families. I don't care if it's a spouse. I don't care if it's your dog. There are people that rely on you. And if you don't take care of yourself, the whole thing comes toppling down. Listen, if I'm not okay, it's not just about me. It's about everybody that relies on me. And so that's why we have to be honest about this, and we have to learn how to do it better. We need to stay strong so we can keep showing up for them. So today we're going to kind of discuss the challenges of aging in America. And to be honest with you, I know you're hoping to get out of here. I could talk to you all day about that. And particularly the challenges that we face right now and the chaos in this country. But don't worry, we won't stay too long on that. Sustaining yourself while serving others. We're going to talk about time, energy, and delegation, and something that I love that I call chunk it. We're going to talk about how to chunk your time, energy, and your presence, and why that is so, so important and why we don't do it. And I'm going to urge you to stay inspired and connected to your purpose so that you can build a resilient future. Because just like Bob said, he became an attorney so that he could help people. Every one of you that's sitting in this room is doing the job you're doing for some reason. I started as a social worker in a nursing home. I loved my job. Loved my job. I will tell you guys, it was at a bad time. I was really young. I just got out of college, a social worker in a nursing home. For whatever reason, I vied with my administrator boss that the residents could have some alcohol, like just maybe a beer or something, right? So here I am, this young person, just married, had my first kid. And I'm like, yeah, they deserve that. You know, they have rights. They deserve to do this. And it was an old, not what you think of nursing homes today. You go back that many years, it was an old county home. There was residents that were there for many, many years and never would get discharged. It's not the same as it was today. So I got everybody to get their, doctor's orders so they could have one beer. I set them all up, went and got it. Next morning, I walk into the office. Literally, the administrator he meets me at the door, takes me into his office. For some reason, I got a little out of control, the party. There was some touching and feeling that should not have happened. I was pretty young, and I couldn't even talk about those things with somebody. But we're gonna think through those things. And we're going to talk about why is it that you're in your job. And what I hope you think about is, why are you? And how do you reconnect to that? Because that energy about reconnecting to why you do what you do helps you get through those bad days. Makes it all worth it. Let's talk about the growing challenges of aging in America. Families are more spread out, absolutely. But I have to say to you, I think sometimes that's a cop that people say because they think, oh, well, families don't help. That's not true. That's not true at all. In fact, I'm going to read you guys some statistics that actually the Alzheimer's Association put out. Got them from the back in Michigan specific. As soon as I sat down, I thought, oh, the Alzheimer's Association is here. I got to go back and ask them if they have the Michigan stats. So in Michigan, 202,000 people have Alzheimer's disease. They are cared for by 385,000 people. I want you to think about those statistics. It means it's almost 2 caregivers for every 1 person that has dementia. So 202,000 versus 385,000. But they provide 883 million hours of unpaid care. So when we see the cost of care, we see that it's $384 billion across this nation, but $404 billion is provided for free. That is crazy, you guys. But more importantly to those statistics, and I think the Alzheimer's Association does a great job at advocating for change and advocating for legislation that helps with this and for funding. But more important for me is, of those caregivers in the state of Michigan, 66% of them have a chronic health condition. I'm caring for my loved one that has dementia, and I myself have a chronic health decision. 30% have depression. We get into the employment statistics, 50% of them are going to be employed. And of those 50% that are employed, 16% of them are going to take a leave of absence. This is hard. Aging in America is hard. And there's no way we can just make it easier. There's no silver wand. We've seen a lack through the years of our federal government addressing this issue. We've seen states come out and try to address it, but it's haphazard at best. Does anybody know why? I'm just looking at my time. I have time to tell a little aside story. Why we have this fragmented Medicare, Medicaid? Ever think about that? Because Medicare was built in the 1950s. And Medicare reflects the care that occurred in the 1950s. In the 1950s, you got sick and you either died or got better, right? That's acute care. Medicare does a good job of that. There was no long-term care. So it's not that Medicare is wrong. It's that it was never designed to provide the care that we have today. And the federal government hasn't responded to that. There was once with the when the Affordable Care Act came in, we had a thought of long-term care insurance, and that was abandoned very quickly. But when we think about why is this hard? Why are there so many people having to care for their loved ones? It's because the system says, you know, if you have a heart attack and you're really sick and you need a bypass, we'll pay for that. But if you have dementia, we won't. And that's where we're at. But there's lots of other reasons. I mean, I can give you more great news. So there's other reasons that it's hard in the US. Many people don't have children. So about 16.5% of people don't have children. They're called solo agers. Solo agers. Yeah. And it's so important that we know who you'd want to talk to, who's your power of attorney. And when they were talking, they talked about the fact that professionally, there aren't a lot of really great guardianship services. And a lot of what they talked about in Michigan here would be the same in Pennsylvania. There aren't a lot of companies. Some of the companies do it are fraught with fraud. I honestly, in my local town, am often fighting one of the local providers because I don't think they do a good job. And so we want to think about that. There's just more of us. There's more senior citizens. It used to be that 10,000 baby boomers turn 65 every day. Now it's 11,200 baby boomers turn 65 every day. But let's add to that, you guys, the fact that, I don't know about you, but in Pennsylvania, 300 facilities closed since COVID. There's less facilities. Let's talk about caregivers. Is there enough caregivers out there right now? No, there isn't. So it's hard. It's hard. And it's not going to really get easier. People are living longer. So we have more people aging and they're living longer. But sometimes they're living with chronic health conditions. So sometimes they need more help. There's all kinds of statistics about, those people who are 85 plus consume 3 times as much health care. I would say to you, though, if we all created this circle of care and we all worked together and maximized the benefits that are out there and had tough conversations about do not resuscitate orders and really put a plan in place, we could have a better outcome and it would actually cost less. It's just really hard. My mom, I told you my mom passed away in December of restrictive lung disease, and she struggled with that for years. And the last year was not easy. I pretty much lived with her most nights. And we were a little fiery with each other. My mom loved her grandchildren. In fact, she had some surgeries, and she woke up from one surgery. I was standing beside her. There's me and my brother. I'm standing beside her, and she's telling the nurse, she's still halfway in anesthesia, but she's telling the nurse she didn't have any kids. She had 5 wonderful grandchildren, but she didn't have any kids. I'm like, I'm standing right here, Mom, right? But it was hard. But I would say to you, we were able to affect a better life for her, some through Medicare. One of the best things we ever did with my mom is got her enrolled in palliative care. Palliative care changed my mom's life. She went from, we kept taking her to doctors and all this kind of stuff. She kept falling. She had restrictive lung disease. Plus she had a drop foot. So she would, pull her foot and then she would fall. She'd end up in the hospital, or she was on Eliquis, the blood thinner, and she'd fall. We'd have to go to the ER. At our ER, you're out in the hallway. They don't even let you in the room, because there's not enough. And it was this traumatic event every time, traumatic for her, traumatic for us. And so I got her on palliative care, and they gave her just a bit of pain medicine. And the nurse explained to me, the certified registered nurse practitioner explained to me that it was my mom's restrictive lung disease that was causing her to fall, not the drop foot. And that if they just did that, she would stand up a little higher. My mom never fell and went back into the hospital the rest of her days. That's powerful. Yet, I have situations at my office right now. We do just like they do. I'm talking to a client of mine and I'm like, hey, we have to get her palliative care. So we make the referral and the doctor says, you don't qualify for palliative care. I'm sorry. I read the regulations. It seems that they would. You just have to have if you read, the legal interpretation is that you have to have horrible symptoms, significant and horrible symptoms. Without me advocating, then the family's mad at me. You told us we could get it. I knew I did. And I still think that's correct, But now I'm having to interact with that. Hospice. My mom ended up dying with hospice. And even though I had some very, very pointed conversations with my mom, I knew what my mom wanted. My mom wanted to die where she was at. She did not want to die in a hospital. And we filled out all the paperwork. We filled out the post. We did all of that. And then I was up at my lake house with my husband. I had just actually had a procedure myself, a medical procedure, and I was off of work. My husband and I thought, oh, we'll just go to the lake house together, right? And my brother called and said, hey, mom's doing really bad. I'm going to call the ambulance. And I said, buddy, don't call the ambulance. See, even though we had talked about it, that was his first instinct. And his instinct was, I want to help mom. And I said, buddy, she doesn't want to go. I know, I have goosebumps sitting here telling you this story. I could cry too. I won't though. I know you want to help mom because, like, especially, no disrespect to the men in here, but you guys want to fix things, like, right? Like, I don't know. Have you? I'll be slightly sexist and then I'll get back. But I don't know if any of you women, you ever like tell your husband a story and you really just want him to be like, oh, honey, I'm sorry. That's a tough day. And he's out there trying to fix it for you, right? That's an actual instinct, I think. You know, so my brother wanted to fix it for my mom. And I had to say to him, buddy, you can't fix it, but it'll be okay. You know, I said, Donald and I are leaving. We'll be there as soon as we can. And so we want to be thinking about that. So these next slides just kind of talk about how much the cost of cares went up. It's amazing to me. So this starts, if you can't see it, this starts down here at like 2004, and this starts about $30,000. So in 2020, well, this is 2024 from Genworth, it's $64,000 is the average cost of assisted living care. That's dramatic, isn't it? For those of you who are financial advisors in here, I know I think maybe there's a couple. When you say to your client, you have enough money, I want you to really think about, can you get this return for them? If you can, give me your business card because I would love to use you as my advisor. But we have to always think about that. It's astronomical. This is the average cost of in-home care. And again, starts about $42,000 a year in 2024, and now it's up to $75,000. And look at this. Look at how this went up right after COVID. It skyrocketed. This is all stuff we know, right? Nursing home care, kind of the same. It's $65,000. And this is national, but I was looking, your guys is what, $11,000 a month. So you're right within there. So 80% increase in 20 years. Astronomical. And I would say to you, it's just going to keep getting worse because we're going to have less facilities. If we mess with Medicaid, as the federal government is thinking at this point in time, that's going to trickle down to the states. We're going to have more people competing for less beds. Their wonderful chart that they gave you that talks about, you know, waivers and PACE and everything they talk to, they're optional services that your state, if they get less funding, will have to decide whether or not they keep them. And so I think, you know, we're just on this trajectory in this nation that this is just going to get harder. I know, I've made you feel good, right? I've made you feel good, right? But my goal is just to kind of talk about sustaining yourself while serving others. And I love this quote: taking care of yourself doesn't mean me first, it means me too. It means me too. So how do we take care of ourselves too? Burnout is real. So who in here is a social worker? So statistically, 50% of them, 50% of you will report very high levels of stress in your job. I actually think, like, did they ask all 100%? Because I actually think it's higher. The rest of you are just lying. You're just like, oh, I'm okay. You know, you didn't hear the song yet. And so one of the things I want you to get is I'm asking you to create a plan for yourself, just like you would create a plan for your clients, and prioritize your well-being, your rest, your boundaries. And we're going to talk about some specific ways to do that. There's all kinds of research about how helpful just a small amount of change can be. They call it the compound effect, you know, do something very small. So I know from my perspective, like sometimes I'm like, oh, I'm going to get in shape and I'm going to do everything. I'm going to get up and go to the gym 3 nights a week, blah, blah, blah. And, you know, that lasts for a week, right? But the studies will show just taking a walk for 15 minutes So just at lunch, it's nice. I live in Pennsylvania, like you live here, where like the winter stinks, right? It's nice outside. Take a 15-minute walk every day at lunch. That will actually make a difference. It doesn't sound like that much, but that will make a difference. Self-care is definitely professional care. There's studies that show those people who do engage in self-care will report that 23% higher job satisfaction and lower turnover rates than people who don't take care of themselves. Because the idea is that if you don't take care of yourself at some point in time, everything breaks. It's too much. You can't do it. And you either then get very resentful at your job or you leave it. And so we want to be thinking about that. Use your paid time off. I hear some stuff over here, like you can't do that. Use your PTO. I have to tell you that we as a country are so different. Over in Europe, they take a month off every year. So they're not burnt out. This whole idea, to be honest with you, a week really doesn't do as much for you as what studies would show it takes 2 weeks, 3 weeks. But I have people who say, oh, I haven't taken a vacation in years. And I don't even mean that you have to spend a lot of money. I'm not talking about that. One thing that I think is really helpful that I learned when I was doing some coaching with somebody else was what they call a flow day. Take a day. Do whatever you want. Could be sitting on your couch watching Netflix. Could be checking yourself in a hotel and your family doesn't know where you're at. No judgment. No judgment. But so much of this is so much of it, we don't have any control over what we do day to day or hour to hour. I don't know about you, but when I walk in my office, there's a calendar and it tells me everything I'm going to do for the next 8 hours. And I barely at times have time to pee. I'd have to say, oh, I'm going to be 5 minutes late to that Zoom, So I urge you, use your PTO. If you haven't scheduled a vacation, if you haven't done something like that, or a weekend away or a weekend at home, just don't make it a stay vacation. And then all you do is work at your house. Right? That's not what I'm talking about. And if any of you guys are the boss, lead by example. Because sometimes you got there because you're like, I can't take off. I can't take off. It's not possible. So we want to think about time, energy, and delegation. Definitely, I liked this quote too. It talks about we can do anything, but not everything. It's funny, I was raised in the 80s, Dolly Parton working 9 to 5, right? And I think that was a little bit, please know I greatly respect Dolly Parton, but I think it was a little bit of a, I don't think it was helpful to think that you could have everything. You can, but not all at once, right? There's chapters in our lives that we have to be thinking about and moving forward. So one of the things I'd ask you is, do you believe the list of lies that overwhelm you? So I'm sure some of you are in here and you're thinking, well, this is all great that she's saying this, but, I don't have a choice. Yeah, you do. Any one of you could walk out of your jobs today, disengage yourself for some relationship that's not helpful, make the person underneath you do the job they're supposed to, or have a strong conversation about how they need to. We do have a choice. I'm more productive if I'm busy. Yeah. And again, that's the 9 to 5. Bring home the bacon, put it in the pan, do everything all at the same time. That's not all that helpful. To be honest with you, the best work is done when somebody's focused and gets something done. being busy validates my salary. Sometimes that's about you. That somehow that you still feel like an imposter in some ways. That you still have to prove yourself. I'm telling you, if you're sitting in this room, you don't have to prove anything to anybody. You care. And you do a good job or you wouldn't be sitting here. Step into that power. Really important. Everyone else is busy, so I need to too. Like, or they didn't take PTO, so I can't either. I don't know. Do they pay your bills? No, are they going to be at the hospital when like you stress out? Or it's all important. Everything I do is important. Yeah, it is. Everything is important. Doesn't mean all of it has to be done by you. It also doesn't mean it's all equally important. It's funny, Bob talked about, my kids, and I have my middle child. Everybody has the one kid, right? Right? I love her. She's passionate. She's perfectionistic. She's a fighter. I respect her. She is a pain to live with. I'm going to tell you that right now. But this is where she is. She's like, oh, I have to do all this stuff. I've been trying to help her understand that, yeah, it's all important, but it's not all equally important. The best thing she can do is prioritize her list. And all of us have things that we thought were important, and we keep holding on to them. Like, oh, I'll get to that. Oh, I'll get to that. Maybe the reason you're not getting to it is it's really not as important. You should just let it go. You cross it off. They don't need to do that. I worked with a business coach one. His name was Rob Berkeley, and he really, really helped me. And I remember I'd get on coaching calls with him, and I'd be like, oh, I didn't do that. I will do that. I promise, Rob, I'll do it. And finally, one day he said to me, Julie, you're never going to do that. And I was ticked at him. It's like, don't tell me. I'm going to do it. He was right. Because although it was important, it was never going to be the most important thing on my plate. And I either needed to delegate it out, decide that it didn't need to be done. So important. They need me. Funny, when we do coaching with a lot of the attorneys, we always do this thing where we're like kill the hero, right? Remember that sometimes when you fix a problem at your office or at your place, just remember sometimes you're feeding your own ego because it feels good to help. Like, oh, they need me. Like, I'm the only one person here that can do it. Right? And please know, I'm not making fun of you. I've said everything we're talking about right now. Everything. But I urge you, when you think about, I can't make a change in my life, challenge yourself. Because everybody can. And maybe it's just a small change. We all have some control over some part of it. For me, learning how to control that, learning what I could do started actually when I started building this thing that I called Chunk It. Chunking your time, energy, and presence. I remember this was when my stepdad was sick. So 3 kids, little kids. My husband worked a lot. He does demolition and excavating. I was like a single mom in the summer. I have this job, this office of my own. Things aren't going great. It's not like a simple slide up, is it, Bob? It's like 2 steps forward, 1 step back. My stepdad was sick. He had congestive heart failure. It was really sad. I considered him my father. My parents were divorced, and he was my father figure. And my mom and him had worked very hard, and they retired probably too late, and he got sick. But he wanted to live. And so congestive heart failure is also a horrible disease. Like he kept getting sick, and we'd be in the ICU, and then we'd be home. The nice thing about it was that, he could still interact and talk to us. But during that time period of all these hospitalizations and trying to help my mom care for him, my life was too much. I remember I was at Wegmans. It's a grocery store where I live. And it was like 5 o'clock in the morning. I had spent all night in the hospital with my mom and my stepdad. And I left, honestly, I was picking up some groceries on my way home because my kids needed something for the lunches. I know, don't judge me, but they needed something for the lunches. So I'm standing there in line and the cashier is looking at me. And I really think she thought I was like drunk or stoned or something because I could not make my change. Like I couldn't figure out in my pocketbook like how to pay for my stuff. And I remember she said to me, "Are you okay?" And that was probably the first time in my life I said to her, "No, I'm not. I'm not okay." Like something has to give. Something has to change. I can't keep doing this. Because, I was, just so you guys know, I was getting those groceries. I was going home, getting my kids up, putting them on the bus. I was taking a shower and I was going back to work. I hadn't slept all night. But I was raised on a farm and I was raised by people that you didn't complain to, like my parents, you did not complain to them. You were just taught that if you just worked harder, it would all be okay. And that's not true. So I started listening to things, trying things, reading books, attending seminars. And what I came up with all of that is chunking it. So chunking your time, energy, and presence. And we're just going to quickly talk about these. I added this slide with Brene Brown before we kind of talk about this is because I think, does anybody know who Brene Brown is? I assume this audience. So Brene Brown, best-selling author, great podcast. She does a lot of really great work about boundaries. But she says that compassionate people ask for what they need. They say no when they need to. And when they say yes, they mean it. They're compassionate because their boundaries kept them out of resentment. See, when we say yes too many times, then we resent the people. Right? And this is a great way. You have to, in order to do chunk it, you have to be able to say no. You have to have some boundaries. So chunk your time. I walk into my office on any given day and it has a calendar and I do exactly what's on there. If you're sitting here feeling like you have too much to do, a great thing to do, seriously, a great thing to do is sit down at your office on Monday and write down everything that you have to do and then find a time on your calendar to do it. And I know some of you are thinking, it won't fit. That's the point. Because if it doesn't fit, then decide what you don't have to do, what doesn't need to be done, what can be done by somebody else. And usually, to be honest with you, it's what can be done by somebody else. The second thing is often many of us are sabotaged by other people asking us questions. See, I see some people smiling. Who in here gets somebody in their office that comes in and says, "Do you have a quick second?" Yeah. No, I don't have a quick second. But thank you for taking me off of what I'm doing. It's going to take me 23 minutes to get back to where I was before. So you might as well ask me the question, right? I urge people, if you have people you have to interact with, send them to a meeting. At my office, nobody knocks on my door and says, "Do you have a quick second?" Because you know what? I don't. But everybody gets to talk to me. So we have meetings. One attorney talks to me every morning at 8 o'clock. Oh, I forgot about him this morning. I feel bad about that. But, my estate administration team, they get a half an hour of my time every Monday. My ECN, Elder Care Navigation team, they get a time with me every Thursday. And my expectation is they have their questions ready and they bring them to me. You have that ability. Now, maybe you can't be like me and be like, bring the questions Thursday at 9:30. But even people who you work with together, you have the ability to have a conversation with them and say, "Hey, it seems that we have to talk about things a lot. I'd love to talk to you, but can we schedule a time and we'll just talk about everything together then?" You can even do that with somebody who's your peer. I do that with people that are my peer. At my office, I have a law partner, Landon. Every Thursday at 12:30, Landon and I have time to talk. And instead of me interrupting his day, I write it down. And then when I see him at 12:30, we talk about it. You know, it's just a better way to do that. So understand time is finite. There's only so much time in a day. How you use it really, really matters. You do have control. The very first thing I ever saw written about this was called the 26-hour day. It was by an attorney, Tom Begley. Life-changing to me. Because his idea was that you can put 2 more hours in your day by following, you know, by time management. And I think that that's really important. Energy. Energy is finite too. We only have so much energy. Although we're going to learn a way to re-up your energy. When you think about energy as like the battery in your cell phone, when it's gone, it's gone. Energy is actually more important than time. Energy is what you end up having to deal with. So at my office, you know, I walk in before I even get up, you know, I walk in my office, I have to go up these steps. Before I get there, 3 people could come with me with a problem. This person is talking about that person, or I don't really have a lot of patience for those types of things. It wasn't my thing. Or somebody does something really dumb. How we respond, we have a choice in how we respond. So if we have feelings of negativity, resentment, anger, upset, that pulls down our battery much quicker. We can replenish it by making ourselves feel things such as gratitude and appreciation. We have a choice in that. We really do. I start my days every morning with a morning practice. I have a morning ritual, and part of it is gratitude. And I've been married 30 years. Any of you guys been married very long? Oh, yeah. I have never thought about divorcing him. I have thought about killing him. Numerous times. He knows that too. As Bob has seen me with my husband, I'm very like, are you shitting me right now? Whatever. One of the best things I ever did in my life, it was some tough years. Listen, there's no marriage here that there isn't. Well, maybe I've not heard of one. Mine had a lot of ups and downs. I shouldn't judge your guys's, right? 3 kids. My husband also, I didn't even get into this, but my husband also cared for his dad who had Alzheimer's for 14 years. He was his main caregiver. That was a huge stress to our marriage. He sold his business. But one of the best things I ever did was I got a gratitude journal, and in the morning, I'd write down one reason that I was thankful that he was in my life. I did that for 3 months, and I gave it to him on his birthday. And there was things in there that he would have never thought about, like, and I've reaped benefits from this. One of the things I wrote down is that he went and filled up my gas tank, my car, my Jeep. I hate getting gas. I don't know if you guys ever been to New Jersey. Well, I'm not going to be all that positive about New Jersey. When you live in Pennsylvania, Jersey's just like the drive-through state to get you to New York City, right? But the thing that I love about New Jersey is that they pump your gas for you. I love that. Anyways, I put in there, like, I was so appreciative that he did that to me. He's like, I can't believe you like even cared. I was just doing it. I was like, well, I just want to let you know, I really, really appreciate it. Man pumps my gas every time I get in my car. It's full of gas. So very, very helpful. But the idea is that, you know, your energy, you only have so much energy. And one of the biggest things we do is rehash. If you go home from work and your husband or your spouse says to you, how was your day? And you tell them how horrible it was, that's rehashing. All that does is steal your energy. That doesn't help you, and it doesn't help your spouse either. They actually didn't give a shit. Or they're going to be something stupid, like try to like give me the solution, which is even going to be worse. I didn't ask. You asked me how my day was. I didn't ask, so don't rehash. At your office, don't rehash. Something bad happened. To be honest with you, there's a lot of research about this. Like if somebody gets a cancer diagnosis, you shouldn't ask them to tell you their story. In fact, if you're helping the person who has that cancer diagnosis, you should protect them from having to re-say the story, because that's rehashing. It's actually even a little worse. It's like it borders on post-traumatic. You shouldn't do that. My daughter was diagnosed with cancer, and that was one of the things I was very strong about. I didn't want her to have to tell her story again. I would just cut people off, like don't ask. But rehashing is really important. But also, what is it that you can get rid of? Is there things that you don't like to do? Like I will tell you right now, I have so many things on automatic order. My dog food comes automatically every 6 weeks. I have an Amazon order. If you put like 5 or 6 things together, you get 15% off of everything. It's a really good deal if you look at it. I don't think about those things. It just happens. There's all kinds of things you can do in order to deal with your energy. So one of the things I wanted to make sure we have time for, and then I got chit-chat and I was doing good on time. But if you just, I want to slow down right now. Ooh, I am a little behind. I'm not going to skip this part though. So one of the things I wanted to talk to you about was heart math. And heart math is, it's one of the ways that I really was able to learn to redo my energy. And I'm just going to start, just going to have you do a little exercise. So I want everybody to stand up. Come on, stand up. While you stand up, I want you to think of something, some positive feeling. So in order to do heart math, I'm certified in doing this, and it took a long time, but we're going to do it in like 5 minutes, right? I want you to think of a good feeling like gratitude or just joyfulness. Now, for me, I can't actually just stand and be like, I'm joyful. Like I could never do that. So for me, I always had to think of something that brought that feeling to me. So for me, I have 2 things that I always go back to. One feeling is one time my son, who is now graduating from college, when he was in about 7th grade, he played basketball. And I had been out of town, and I flew in and walked into his basketball game, and this 7th grader boy puts the basketball down. They're just warming up, puts the basketball down, and comes over and gives me a hug. And there was another attorney there, and he said to me, what 7th grade boy does that in front of everybody? I was like, that's my son. So that's my memory. I go back to that. Or for me, my husband and I have this chair and a half, right? Because when you're younger, you just can sit on a chair together, right? When you're older, you need a chair and a half to do the same thing, right? So that's my safe space. Like, so the world has gotten me really down. I go upstairs and I crawl in that chair and a half with him. I hope he doesn't talk to me or try to solve my problems, but I just lay there. So I want you to think about, what is a happy feeling? You don't share it with anybody. Everybody just think about something. Either you can just say, I'm going to be gratitude, I'm just going to be joyful, or think about that. And then I want you to, while you have that, I want you to take some deep breaths. So breathe slowly, slow, deep breaths, just in and out. Slow, deep breaths. And imagine that your breath is actually coming out of your heart and up through your nose. This is called heart math. So we're breathing slow and deep, imagining that is coming right up out of our heart. And while we do that, continue slow, deep breaths. I want you to feel that positive emotion or think about that memory. Continue being slow and deep breaths. In and out. Slow,
deep breaths, and imagine that positive emotion. When you do this, when you combine slow breathing with positive emotions, your heart rate actually becomes more balanced and goes into what's called coherence, which makes your brain and your work better, and it actually reduces your stress. And what it does for your emotions and energy is it puts it back to neutral. You actually probably won't feel all that happy, but we will lose feelings of resentment and upset and anger. Slow, deep breaths in and out, and imagine that. Right, you can sit back down. So in my office, when somebody comes up to me and ticks me off, I don't yell back. I start breathing, slow, deep breaths, and bring myself back to center. And by doing that, I'm able to really, really go through my day. And at the end of the day, I don't feel exhausted. So I learned heart math because I actually had a problem with my heart. I've had AFib for about 18 years, and this has allowed me to live with that. Although I did recently have a procedure done, I lived 18 years by using this heart math. It's good for everybody, but it's very, very scientifically based. I urge you to think about when you're upset, when you're feeling exhausted, add a positive emotion and try not to rehash. Does it mean that your feelings aren't valid? It just means that it's not going to be helpful to anybody, particularly yourself. Chunking your presence. This is actually my favorite. What does it mean to be fully present? It means that when you're sitting in here, you're not on your phone. You're actually really here. And I have to tell you, Bob, like this audience, they are here. It's wonderful. It's actually wonderful. See, if I was out in Seattle with those attorneys, they wouldn't be there. They'd be on their phones, and, you know. But what does this mean for me? When I'm at work, I'm at work. My kids do not call me and ask me what's for dinner. My husband certainly doesn't call me and ask me something stupid. Joking. Just joking. But I put those boundaries in place. Like, seriously, if my kids call me, they knew, come get me. Like, somebody died. Right? But I give the same back to my family because when I leave my office, I don't think about work. See, the problem is too many of us spend our days at work worrying about stuff at home that we didn't get done. And then we go home, we worry about things at the office that we didn't get done. You're not serving either place well. And I'm not saying that any of this is easy. I certainly have fallen off the horse and had to get back on again, right? But I would urge you to be where you're at. If people come in your office to talk to you, be with them. Don't be halfway. I cannot stand it. If I go into one of my staff's office and they're halfway looking at me, halfway reading an email, drives me up a wall. Because you know what? They're not being respectful to me or the email. Both of us are probably going to get like a half-arsed answer, right? We want to make sure about that. At the end of the day, the only person that is ever going to respect us is ourselves. And only by respecting ourselves, we'll be able to do this. And I get that some of what I'm saying to you can feel uncomfortable as boundaries that we haven't done. But I would say to you, you can never expect people to put value on your work when you don't value yourself enough to put those uncomfortable boundaries in. And it's hard. But I think so important because the people that you serve and the people that you help really need you. And you have to be there for them in the best, most productive way possible. So how do we do this? Well, we want to stay inspired and connected. There's actually research from the Journal of American Medical Association that says having a strong sense of purpose can actually add 7 years onto your life expectancy. Caregiving for somebody with dementia takes away 5 to 7. So, you know, balance it out. That's right. That's right. So I said to you in the beginning when I got up here, thinking about like, why do you do what you do? Don't lose that why. Don't lose that. Don't isolate yourself. Now, I, like Bob, am very shy. I know up here you think I'm not, but I'd rather be up here talking to you like this than be at like a cocktail hour or having to have small talk with somebody. I'm just not that social. But it is important to stay connected. I actually did a TEDx talk about the fact that Alzheimer's in this country is made much worse because we isolate people who have diagnoses of dementia. The blue zones, if you've ever read about the blue zones, one of the things that in all of those zones they have in problem is that people are connected to community. So figure out how to connect with other people and people that you're not rehashing with, people that can lift you up. You know, for a time, my husband and I went through a time period where like we'd go out with other couples and it was like, I don't want to go out with them again. Right? It's hard to find a couple where you like the husband and the wife, right? You guys know what I mean. You know, I'm not being mean, but like you go out and you're like, oh my God. So we found this, we had one couple, it's actually my best friend since high school. And we would go out once a quarter. Now, it doesn't seem like very much, but it was actually hard to coordinate our schedules with everybody's kids and everything. But we kind of fought hard. And my husband and I went out once a quarter with them. And we have for years. That's really helpful to me. I know it's not a lot. It's once a quarter. We look forward to that. We're also kind of very like not fun people. We literally go out to dinner, they go home and we go home. Like there's nothing else. When we were younger, there would have been, but you know. Remember your why. It basically, you know, can lead to much better job satisfaction and resilience for yourself. So that's so important that we have that. We have that resilience. Don't stop learning. Hey, you're here, right? That's great. And the fact that Bob's office goes through all the work to get you guys in these seats is amazing. It's a testament to him and his team, because these are wonderful. And I hope you've had the ability. I hope you learned as much from each other and gotten to talk to all of the exhibitors. And I hope that you get, you know, something out of it. So how do we do this and really not just preserve where we are, but build a resilient future? And it's funny, my son graduated from High Point University and Jane Seymour was the commencement speaker. And she talked about resilience. I thought she had a great message for the graduates. It was basically all your plans for life, you know, good luck, you know, because life is not going to, you know, work out. But that's okay. So we want to be thinking about this. So the picture up here actually is a picture of glass that has been pounded by the ocean, and that glass that was very rigid, you know, becomes very smooth and quite lovely. And, you know, the idea is that, you know, we need to be resilient and allow that to happen to ourselves so that we're able to go in that manner. You will have to adapt to a changing landscape. What's going to happen in this country in the next couple of years is going to be interesting. As somebody who's pledged her life to helping those who are in the margins, people who have disabilities, people who are dealing with serious illness, it's something that, you know, we have to understand. How can we continue to best serve them within that changing landscape? I myself have chosen to become very vocal about it. You don't have to. You can choose to be very much doing the best you can within the system that you are. But don't let the system take you down. You do need to invest in your own future. The thing about this is that I think you can make big plans, like plan your whole future. And I'd urge everybody in here, if you don't have wills and powers of attorneys, there's a local law firm that could do that for you. And I do think that's really, really helpful because then you've taken that step. And if something happens to you, you have a plan in place. You can make small plans, like I talked about. You know what? For us women, a lot of times I spent a lot of my life working and raising my kids. In fact, one time my husband and I got into this epic argument about the fact that I didn't have any friends. It's not funny, Bob. Men do a much better job in staying connected. They do. And us women don't. That's our fault. So what did I do? I called up some friends I had, and I started going to lunch with them every once in a while. Now, for me, it wasn't about, I know a lot of people would say, oh, you need to go to women's weekend away. That really wasn't my thing. I did it once, and all I thought about was my son's basketball game. So for me, it was about being there in that chapter in my life. But, my college roommates and I, we get together twice a year, and I love those weekends. So we all have somebody. It could be a sister, an old friend. Reach out to them. They're just as lonely as you are. I urge you to leave your lasting impact, whether that's mentoring younger people in your office, even if they tick you off on a day-to-day basis because of everything they don't know. Remember, you were that person at some point in time. I spend a lot of time in my office mentoring the young attorneys, and I actually really enjoy it. But there could be something you care deeply about where you work and it hasn't happened. But I urge you to think about that. I think together that allows us to build a strong future. So for me, at the end of the day, I talked to you about the fact that, my daughter, Stephanie, had a diagnosis of cancer. She was at American University at the time. She was a senior at American University. And that was probably one of the toughest times in my life. And for the first time, I felt in a way that was so much different because I'd already cared for my stepdad and my father-in-law, but I didn't know. So she gets this diagnosis. She comes home and we're waiting to talk to the doctor. And the doctor's saying they're going to take my 22-year-old's colon out. And I don't know. And so we're waiting for the doctor, and we're waiting for this, and we're waiting for that. And of course, I'm Googling. Don't Google. You shouldn't do that. And the bottom line is that my husband and I decided that she wanted to go American and finish her senior year. And my husband and I decided that somehow we were going to make that happen. And so we made the decision that she would get treated in DC by a hospital there rather than our local hospital, which I won't name right now, but they're not high on my list. And, we had spent so much time just not knowing and not having a roadmap and not knowing the good, the bad, or the range. All we knew is that this kid might have surgery and that she had cancer. Until finally, one person called me. And she was a nurse navigator for the doctor we were going to meet in DC. And I vividly remember sitting on my front porch and sitting down and listening to this woman who, for the first time, could tell me what she thought might happen to my daughter. What was the range of things? What was the good, the bad? What was the possibility? What was the process going to look like? For the very first time. And I vowed at that moment that my office was going to up its game and be that navigator to other people. So when people are aging and they have a diagnosis of dementia or Alzheimer's or congestive heart failure, or they go to the hospital and somebody's, discharged and they don't know what to do, I urge all of you guys to be that navigator on a journey, because everybody, and you're part of the circle of care that you are, can help people navigate to the next stop or understand what the process is. And I think in this country right now, in the changing landscape, that's more important than ever. And in order for that to happen, you have to take care of yourself so you can be strong and resilient and help the people that you're here to serve. And so with that, I thank Bob Manor for inviting me up to his stage. I thank you for listening to me, and I encourage you all to go out there and do really good work. Thank you. Actions and insight, my call to action to you, one thing on here is for you. One thing. If you fill this out, one thing is for you. Okay, sorry.
Thank you so much. Let's give another round of applause for Julie. And before you leave the stage, we just wanted to offer you this gift on behalf of our whole entire team.
Thank you.
It's a basket full of Michigan-made items, so that way you can take a little piece of Michigan back to Pennsylvania with you. We'll ship it for you, so don't worry.
Oh, sorry, I had to drive.
Oh, well, great. There you go. Now you have snacks for the road, so it's beautiful.
I had a plane ticket, but yesterday I decided I had to drive.
Well, great. Everything works out then.
Yeah.
Perfect. Well, thank you again so much, Julie. We really just appreciate you, and I'm so happy that you could be here. So thanks again.
I also wanted to tell everybody that Julie waived her speaker fee for today. And so she said, instead, get everybody something. And so the request for the last few years was, we got all these wonderful exhibitors that have some great stuff. And the request was, how about, a bag to carry the stuff in? So Julie paid for the bags, basically.
Yeah. Thank you, Julie. So before we bring up our last speaker, I just wanted to give a quick, I don't want to say shout out, but just a quick nod to our next year event. We don't actually have a date for next year chosen. It will be in the springtime, about the same time as this event. But we are offering, if you do sign up today, I'm not kidding, I'm like really winded from doing the, hold on. If you sign up today or in the next couple of weeks, I'll email this to you too. Tickets are only $45 if you purchase them now. So again, we don't have a date. So there's kind of like that little weird thing there. We'll find out the date soon, but you'll be on the list. If we give you the date and it doesn't work, we can work that out. So, but yeah, go ahead. You can scan the QR code. We'll be emailing the link to you later as well. So there's that. And now I would go ahead and like to welcome our final presenters of the day, Attorney Kelly King-Penner, Attorney Bob Manor, and we also have Danielle Schwalibog. She's not on the slide, but I promise she's a part of the presentation. Yes, let's welcome them here. Thank you so much, you guys.
Okay, so this is always, I think, a kind of a fun part of the day. Kelly's portion is kind of boring, but my portion is great. But we like to talk about what's going on in elder law, and there's a lot of things going on. But, some of the things just kind of update you on court cases that we found interesting, things like that, and update you on some things that are just kind of continuing. As you know, Julie said, there's a lot of uncertainty right now, right? And so one of the things when we talk about hot topics is that advocacy part of it, and really trying to make sure that those that know are able to help those that don't have that experience. I remember one time, this was years ago, we had an appeal from a Medicaid matter that went through the regular administrative appeals and went up to a circuit court judge. And I thought, okay, well, this is great because this judge must have parents, right? Must have gone through this. Clearly, this circuit court judge didn't have any experience in with anybody that had dementia and anything that was associated with, home care or continuing care, because just didn't have any perspective of reality. And I think that's where some of our, the politicians are, frankly, is they don't have context of what you know about. And so I think it's about telling the story Both Kelly and I have been part of the board of directors. I was chair, so will be chair eventually of the elder law section of the State Bar of Michigan. And one of the things that we do, I think, very effectively is advocate for issues with the state legislature. And what we've learned a few things about how to do that. And the biggest thing is telling the story, right? It's not making a legal argument, which we do too, but with the legislature, no, they don't care about whether or not we're meeting the strict statute of the whatever.
Right.
But the stories are what influence people, and so we're going to get into a little bit of that by the end of the presentation. But let's start off with.
So you guys heard me talk about this today. So this is news in Michigan as far as estate planning. I don't always get to say that. Estate planning doesn't always change a whole lot, but when things change, it's one of the things we want to talk about. So I mentioned this earlier in our presentation that Michigan did pass this Uniform Durable Power of Attorney law. It went into effect July 1st of last year. Admittedly, I have some mixed feelings about it because yes, I want people to have access to these documents and make it easy and make sure that it's a document that's accessible. But at the same time, this is a really important legal document that people should not treat like you're filling out a form, your grocery store list or whatever it is. You want to be very particular about this. So this law went into effect. It's new. It's a baby law. We're still seeing the first year's worth of things. It is designed to make it easier to have these types of documents be accepted. That's great. It has an enforcement mechanism for when they are rejected. So how can we get the financial institutions to accept a validly executed uniform power of attorney? But we're still early on in these days with it. So as we see this law progress a little bit more, we'll be able to give you more feedback on it to see how it's actually being used, if it's good, if it needs some modification with it. But this is a significant change in Michigan. Now, what you may end up seeing in here as well is the financial institutions pushing back on powers of attorney that don't look like the standard form. Now, if they were executed appropriately prior to July 1st, they're still valid. We might have to do a little extra jumping through to make sure that they're being accepted, but they are still valid. Doesn't mean that there aren't going to be future challenges with it. So that's something we as advocates need to be prepared to talk about.
So the one thing real quick on this, that, the reason why we're getting nervous about the form is because it requires, there's probably potentially 40 different options that you can choose on this form.
Yeah.
And my guess is most people haven't thought about what authority they need to pass on to somebody in ways that are, contemplative of things like, well, what if we need to qualify for Medicaid? What if we what if the first person that we have, our spouse, is the person that actually needs the care? Mm-hmm. There's just so many things about the form that could be filled out insufficiently. There was a question earlier online for one of our online viewers that asked, where do you find the form? And the answer is, it's actually right in the statute.
Yeah, it's exactly in the statute. You can pull it up. I'm sure if you looked at Michigan Uniform Power of Attorney, you would find something really consistent. Do be aware that there are a bunch of warnings peppered through there about getting good legal advice. Because like what Bob mentioned, you don't know what authority you might need to empower someone until you actually need it. And if you read through those extraordinary powers, for example, you're going to look at it and be like, why on God's green earth would I ever grant somebody authority for that? The answer would be in a long-term care crisis, because in order to take advantage of the safe harbors that are built within the law, we need to work with people that are empowered to do certain things. And that's the most important document that you can have. Guardianship reform. So yet another full circle moment for me here. Earlier today, we talked a lot about guardianship, and specifically the state of Michigan in the guardianship reform efforts. This case, while not technically a guardianship case at its presentation, is really about guardianship reform. So the case of Findling versus Auto Owners Insurance Company, which really has very little to do with insurance, is focused on professional guardians. So in the case, Finling was a professional guardian. Anyone that serves in that professional guardian role knows that they have to have a staff. You can't be everywhere at all times. So a lot of times they have staff members that they rely on in order to fulfill servicing these roles. Well, the case of Finling versus Auto Owners Insurance Company was really focused on what duties and what powers can be delegated to staff from a professional guardian and which ones they have to keep for themselves. So this is really the court clarifying and holding these things to the fire. Now, again, trying to scoop up those bad seeds, sometimes you're going to make it harder for good seeds to grow and prosper in this area. So when we see cases like this, yes, it's good to scoop out all the bad things that are happening, but this will make a harder landscape for professional fiduciaries moving forward.
And, you know, it's tough with the professional fiduciaries, professional guardians, because first of all, they're under a lot of criticism and probably justifiably so, right?
Okay.
But the problem is when we need them, and there's less and less of them. And so there's, you know, it's going to come to a head where we got to come up with some solution in Michigan. They talked about having an Office of the State Guardianship.
They're still kicking it around, yeah.
It hasn't happened yet.
Yeah, they're still kicking it around because you touch one thing in the legislation and 18 other things are affected by it.
Okay, so this is kind of cool for our own Kelly King Penner. So I've talked for years, or we've talked for years about this idea that if you hire someone in your home and then later on need to file for Medicaid, they might penalize you if you didn't jump through a bunch of hoops and have a notarized contract with that caregiver and all this other stuff. It's a ridiculous rule, okay? We're going to talk about it a little bit later. We're trying to fight that in the legislature. We've tried to fight it administratively. And now we have a friend of ours that is fighting it in the court system. It is up to the Court of Appeals level, I believe.
Yes.
And so the cool part is that in important cases that have that are important beyond the scope of just Carla Brown. So this is about the estate of Carla Brown. But in important cases that go beyond the person that is involved in the case and the agency involved in the case, sometimes the court will allow interest groups to weigh in and say, this has a bigger societal value. Your decision in this case has a bigger societal value than just the parties of this case. And then they allow the organization to file a brief explaining why this isn't just about Carla Brown. This is about the all seniors basically. And so the State Bar of Michigan Elder Law Section and the National Academy of Elder Law Attorneys petitioned to be able to have a brief filed in this, trying to explain to the Court of Appeals judges that this is an important case and that they need to consider the societal impact on it. And who do they think they asked to write that brief? Our own Kelly King Penner was asked and authored the brief.
It was fun.
We do not have a hearing on
No,
this case yet.
anyone who has ever dealt with the court system, it moves really, really slow. Carla Brown was actually still living when all of this started, and she has since passed. We'll know more hopefully later this year, but it might be later in the summer before the court actually hears it for oral argument, and then sometime afterwards before we get an opinion. All right, guardian obstructing visitation. Again, more in the realm of guardianship reform. This is in re guardianship of AMS. So we talked about this a little bit, or we alluded about this earlier in terms of when guardians are not doing or aren't being perceived to do what they're supposed to do. What is the mechanism that the court has to follow in order to get that person removed? And in this case, the probate court heard the case of where the spouse, who was also the guardian, was replaced with a professional guardian because there were some allegations that the spouse was alienating the ward from family members. Now, whether or not that's true, I'm not sure, but the court in this case made a couple missteps. And the biggest missteps that they did is that they just automatically kind of went in there allegation-wise, and they're like, all right, spouse, you're no longer guardian. We're going to appoint this other third party involved with it. Well, you can do that, but you have to follow the proper procedures for that. You can't just remove the spouse without notice to say, hey, there's a fight, so we're just going to take you down and you're going to go sit over here. You also have to have specific findings that what they're doing is unsuitable. You can't just accept the allegations as true. The court has to make findings of particular fact that what the guardian was doing was inappropriate in order to remove them. And then on top of it, the court just can't ignore the priority that's set forth in the statute. So in terms of the closest people next to serve, and appoint it with a third party. So in this case, it's really holding the probate courts much more accountable to the procedures and the system that is set up in the act. And that is a form of guardianship reform, because far too often we were seeing that a lot of these cases were just being rubber stamped. And if there was any inkling of family fighting, they would just take it and give it to a professional person who doesn't really know that person that well. And especially in circumstances where family is suitable, family should be allowed to take care of family as long as everybody's needs are being met. So the court got knocked around a little bit on this, but I think overall this is a pro in terms of guardianship reform.
On the same concept here of whether or not somebody can prevent their relatives from come visiting mom, this is a big controversial thing, right? Mm-hmm. And I think last year during Hot Topics we talked about this, that law did get passed in Michigan.
Yeah, the Casey Kasem law did get passed in Michigan. Yes.
So it's so that there's a mechanism if you're being denied the ability to see your mom, and it was Carrie
Kasem.
Carrie Kasem was the daughter of Casey Kasem, and for the younger people who have no idea, my wife still listens to the Casey Kasem Top 40 on Sundays, and he's been dead for years, but it's it's the 80, anyway. It was there's a mechanism if you're being denied the opportunity to visit your loved one to have the court look into that now.
All right, more in the realms of guardianship. It's just been a hot year in terms of guardianship reform cases. So this was interesting because this is something that Bob and I kick around a lot in terms of what a person who is deemed to be legally incapacitated, so a person subject to a guardianship, what they're allowed to do. In the case of JLD v. Nowak, the court found that just because you have a guardian appointed doesn't necessarily remove your ability to create a will, to decide what stuff you have and where it goes and who's going to be in charge. So simply having a guardianship in place did not eliminate that person's ability to execute a valid will.
I find this case really interesting because one of the things that comes up when somebody has an appointed guardian, if they don't think they need a guardian, how do they get rid of that guardianship? And I have sort of an answer for you, but we've had a few times where somebody would call up who's under a guardianship. Mm-hmm. They're what they call the ward. Mm-hmm. Again, kind of weird language, but the ward under guardianship. And they wanted to hire a lawyer to dispute the guardianship after, not before it was they were assigned a guardian, but after. They can't contract. They can't hire a lawyer because they can't contract. So you can't even hire a lawyer to dispute your guardianship because that's been taken away from you.
Yeah, they're very challenging gray areas at times.
And so my answer on that was always write a letter to the judge. The judge will appoint you a lawyer. You can even say, I would like this lawyer to be appointed or whatever. But the idea is that that's the way to do that is write a letter to the judge. Then the other thing is, I just thought that was interesting that you can't hire a lawyer, but you can write a will. So interesting.
Bob, we have a comment.
From Medji.
Yes. Oh, awesome.
I think, so the court can appoint a lawyer with the note, and also legal aid can assist depending on your local legal aid office. Perfect. So the Michigan Elder Justice Initiative, I'm a legal aid attorney. Excellent. Currently working on the guardianship diversion project, but absolutely, anybody is allowed to have a lawyer even if they're under guardianship.
Yeah,
that's excellent. The point out, and you make an excellent case, and I hadn't even thought of that. That's a great idea. I should have thought of that. The point is that if you're under a guardianship, you can't sign a contract. So if you can't sign a contract, you can't hire a lawyer. But if you don't have to hire them because they're legal aid, I don't think we told you Nick comes to us with 10 years of experience. He was over at Eastern Michigan Legal Services for
Mhm.
10 years. So they've actually worked together. So he's in a different county than Nick was, but Nick has a lot of great experience on that.
No, and that's really one of the purposes for organizations like the Michigan Elder Justice Initiative is to provide resources for these individuals. All right. Once again, court needs to follow the proper procedures. So you can't appoint a temporary guardian where there is an agent acting under a valid financial power of attorney or a patient advocate power of attorney simply based on allegations. We have to go through the process for this. So in Re J.E.K. So J.E.K. was an older gentleman. Later, he ended up in a facility and then later had to end up in a nursing home. Prior to him going into the facility, I believe he appointed his friend Paul as his agent under his financial power of attorney and healthcare power of attorney. Paul then went on a European vacation for an extended period of time. Unreasonable, debatable. But he became very difficult to reach. The facility was having care issues with J.E.K. where he needed to look at nursing home, higher levels of care, and Paul was just largely non-responsive, or at least that's what the allegations were. The facility, not sure what to do, reached out to J.E.K.'s other friend, Susan, who had visited and was involved, saying, hey, we've got some increasing care needs. We don't know what to do. We can't get a hold of the guardian. Susan went in or get a hold of the agent. Susan went in and filed for guardianship and conservatorship. The probate court suspended Paul, which again, they can do so long as they go through the proper procedures. They just automatically suspended Paul and appointed an independent temporary guardian. Court of Appeals said, probate court, you can't do that. You have to prove that that person is unsuitable and make specific findings as to their unsuitability before you just remove them and replace someone else. What's not mentioned in this case, but is probably kicked around again, is that you can't also ignore the other provisions. Is there someone else with higher priority? All of those things that need to be considered. Under the statute, an agent appointed under a financial or healthcare power of attorney actually does have higher priority to serve in these roles than other people. So even if we're alleging that Paul is inappropriate, he still had higher priority than an independent guardian. You have to follow the process and make the findings first. We can't act first without going through those procedures. So what we're seeing here is more consistent stuff with the probate courts being pushed into following what the law is actually supposed to provide. And these mechanisms are here for a reason. Now, does it always work perfectly? No. But the mechanisms are designed to keep people involved that should be involved and to make sure that we're just not making decisions off of allegations. All right. This case is actually very convoluted. It's an interesting read if you like kind of.
You're a lawyer geek. Yeah.
Yeah. If you are, come talk to me. I'll talk to you about this case. It's fine. This is actually more of a case of conversion, which is the fancy lawyer term for you took my money. But the more important part of this that I always like to highlight is around the taking of the money, there was some very bad deeds in here. And I don't mean like bad acts. I mean actually bad transfers of real property.
Poorly written.
Poorly written or poorly followed through deeds. So in this case, individual A wanted to individual A and B owned property together. A was like, I don't want to be a part of this anymore. I'm going to transfer my interest over to B. So pulled off a deed from God knows where, wasn't notarized, wasn't witnessed, wasn't recorded. And now was this one of the parts of this case, which I don't even want to know what the legal fees were involved with this because this got kicked around quite a bit and ended up not working out so well for B because it was treated kind of haphazardly. Now it cost both sides a lot of money, a lot of stress, and a lot of time. The whole point that I want to highlight with this case is do not treat deeds or real estate transfers as an informal arrangement. Yes, I know you can go to the Register of Deeds and pull out a form that's one page. How hard could it be? I will tell you that on a very consistent basis, I am having to fix a lot of these issues, and the legal fees for it go thousands, if not tens of thousands of dollars, and a year or more in time fixing it. So it seems really easy to start. It can have really bad consequences if you don't know the ramifications of it.
So, we have this conversation with our clients all the time when, does something look simple or is it simple?
Right.
It might look simple because it's one page. Whereas we haven't talked about this very much today, but trusts, if you guys are familiar with trust is just a contract between you and your family. That's all a trust is a contract. It's kind of like a substitute for a will, but really it's just a contract where you're empowering your family. So we don't need to have the court empower the family when you're needed. So trust is a contract. Trust looks complicated. A well-written trust is probably 60 pages. Okay.
Right.
And it looks complicated, but it's supposed to make things easier and keep things in the family. It's a contract where you're empowering your family to do the things you need them to do if you get sick or when you die. Okay. And you're empowering. So now we don't need a judge to empower them. So that is to create simplicity, but it looks complicated. A deed looks simple, but causes all kinds of complications.
Yep.
Literally one or two words different, sometimes one word different will change the entire meaning of it. If you leave off the words, then the state assumes it's a certain way. It's called tenants in common. If you don't say how it's going to be owned, it's called tenants. It's assumed to be tenants in common, which is often what people don't want. Okay, and the idea is just a couple of phrases, a couple of words different can completely change the meaning of the deed. And so our answer is don't do them. Yeah. Even ladybird deeds are often not a good idea. And so they seem simple. You say, okay, that's just like putting a beneficiary on your bank account or your life insurance. Sounds simple. You can't divide up a house as well as you can divide up a life insurance account. Life insurance, okay, $10,000, you each get $5,000. How do you divide up the house? It's not that easy. There's a lot more complications to it.
I always say if you've got 5 people that are trying to decide where to go to dinner,
Yeah.
is everybody going to agree? Try doing that with a large asset that you can't take a chainsaw to. So just be cautious in doing these things. And when in doubt, get the legal advice for it. Ooh, I'm excited about this one. So much like Bob and Amy, how they talked about, there was a number that changed in the Medicaid or in the context that hadn't changed in like 50 years. Something changed with Social Security benefits, the Social Security benefit known as SSI or Supplemental Security Income that hadn't changed in a really long time. And I actually think it's a really good change. So SSI is designed to provide a monthly benefit to individuals that didn't necessarily have enough quarters of coverage or work history to get into the Social Security system. And they were disabled younger, usually, or a series of different things. We're not talking about a huge benefit. The max benefit for a single person in 2025 is $967 a month. So not a huge one. But what SSI did, though, is they said, okay, we're going to provide you this monthly benefit. But if any third party is providing you with necessities, because this is what this $967 a month is designed to do, is to provide you with the necessities that you need, we're going to penalize you for a third party paying for those necessities. And they had these necessities designed as food, clothing, and shelter. They're not always the best at defining what those things mean. Well, at its heart, that could mean that somebody who was receiving SSI benefits couldn't be treated to dinner because that might reduce their monthly benefit that they're receiving. So what SSI finally went around and did was removed food from this list of necessities. Because again, we're talking that $967 a month is to pay for somebody's food, clothing, and shelter. I don't know how many of you have been grocery shopping lately. My 6-year-old that plows through a Costco order in one weekend, it's really easy to see how someone cannot sustain themselves if that is designed to pay for their food, their clothing, and their shelter. Rent is usually more than $900 a month. So this was a great change. So hopefully this is signs of more things to come with catching up with some of these archaic numbers and changes that we haven't adjusted. But I'm really excited about this case. Or not case, rule change.
So this is a weird case. It is unpublished. So when the Court of Appeals, so the Supreme Court of Michigan, when they make a decision, it's all published. It has what they call precedential value, meaning other courts have to pay attention to it. When the Court of Appeals makes a decision, they can either make it published where they say this has precedential value, meaning other judges should follow it, or they can make it unpublished where it's not binding on other judges or other courts. It is persuasion?
Persuasive.
Persuasive. And so this is considered a persuasive opinion, not it's only binding on the parties to this action. But it's pretty weird.
It is.
Because pretty much if you followed the strict conclusion here, nearly everything we do in our office could be set aside by a handwriting expert. Because here's what happened. So what did I write down?
Jerry.
Jerry.
It's Jerry.
Jerry, had done some planning through the years and he had done a trust. Remember, that's a contract between you and your family. It can be a will substitute, and you can amend a trust. And so this was intended to be the third amendment. And Jerry died, and then someone claimed that Jerry actually didn't sign it. Okay, well, that's interesting. What evidence was there that Jerry signed it? Well, 3 people in the room testified that he signed it, including a notary. So 2 witnesses and a notary all testified Jerry signed this document. Handwriting expert was called, and the handwriting expert said, oh, it's definitely not Jerry's signature. I don't know about you. My signature changes every time. And especially, we see this all the times with our clients as we age, or maybe we have some medical issues or memory issues or things like that. It might not look anything like our previous signatures. And so both the trial court and the Court of Appeals decided with the handwriting expert over the 3 people that testified they were in the room and that Jerry signed it. So pretty much, I don't think they would do it if it was signed in a law office, but in theory, everything that we do in our office that's ever signed by 2 witnesses and a notary could be thrown out by a handwriting expert. It just kind of seems like an absurd conclusion. And so it goes to one other point, and this is me getting up on my soapbox for a second. Probate is supposed to be, or in my mind, probate courts should be different than the regular courts. They call them circuit courts or district courts, where they decide criminal actions and divorces and lawsuits and all this stuff. Probate court was always supposed to be designed differently, where we're dealing with family matters, we're dealing with estates, we're dealing with guardianships. And traditionally, probate court is a little, I'd say, informal, a lot more informal than the other types of courts.
Yeah, more people-centered.
Here's my soapbox issue. We keep electing prosecutors to be probate court judges. Not in Genesee County. I'm not talking about Genesee County. But throughout the state, we often are electing prosecutors to be probate judges who've maybe never written a will or maybe never read a will. Maybe aren't sure what the difference between a will and a trust is. And I'm exaggerating slightly, probably. But if it's a prosecutor, they don't have experience. And so we just had a friend of ours that was running for judge in Macomb County.
Yeah.
It was a new judgeship, a new probate judge. Very well qualified elder law attorney. We need to get more elder law attorneys on the bench. I'm not doing it. I would hate that. It seems like a terrible job to me. I would never want to be a judge. Kelly says that maybe she would be, even 20 years from now or something. But I would hate that job. But anyway, there was a really qualified elder law attorney that knows all the type of stuff we've been talking about, and he lost to the prosecutor in Macomb County, and that's a shame in my view, because I think we just need more people that know their stuff on the bench.
So pay attention to your local judges. I know that's usually the back part of the ballot that comes around. Research those people. The ones in our community actually impact us the most. That second side of the ballot is really important.
And I do want to specify for those that are local, this has nothing to do with Genesee County probate. I was really referencing other counties.
We have some excellent judges in Genesee County.
Okay. So we did a whole hour on this last year, and I put it in hot topics because this really is kind of a hot topic. So Julie talked about this. You know how she was talking about the nurse navigator? Well, we kind of do this. We've been doing this for a few years, partly at Julie's urging, right? I told you earlier about how I said we weren't going to hire any social workers, and then they came back and hired 2 social workers. Well, our social workers in our office are called care navigators. And so I wanted to have Danielle kind of talk you through what care navigation looks like in our office.
Okay, so I think it's important to start off by what is care navigation. And so it focuses on the individual by guiding and supporting patients throughout their healthcare journey. But in particular, elder care navigation is a service or support system designed to help older adults and their families manage the often complex and confusing landscape of aging-related care. It involves guiding seniors through healthcare, housing, financial, legal, and social service options to ensure they receive appropriate and timely support. Care navigators, who could be nurses, social workers, or trained specialists, help coordinate medical appointments, explain insurance coverage, connect elders to community resources, and advocate for their needs across various settings. This personalized assistance can reduce stress, improve health outcomes, and help elders maintain independence for as long as possible. And so what do we do? Well, we can help families understand options by breaking down complex medical details into understandable, clear terms. I don't know how many times I've gone to the doctor for my kids lately because it seems like they're always sick. And they tell me something and I'm like, what is that? I have no idea. And I think I'm pretty well versed in the medical field. I still don't understand sometimes. We can help make informed decisions by empowering and educating our clients and families to make confident choices about care needs. Sometimes we have to have those tough conversations. Is hospice an option? Do we need to look at placing mom or dad? Is it a conversation that it's no longer safe anymore and we really need to try and get everybody on board? We can help with access to the right care, such as finding a specialist, scheduling appointments, and coordinating care across providers. I've seen it many, many times before with our elderly clients. They go to a specialist, they order equipment. Now they have to go to a DME company and get the equipment. Then they go back to their primary care doctor, and the primary care doctor has no idea what the specialist said. Where's that gap in that communication? And so we help bridge that to make sure everybody's on the same page. And lastly, advocacy and support. We do this by ensuring our clients' voices are heard and their needs are met. Nobody wants to be in a nursing home on their last days. We want to make sure that they get the care that they deserve. So what are the benefits? It's more than simply making healthcare easier. It's about improved healthcare outcomes. Clients are more likely to adhere to treatment plans, experience better chronic disease management, and most importantly, lower hospital readmission rates. As we know, that is being scrutinized every day. And imagine if we could lower that rate. How happy would the CEOs of the hospital be? We can reduce costs by optimizing care pathways, and we help with overcoming barriers to care, such as lack of knowledge and financial constraints. And last, we have enhanced client satisfaction. If a client's family and a client feels supported and empowered throughout their healthcare journey, it leads to higher client satisfaction and loyalty. They go to the hospital, they get good care. They're going to come back to that hospital. Go to the rehab facility, get good care, get good response time. They're going to come back. And your client satisfaction survey scores are going to go up, which I know that is being scrutinized as well. So who can benefit from this? Really anybody could. Like Julie talked about earlier in her presentation, she had the nurse navigator for her daughter who was 21. But most importantly, It's our elderly population. Imagine that you're at the ER. You're alone. You're by yourself because you had to call 911 because something happened and your family's not around to help you. You forgot your hearing aid, so you can't hear anybody talking to you because now you were rushed and the ambulance took you away so fast. You've got doctors and nurses talking about what's going on, what they're going to do for you, your treatment plan, and you have no idea what's happening around you. And you aren't going to be able to relay that information to your family. So we get involved. We make sure that throughout that scary time, there is no confusion, that communication comes a long way and that you're informed in making the decisions with your family. We kind of already talked about this a little bit, but services provided by care navigators. So we do assessment and education. How important is it to educate people on their diagnosis? Doctors are in and out in your office in 5-10 minutes, and you don't really get a lot of education. So we really spend time by sitting down with them, educating them about their diagnosis, what to expect, especially with families who are uncertain, who have never gone through this before. Again, going back to that advocacy and support, we're helping them navigate through this entire process. We're supporting them. Sometimes there's insurance issues. Constantly get phone calls. I got a bill in the mail. What do I do with it? Bring it to me. Let me look at it. Let me help you through this and we'll figure it out together. And care coordination, making sure again that everybody across the same board is working together for one outcome. I think that's my last slide, but I have something else to say. Most importantly, our elderly population is vulnerable. So elders without care navigation often face significant challenges that can lead to poor health outcomes and diminished quality of life. Without guidance through the complex web of healthcare services, insurance options, and community resources, they may miss essential medical appointments, misunderstand treatment plans, or fail to access the necessary support services like transportation or home care. This lack of coordination can result in preventable hospitalizations, medication errors, and increased stress for both the elder and their families. Ultimately, the absence of care navigation leaves many older adults vulnerable, isolated, and unable to maintain their independence. So this program is very needed and it is up and coming. We've seen a huge increase even across the United States and more attorneys even doing this program. And so I really value, Julie talked about, why do you do your job? I value it because I can finally be on the good side. I feel like I don't have a corporate standing behind me telling me that person can't stay long-term here. I can finally advocate correctly for my clients and my families.
Okay, so before I get into the last couple segments here, I want to commit that we're going to get you out on time. But once I'm done, we've got some logistics and cleanup to do. So if you are licensed, we want to make sure we get you your credit hours. So Savannah will come up and give you some instructions. And so it's really important that when we're done, for everybody's sake, whether you're licensed or not licensed, that we just stay seated. It'll only take a few minutes. Probably going to get you out here a few minutes early, actually. But the idea is, even if you're not licensed, first of all, you get a certificate. But for the benefit of the people that are licensed, if you can just kind of hang out here quietly for a couple minutes while Savannah goes through and explains it, you'll get your certificate even if you're not licensed. But that will allow them to efficiently get that. I'm always amazed at how efficient we are at that process. Yeah. So we divide it. She'll tell you in a minute, but we divide it by the alphabet, by your last name, and we get people out of here really quickly. And there's a treat on the way out too. So, clicker.
I have a clicker.
I'll take it.
All right.
All right. So what's old is new again. And so I was thinking about this year, and I was feeling that for those of you that have been to boot camp for several years, you might start getting frustrated with me because I keep talking about the same advocacy things. And it's like, okay, Bob, there's optimism, and then there's Pollyannaism, where you're just so optimistic. It's like, is this ever going to change? Are we ever going to make any progress on this? And the answer is, I'm not giving up. I'm just not giving up. I do think that there's a possibility of change. So let's talk about the things that I've talked about for years. And then I want to spend a little bit of time on, tips for advocacy. So remote witnessing and notary.
It's still here. We're working on it.
It is one of those things that a lot of people just don't understand. And so we found that this is very true for a lot of the folks in the legislature, but a lot of attorneys too. They're like, well, why do we need this? And there was a law that they tried to pass a couple of years ago by one of those online companies, was the one that was sponsoring the law. And they were online wills or whatever. And they wanted it to be so you could do a remote will in your room by yourself with, and there was no safety protections in there. It really could have resulted in a whole lot of fraud. So our organization came out against it, and it didn't pass. And which is great, in our view, great. So now I said, okay, it's really important that we have remote witnessing and remote notary. And then the one bill that did come across, we tanked, and it was intentional. Because when we had remote witnessing and remote notary at the beginning of COVID, so we had first a governor's order, and then for the better part of a year, the legislature kind of backed it up and said, yes, this is the law. But it was one of those expiring laws, sunset laws. So it's not on the books anymore. But it required a whole lot.
Yeah.
It required so much that I wouldn't do it. Kelly did I
did over 60 of them.
60 of these. And so you had to record it. You had to get them on screen. There was a whole lot of things. We got to keep the recording for 10 years.
Yeah.
It was a whole lot of better protections than we have in most witnesses and notaries. Okay. And it's important that we have, now there is an online notary option or a remote notary option. But that doesn't help us for the documents that need to be witnessed, okay? And we can't control it. Back when we had this remote witnessing notary, we could control the signing. Right now, under the remote notary, we have to hire a company, and they're the notary, and they control it. And it's just not very efficient, and it's expensive.
And they're not always the most easy things to navigate. It's tech, right? And if you're dealing with families that are not super tech friendly, the laws as they stand aren't really designed to be facilitated. So the law that we've been trying to get passed for some time makes it a lot easier for professionals to help facilitate this. And the witnessing is really where it's key, because the healthcare power of attorney doesn't matter if it's notarized. It has to have two witnesses. So the fact that we have remote notarization in Michigan helps a little bit, but not where it comes to these significantly important patient advocates.
So our friends in the probate bar often, when we took this to them to get them to also push for this law, a lot of the lawyers were like, well, why do you need it? If COVID's over, why do we need it? And the answer is, you guys know, we've got a lot of people that can't leave their house very easily. We got a lot of people that, what do they have? C. diff? Was Wendy here? Yeah. Yeah, we showed up at a hospital one time, and they're like, okay, put on this hazmat suit. And we're like, would have been nice if you warned us.
You can tell that they're not healthcare savvy.
No.
Yeah. And so, okay, so you get it. That's why we need it. There's no current pending legislation on that, but
it has not been reintroduced yet.
We'll get it submitted. We got some friendly legislators who have promised that they will resubmit it. So far, it really hasn't got out of committee.
Yeah.
Care contract legislation. We talked about this a little bit earlier. So if you remember, again, I'm going to sound like a broken record for those who have been here year after year, but this all started with Betty Jensen. So Betty had some dementia, and she really wanted to stay home. Sounds like almost all of our clients, right? She really wanted to stay home. She didn't have very much. She had a very modest house and very little money, but she wanted to figure out how to stay home. And so she hired, she didn't hire. She had some help from her grandson, Jason. So Jason was helping her out the best he could. But then Jason realized, well, he can't do it completely. So they got a neighbor to come in and help out. And so they, of course, had to pay that neighbor. But it was way, way under market rate, right? It was $18,000 over 11 months. Okay. And it was, it was a lot of care. And so that's not market rate by any means. And Betty was not a rich person. She had very little money to work with. And eventually she did have to go into a nursing home and apply for Medicaid. And so they said, well, when you reimbursed your nephew for picking up prescriptions and for gas, for gas to come over, and when you paid your neighbor so that you didn't have to go to a nursing home, because you didn't have notarized contracts that were signed by a doctor, we're going to penalize you as if you had just gifted that money away. I am confident that that is not the way that the rules were written back then, back when Betty Jensen applied for Medicaid. And that unfortunately it went through the whole court process, went through the administrative process, got up to the Court of Appeals. So it must have gone through a circuit court and got up to the Court of Appeals. Court of Appeals said, no, that's it. The local judge basically said, you can't penalize Betty for this. She's trying to stay in her home. She's trying to stay off of Medicaid. And why would you pick her? You're not picking the person that has $500,000 that's doing this. You're picking the person that has almost no money, that was just trying to stay home. And so the local judge said, no, you can't penalize her for this. Went up to the Court of Appeals, and the Court of Appeals said, well, we don't like it, but we think that's what the regulation says. And so if they want to penalize, if the Department of Health and Human Services wants to penalize her, they can. I think the judges were wrong. It was not appealed. And then what was worse is they went back and changed the rule to be compliant with the court case. And so now it is the rule that says you have to have a notarized contract signed by your doctor, itemized as far as what the home care people are doing. So we've been fighting this for years, right? And fighting it on every battlefield that we can. We set up meetings with the department. We've set up meetings. We had a meeting with the Attorney General, which went really well. We've had a meeting. We have somebody in the governor's office. All of these things go well, and it just doesn't ever. We haven't gotten across the finish line. So then last year or the year before, our section of the state bar drafted legislation that said, okay, if they're not going to take us seriously, let's draft legislation. And it was pending, and now it's been reintroduced for this session.
Yep. So it's Senate Bill 266 is how it's been currently introduced in the Michigan legislature currently. It died in lame duck. It really should have passed, but the legislature really wasn't playing ball.
There's nobody on either side of the aisle that could argue about this, right? The idea is that to stay off of Medicaid, to pay somebody to stay in your own home, it doesn't make sense that you would penalize somebody so that you're forcing somebody into a nursing home sooner so that the state can spend more money on it. That makes no sense. No Republican or Democrat, if we explain it to them like that, is going to, if I just tell them Betty's story, I don't even need, I'd love to have your stories, but if I tell them Betty's story, anybody on any side of the aisle is going to say, well, that's ridiculous. Why would we force somebody on Medicaid too soon when they could be in their home for a little bit longer? It just doesn't make any sense. It's just hard to get people's attention.
And that's where, truly, if you have a call for advocacy, this is reaching out to your local representatives in the Michigan legislature to give them your stories for how this dramatically impacts family members, because that's what's going to change this law is people and seeing how this affects everyday people. This isn't millionaires. This is everyone.
And this is the case that Kelly wrote the brief on. So our friend Susie Shelgin, many of you might know the Shelgin law firm, but Susie is the attorney that's arguing the case, and then
on behalf of the estate of Carla Brown.
On behalf of the person, and then Kelly wrote the brief on behalf of the organization. So there's a quick question.
Yes, it's a Michigan legislature. It's a Michigan bill that we're trying to pass. What is interesting, though, as a side note, is the policy that is contained is actually not authorized in federal law. They've just made it up.
It's against the rules. It's against federal law, which is why there's the court case. Yeah. Your
your
rep.
local state representative and state senator.
So we have a excellent lobbyist that
Mhm.
works for
Capital
our section of the
Services.
bar and Capital Services, yeah. And they've done training for us a number of times. And the answer that what they always tell us is you're going to get the most attention by your representative where you live. And so you got the state senator and you got your state representative, and that they're the ones. And so when you approach them, you say, I live in your district. And I'm a social worker, you know, whatever. They have coffee hours. You
Yeah,
can
they
talk to
usually
them.
have constituent
Yeah.
events where you can meet with them, but tell them your stories. Truly, that's what's going to make a difference.
So we're still pursuing that on every way. Now, what if you're stuck? What if you get a situation where somebody's penalized for that? Sometimes we can help.
Yeah.
There might be workarounds. Where we get creative. Sometimes we can come up with a way to work around that penalty. But just, you know, the best answer would be let's get the rule changed. And this is what gets frustrating. Like no rational person would think that this is a good rule. And I'm not, you know, we I don't like this, but we hear sometimes on the federal level, they talk about deep state and all the bureaucrats that are deep state. This is kind of a deep state, you know, issue in Michigan of there's been so many bureaucrats in the department that have been there forever and they just make rules, but without really thinking about the consequences and how really who would support that. So quick question. Yeah. It's specifically related to personal care, not home maintenance, not lawn, not a housekeeper.
No. And that's what's interesting about the law is that it's clearly judging people for trying to stay out of facilities.
Yeah. So get dressing,
Care
undressing.
contract and personal care services. Yes. Yep.
Last one that we keep coming up again and again, and this has been my pet project forever, and can't say that we've made a whole lot of progress, but I really think there should not be an income limit for PACE and waiver, and if there is, it should be higher. It's so unfair. It's so unfair that in the state of Michigan, which was the labor, you know, this is where unions made their stand, and we've got pensions, and we got the 8-day, you know, work day and the 40-hour work week, and we got pensions, and so now we're penalizing people that get pensions because they make a couple dollars more because they get their pension, and now they can't get on PACE or waiver. They can't stay in their own home. They run out of money. They can't stay in their own home because they worked for GM instead of for, you know, whoever.
They're one penny over that income limit.
Yeah. And we've seen the number of ones recently that was literally within dollars and they're over. And so it makes no sense. Most states, including Pennsylvania, where Julie came from, have figured out a workaround. Okay. And then the federal government has said, you don't even have to figure out a workaround. You just have to ask permission. They came out in 2020, the CMS came out, gave guidance to the states that says, all you have to do is ask and we'll raise that income limit, or you can get rid of it altogether. So we just have to get the right people to ask. Okay. And so there's a group that was working on this. They've decided to focus on a slightly different issue. I think Menji can probably weigh in on this if it's true. The different issue is probably even more important, which is the focus of that group right now is I'm trying to think of the way to word it. When somebody's on Medicaid for medical Medicaid, like hospitalization Medicaid, and they've got, they call it a spend down, which is confusing because we talk about spend down, but it's a whole different thing. But the spend down is how much they have to spend every month to keep their Medicaid. Okay. And so they're trying to change that. So that's been their priority. This has gone on kind of the back burner, but that's the group's priority. It's a bunch of organizations working together. And I think that's probably even worse than this one, because it's basically saying they gave examples of you know, somebody who's on Medicaid as their primary insurance, their hospitalization doctor insurance, and that after their spend down, they've got like $112 left to live on.
Right.
Okay, that's ridiculous, so I understand why they chose that as the priority. Sarah Slocum and others that are working on this and putting together a nice group of organizations that are fighting for this. That makes sense that they chose that, because that probably affects even more people that are on medical Medicaid. So my point on all of this is that yes, I'm stubborn. If you think that I'm going to give up, you don't really know me. Persistence is my only. It's probably my main benefit here is that I have some other attributes, but one of the biggest one's probably persistence. I just don't give up, and so we can make our own future. My advice is that talk to your local folks. Doesn't matter which side of the aisle they're on.
Yeah.
On the federal level, sometimes people are getting upset on both sides, really, really upset on both sides. Don't hold it against somebody because they're a Democrat or a Republican. On the local level, this is who we need, and we can get advocates on both sides. Tell your stories. They got grandparents. They got parents. They've got spouses. Okay. We can make a difference on the local level, and and my advice is, don't get too tied up on what side of the aisle they're on, because this is the only way we're going to make progress, at least on the legislature side of it. So now I get to come off my soapbox and just talk about a couple of fun things before we bring up Savannah. Advice from your advocate. So I've been doing this podcast for 2 years now, probably. It's awesome. It's so much fun. I get to interview really interesting people. And this is probably the least relevant person that I've interviewed on the podcast, but it was really fun. Anybody remember the guy from the infomercials in the 90s that would run around with the question marks all over his suit? And he was telling people about how to get government benefits and how to get government grants and loans. He was on my podcast. He was really fun.
I was really excited.
I was excited. He reached out to us to be on the podcast.
Yeah, he sought us out. And so the thing is, I always thought all of those, infomercial guys were scams, and almost all of them were. I always liked that guy. And he's talking about real stuff. I mean, he's talking about government grants and government whatever. And so, but he was so much fun to have on the podcast. But we've also had, nationally and internationally known folks that talk about dementia and caregiving and legal answers and things like that. And so it's really fun to do. We try to make it fun to listen to. I've learned over the 2 years, try not to make it, an hour and a half long. So we've gotten it down typically about a half hour, 40 minutes, maybe at the most. So it's listenable. We're talking about, we have a video component too, but we're talking about maybe just making it audio only. So really easy to listen to even now. Most people just listen to the audio instead of the video. So that's a lot of fun. We started doing this thing for local folks on the radio, 103.9 The Fox, classic rock. Sunday mornings, it's once a month. We're not doing it every Sunday morning, but once a month. And Savannah and I have been doing this radio show. It's really fun. Same kind of concept, but basically this one is where I'm the guest and Savannah's the host. And so she asked me questions about, stuff related to seniors. And so this was the most recent one, I think. We talked about why good families still can end up in court and how to avoid it. This was cool. So we sent a contingent down. We had a legislative day where we went down and visited our legislators.
Mm-hmm.
I was unfortunately unable to go, but we sent 3 of the folks from our office to go visit their legislators, and people from all over the state and from law firms went and advocated. I saw last week was the senior day with done by the PACE and waiver agencies. And one of my friends, guy with bow tie, Howard Collins was there, with those organizations. So any opportunity, but yeah, so our staff went down there. I thought that was pretty cool. And this is cool too. So this is the 12th year in a row that we've been voted by the readers of the View newspaper as the best or favorite law firm in Grand Blanc. So that's pretty cool. Yeah, I like that. And so finally, and this is the last thing before we bring up, thank you. This is the last thing before we bring up Savannah. I told you earlier, we can be a resource for you. If you have a question and you don't think it's worth calling your corporate lawyer for, we may tell you have to call your corporate lawyer, but if you feel like you need a question or need clarification, we cannot offer this to the general public, but we can offer it to other professionals like everybody here. And you can call us, email us. I want to give you the easiest way to do that. I also want to give you the easiest way to send us business, to send us clients. And so we have an excellent intake process where we can, gather some information and kind of screen things that a lot of you might want to skip that and go right to what we call the easy button and just go right to the source. Instead of calling in the front desk, you can call and ask for Liz. You can email Liz. So Liz is your opportunity to go directly to her to get questions answered, to refer a case. She'll help you, shepherd that case along, rather than going through our regular process. For you guys, we'll speed that up a little bit. So, I thank you very much. This is one of my favorite days. I was going to share with everybody so when Julie talked about what was it, the heart memory? I have one. I wanted to share with you. So this was a couple of years ago, probably, I don't know, it might maybe more than a couple of years ago. It's easy to lose track of time, but it was one of my favorite days of the year is boot camp. Always. I love boot camp. It's just a great day. And so my memory was having a great boot camp, and then came home, started a fire in the fire pit in the backyard, and all the kids came out. And I have 5 kids. So the idea of having all 5 kids come out voluntarily and participate in the campfire, it was amazing. And we played the secret game. So these were mostly teenagers at the time. Getting them to play a game or even talk to each other or sit around a campfire was not always easy. And we played the secret game. We had a whole lot of fun. So I thought that was my memory: a great boot camp followed by a campfire with the kids coming out. So that's my memory. So everybody's talked about the circle of care today. This is really important to us. And we just wanted to conclude on that. So let's go ahead and bring up Savannah, and she will give you the final instructions.
Thank you, Bob. My joyful memory was sitting on the couch with my kid taking a nap. Okay. So we're at the end of the day. I want you guys to go ahead and pull out, she's on it. Pull out your evaluation form. Yeah, Lisa's ready to go. So pull out the green form if you're an attendee, blue form if you're a sponsor. If you're at home, that's the form we had you pull up earlier. We emailed it to you, and it's on your materials page. I guess where's the clicker? Oh, okay. Will you click to the page, please? Oh. Okay. So now we're going to finish filling out the form. So it is important. We do have the checkout up here where you're going to put your signature and your checkout time. That is important. And I'll give that time to you in just a moment, or Liz will. But there's also some other questions. And I won't go through and read through the questions, but this is an evaluation form, and we really do want you to evaluate your experience today. Evaluate us. How did we do? And I want you to know that we don't just have you guys fill these out and sit them in a folder. We actually have a meeting, and we sit around a round table and we read them. So we want to know how this went. We literally take turns reading each form and we talk about it. So we appreciate your feedback. We want your honest feedback so that we can take that and make it a better event for you next year. So I really appreciate your time with that. And now we can get to the important stuff. So our checkout time for today is 3:29. And then you have your signature. When you are finished with your form, you'll take it out. So this is for the in-person people. You'll take it out to the hallway. We have 3 stations. They're broken up by alphabet. I know the first one's A through G, but I forget the other 2. So I took pictures. H through P. and Q through Z. So we have 3 stations set up. If you're at home, you can go ahead and just save the form once you fill it out, email it back to info@manorlog.com. And the at-home people, you're going to have to wait just past the weekend to get your certificates. We will email them to you once you receive the form. Give us a day or two to get them to you. But we're going home. We're not working anymore this weekend, so you're not going to get your certificate if you're at home. But if you're here, you go ahead and exchange it at the alphabet table that goes with you. And then we should be able to give you a certificate home. If there's an issue, I know some people changed registration this week, even yesterday. So you might, if that's you might not have a certificate here today, but we will get you one. So that's it.
And we just want to say thank you for coming. There is popcorn outside. Please don't forget it to take it on your way. Have an enjoyable weekend.
Yep. Thank you all for coming.